Hello, check. Hello, check. One, two, three. Hello, hello. Test one, two, three. Hello, hello. Hello, check. One, two. Hello. Test one, two. Hello, hello. Hello, check. Test 1, 2, 3. Hello, hello, hello. 1, 2, 1, 2. Hello, test 1, 2, 3.
Hello, Mayank is a third year law student at NALSAR University of Law, Hyderabad, and serves as an editorial board member of the 13th volume of IJCL. He has a keen interest in comparative constitutional law, intellectual property, and criminal laws. His work explores the intersection of legal systems with emerging technologies, political ethics. So, with regards to dignity, dignity is the symbolic expression of each person's equal, inalienable worth, not by virtue of legal status, but simply by virtue of being a human. He writes that the preamble of a constitution elevates dignity both as a constitutional ideal and a foundation of fraternity, autonomy, and constitutionalism. Yet, Article 13 limits its enforceability to actions of state, overlooking conflicts of dignity in private contexts. The term arguably is solipsistic in nature, invites us to ask whether dignity is a personal belief, a community value, a mode of judicial reasoning, or a matter of constitutional morality. Even if society appears to agree on the meaning of dignity, it derives not from universal consensus, but from individual heterogeneity. This year's theme thus reflects a collective promise of mutual respect through recognition of intrinsic human worth. Thank you.
Hello, check. Check 1, 2. Hello, test 1, 2, 3. Hello, hello.
Hello. let that affect one's career. Saying it and living up to it is an act of courage, of conviction that very few lived up to. People like Justice Muralidhar, Maya Daruwala, and other civil rights activists like Balagopal and others in India, they raised bar for our public commitment to justice. That is a ray of hope for all those human rights advocates. With these few words, I request Justice Muralidhar to deliver his keynote address on the question of judicial engagement with dignity in practice. Thank you.
Thank you, Professor Murali Karnam. Good morning, everyone. It's a true pleasure to be back in NALSAR, talking to all of you. I think Professor Murali Karnam heard me speak at Bangalore on the Sukanya Shanta judgment, and then he was very keen that I should also speak on more or less the same ideas here. So when I prepared the background note and sent it to Teja Lakshmi here, I said the backdrop will be the Sukanya Shanta judgment. And as it usually happens, all that plan has changed. So I'm going to start on a different note today. So I don't know what the speakers yesterday adverted to, but in the context of dignity, there has been always, I would say, a kind of a confusion between dignity as a value and dignity as a right. So judges constantly encounter this confusion. So in the earlier phase of the Supreme Court's functioning, let's say up to the 70s, they were referring to dignity as a constitutional value, forming the very core of the fundamental rights. And you find that being adverted to not only in A.K. Gopalan, but even in Indian Express newspapers, where they're talking of wages for working journalists. And there's an interesting judgment in 1962, where Chief Justice B.P. Sinha dissents in the context of the Dawoodi Bohra excommunication practice, which was outlawed by the Bombay state of those days, and so on and so forth. And then you have Golaknath and Keshavananda Bharati. So when you advert to the basic structure, again, there's a reference to dignity. But all of this is in the context of dignity stemming from the preamble being a constitutional value. In fact, the phrase used in the Constitution's preamble is fraternity assuring the dignity of the individual. So it's not fraternity per se, but fraternity that works to ensure that individual dignity is not violated. So they've used this in the 70s to explain the context, explain what is it to lead a life with dignity. So then that comes into Article 21, when you start reading Francis Corelli-Mullin, or even before that, Sunil Batra. I'm not dwelling on all of this, but just to explain to you that when they find conditions in which prisoners are kept, which they find is degrading to human dignity, they draw on that to say there is no question of a right to life if it is not a life with dignity. So then the contours of the right to life, those are explored in the context of dignity as a constitutional value and how life would be meaningless without a life with dignity. That's the classic phrase in Francis Corelli-Mullin. What has happened in the recent phase, the last phase, I would say 21st century, in the context of recognition of the right of persons with different sexual orientation, there's a full arc. And I should, at the risk of being immodest, say that it started with NAS Foundation, where one of the main pillars of the reasoning in NAS Foundation was the right to dignity, the right to a life with dignity. And that was picked up in one sense in NALSAR judgment in the Supreme Court, although there was a setback when NAS was reversed by Sudesh Kausar. But in the Puttaswamy judgment, which is the privacy judgment, there's a very lengthy discussion on explaining, and this is Justice Chandrachud's judgment in the privacy case Puttaswamy, 9-judge bench. There's a lengthy discussion on why Naz is right and Sudesh Kaushal is wrong. And much of the discussion centers around this dignity as a constitutional value and why it is necessary to develop around this constitutional value of dignity to explain full personhood of persons with different sexual orientation. And from Puttaswamy to Navtej Johar was just a corollary, I would say. It became an easy task for the Supreme Court, whether it was Navtej Johar or Joseph Shine, to use the same reasoning to say you cannot criminalize consensual sexual acts between adults in private. Likewise, adultery, criminalizing adultery, was illegalized by saying that characterizing the woman as a property of a man or saying that she doesn't have an identity of her own is violative of the right to dignity. So there's a whole arc that starts with Naz and goes up to Joseph Shine. But as we all know, not all judges think alike, and we don't have one Supreme Court, as in some countries, particularly the US Supreme Court, where justices sit en banc. We have several Supreme Courts. And that becomes very clear when we look at some of the cases that I'm going to discuss today. So let me begin by saying that the centrality to dignity, which is spelled out in the International Bill of Human Rights, whether it's the Universal Declaration of Human Rights or the ICCPR, the ICESCR, that has continued in some of the written constitutions. And the best example is the South African Constitution, which separately defines the right to dignity and separately defines the right to privacy as well. Now, in our constitution, and this is where I think I want to make a definite point, because I find that legal scholars have perhaps missed something. I found in one of the pieces that a reference was made, no doubt, to the word dignity in the preamble, fraternity assuring the dignity of the individual, and also to Article 39E, which is in the directive principles, which says that the health and strength of workers, men and women, in the tender age of children are not abused, and that citizens are not forced by economic necessity to enter avocations unsuited to their age. And F, 39F, that children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, that the childhood and youth are protected against exploitation. The other provision which expressly refers to the word dignity is Article 51 capital A, where in 51AE, it says to promote harmony and the spirit of common brotherhood amongst all people of India, transcending religious, linguistic, and regional or sectional diversities, to renounce practices derogatory to the dignity of women. But it would be a mistake to think that these are the only references to dignity in the Indian Constitution. Because if you go back to history, if you know the Vaikam Satyagraha, the Mahat Satyagraha, about rights of Dalits to enter places of Hindu temples of worship, that was very much in the minds of the constitution framers when they sat down to draft one particular article, which is Article 15. Article 15.2 is entirely about human dignity. I'll just read that because I think we need to revisit. This is a classic example of horizontality of rights. No citizen shall, this is how it reads, no citizen shall, on the grounds of only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels, and places of public entertainment, or, and this is important, the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly and partly out of state funds or dedicated to the use of general public. So if you go back to our legal political history, you will find that much of the struggles of the Dalits were around these issues of course, untouchability, which I'll come to in a minute, but also access, denial of access to public places, including bathing ghats, wells, tanks, roads, and places of public resort. How many in this audience have heard of this documentary called India Untouched? Okay, I'm glad that at least 3. So I would urge you as part of your Dignity Law course to look at that documentary and have a discussion, because it tells you how caste is the elephant in the room as far as India is concerned. And caste pervades all religions. So this whole concept of the hierarchy, social hierarchy through caste, is to be found in every religion in India. And I'm talking of Sikhism, Islam. We don't know enough of Buddhism, but certainly Christianity, Islam, and Sikhism, in their social practices, still strictly and rigidly maintain the caste hierarchy. And that documentary brings it out. Of course, it talks of the Hindu religious fold and the caste practices there. But this is a very important point it makes. And the documentary also makes this important point, which Ambedkar was at pains to point out in the Constituent Assembly debates, of the concept of what is called graded inequality. So even among the Dalits, the untouchables, there's a social hierarchy. So for instance, the Domes will not marry the Chamars, who will not marry the Mushahars. So you can marry up, you cannot marry down. So these rigid hierarchies have been, preserved. So the other point of discussion for all of you could be the matrimonial columns. So pick up like today is a Sunday, right? So any mainstream paper would have matrimonial columns. So Professor Erin Daly may want to, I don't know if you've already seen it, but if you want to understand what do we mean by graded inequality, so you find castes, subcastes, further clarifications within that. So the whole spectrum of inequality is on full display in the matrimonial columns. So these are very important for us to inform ourselves of the nature of Indian society. Because we'll be making a terrible mistake if we do not see in granular detail what our society is all about. And it tells us something about ourselves too. The unacknowledged biases that we all live with, we've grown with, and our own understanding of a society is informed by our immediate surroundings, right? The practices that we are so comfortable with, like the 2-tumbler norm, right? Somebody comes to work in your place, in your house, to sweep and swab the floor, clean your utensils, wash your clothes. Now, the way those persons are treated in terms of sharing of food or drink, in many households, you'll find that a separate set of utensils are kept for them to drink tea from or water from. And this is something as when we grow up as children, we don't question it at all. We take it for granted. We don't even pause to think that passively you're condoning a discriminatory practice. So once you learn to live comfortably with discrimination of this sort, you'll cease to see what do you signify as a person to the person who's being discriminated against. So these understandings as law students is very, very important, because you can read this as an academic subject, but there has to be at least a degree of experiencing what it is. So the third thing which you could do is role play. Imagine yourself to be a rack picker. Imagine yourself to be a sewer cleaner. What it is to be that. You can only have a vicarious experience. I was told in NALSAR you had sewer cleaners come here and clean the manholes. So when I did the social economic rights course here many, many years ago and spoke about this, some of the students then began to notice that, yes, over the weekend, somebody was coming to clean the manholes here, get into the sewers lines and clean it, and then began questioning it as an undignified practice. So constitutional provisions, to come back to that, Article 15 is therefore 15.2 completely encapsulates the whole concept of dignity as a constitutional value. The other provision is Article 17. I'm sure you've been told about that. This and Article 23 are the only two provisions which are unique to the Indian Constitution, which you will not find in any written constitution in the world, which talks of untouchability being declared an offense. Usually penal statutes declare offenses, constitutions don't. But our constitution in two provisions, Article 17 and Article 23, declare a certain practice to be an offense. 17 says untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. So this was a very clear enunciation by the constitution framers of what I think Dworkin would characterize as a baseline violation of human dignity. Something that there cannot be any contestation about. Because there's always an argument saying dignity is so vague a concept. And it has a very cultural specificity. So what is undignified for one person may not be for another. This is one of the arguments against developing a right to dignity. So in academic literature, which I'm sure you'll come across in your course, you will find this argument put forth that the minute you recognize a right to dignity, it somehow militates against this recognition of dignity being inherent to a human being. Which means if there's a violation of a right to dignity, it's a negation of your inherent dignity, which is not true, right? Once you say being born as a person, you have inherent dignity, it just can't be taken away by anyone. You can have violations of it, but it can't be taken away, it can't be negated. The other problem they point out is competing dignities. Let's take the context of medical termination of pregnancy, right? Right to choose, pro-life, pro-choice, right? The whole debate, Roe versus Wade, which has come into India today, unfortunately. And that's happened now in 2023, when two judges, women judges of the Supreme Court, deferred after having allowed the woman's right to terminate a pregnancy because she was already suffering from postpartum depression as a result of the first child. And she had come back to the court saying, I can't afford now to carry this pregnancy to the full term. So initially the two judges recognized that and allowed the termination of pregnancy. And the additional Solicitor General walks into the court the next morning with an email from one of the persons, one of the doctors on the medical panel, medical board, to say that the fetus has a heartbeat. And that makes one of the judges change her mind. And when the matter is referred to three judges, the new bench has no women on it. And it says, oh, the fetus has heartbeat, we will not allow this termination of pregnancy. So again, bringing back what was troubling the US Supreme Court into the Indian discourse around medical termination of pregnancy. So it's again, therefore, a contestation between two rights to dignity. If there's an inherent dignity in the fetus, then can that be, squared off against the woman's right to autonomy? So they say if you start recognizing a right to dignity, you will run into these kinds of issues. But there is an answer to that as far as the Indian context is concerned. I'll just come to that in a minute. So Article 17 is one provision which clearly states that untouchability is an offense, and untouchability is all about the right to dignity. The humiliation that you encounter, right? And in the Indian context, therefore, it is not very difficult for people to understand when we talk of dignity, what it connotes. Again, Article 23 is the other article, prohibition of traffic in human beings and forced labor. So the word used in the Constitution is a Hindustani word, begar, always misprinted in many texts as beggar. It's actually begar. Traffic in human beings and begar and other forms of forced labor are prohibited. So Forced labor is something that we recognized as violating the right to dignity. Dignity is a value. Dignity is inherent in human beings. So our constitution definitely maybe doesn't use the word dignity in these provisions, but these provisions are all about that. Article 24 is the other provision. Prohibition of employment of children in factories. No child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. So on these, there was no doubt in the minds of the constitutional framers that they were talking about dignity. Another important provision that you need to notice, Article 25, Subarticle 2, Clause B. 25 itself is about freedom of conscience and free profession, practice, and propagation of religion, not confined to any minority. This is a general article of religious freedom. But Subarticle 2B is very interesting. It says nothing in this article shall affect the operation of any existing law, prevent the state from making any law, providing for social welfare and reform, or throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. So this is specifically in light of the Vaikom Satyagraha, the Mahat Satyagraha, where even Nathdwara, the temple entry being barred to Dalits. I don't know how many of you followed the news item of the earlier president of India, previous to the present one. Do you know who he was? Can you name him? Can any of you name the president previous to the present president? Ramnath Kovind, who was a Dalit. So he happened to visit the Puri temple in Odisha. And after his visit, they had a temple cleaning that was undertaken. And this is, we are talking to the President of India. So even in 2022, I think this was 2022, this barring entry of certain sections of Hindu society into temples has continued. And this is very unfortunate because in Puri, if you go today, there is a clear board saying that beyond a certain point, non-Hindus cannot enter the temple. Of course, how they enforce it is entirely a different story. But this continues. This continues till today. But among Hindus to do this is something completely unacceptable. So this is in complete negation of Article 25(2)(b), which encapsulates this right to dignity. Because when places of public worship are barred to a certain section of Hindus, the Constitution said the state has a right to intervene to illegalize it, which is what the problem in the Sabarimala case is all about. Okay, so I'll come to that again in a minute. So with this backdrop of constitutional provisions, you begin to understand that in the Indian context, we may not run into difficulty in trying to identify what are practices violative of human dignity. The best example of violations of what Dawkins would call baseline, by the way, he had two categories. One he said is a baseline violation. The other he says is a bad faith violation. So bad faith violation is cultural specific. So in certain societies, in certain cultures, certain practices would be violative of dignity, whereas it may not in some other society. So that he gives a margin for, but he identifies what are called baseline violations. And according to me, 15 to 17, 23, all talk of these baseline violations. If you pick up the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act, and it's astonishing, I don't know how many of us have paused to even read it properly, what the legislature acknowledges as baseline violations. So section 3 actually lists out, and I'm going to take some time to list it out, punishment for offenses of atrocities. Whoever, not being a member of a scheduled caste or a scheduled tribe, puts any inedible or obnoxious substance into the mouth of a member of a scheduled caste or scheduled tribe, or forces such member to drink or eat such inedible or obnoxious substance. dumps excreta, sewage, carcasses, or any other obnoxious substances in the premises or at the entrance of the premises occupied by a member of scheduled caste or scheduled tribe. So this is a proper legislative acknowledgement of practices that are violative of human dignity. So we don't have to go travel far, which is why I'm saying just look around you and you will find this. With an intent to cause injury, insult, or annoyance to any member of a scheduled caste or scheduled tribe, dumps excreta, waste matter, carcasses, or other obnoxious substance in his neighborhood, garlands with footwear. This is in the statute. Garlands with footwear or parades naked or semi-naked a member of a scheduled caste or a scheduled tribe. Does this still happen in our country? How many of you say yes? That's a good number. I'm glad you are reading newspapers. Forcibly commits on a member of a scheduled caste or scheduled tribe any act such as removing clothes from the person, forcible tonsuring of head, removing mustaches, painting face or body, or any other similar act which is derogatory to human dignity. So this blackening of the face is something that still happens. So you have Khap Panchayats, Katta Panchayats, the so-called informal adjudicatory systems, which can sometimes be glorified or romanticized, but which can be completely dominated by the upper castes. And justice can be made a mockery of by the kinds of punishments that they hand down. I'm not going to read all of them, but some which will shock anyone's conscience, forget judicial conscience. Compels a member of a scheduled caste or scheduled tribe to dispose or carry human or animal carcasses or dirty graves. So you should know that even today in the cremation grounds, the persons who handle the human corpses are not persons who belong to the upper castes. They belong to the untouchable castes. People who work in the mortuaries. How many of you have actually visited a mortuary in a non-urban setting? So as part of your discourse, apart from visiting a landfill, I would suggest you visit a mortuary. The persons who actually perform the anatomy is not the pathologist. He's sitting there and he's giving directions to a person who will slit the body open and take out those organs which need to be preserved. That person belongs to a certain caste and a certain community. And you might find very often such person to be inebriated. Just like sewer cleaners are in fact invariably inebriated. They need alcohol to be able to take the level of stench, because it's not just one body they're slitting open, right? Several bodies in a single day, and then stitching them up again after the postmortem is done. So all of this is performed by a certain community. So which is what this is all talking about, this section 3. Performs or promotes dedicating a scheduled caste, scheduled tribe movement to a deity. So the Devidasi system and forcing women into prostitution through this method is something that's treated as an atrocity by the legislature. It also talks about preventing scheduled castes from casting votes or filing nomination papers. This is also important. Corrupts or fouls the water of any spring, reservoir, or any other source ordinarily used by the members of the scheduled caste, so as to render it less fit for the purpose which it is ordinarily used. And then it also talks of compelling them to clean toilets and other places of such use. So there's a whole listing out in section 3 of the Prevention of Atrocities Act of dignity violating practices. So in the context of the Indian society, we should have no difficulty in identifying baseline violations of dignity, unlike what you might read in the literature around this topic. So just to refresh our memory on the case law, I spoke about Sunil Batra, which is about placing fetters on prisoners in standing position. So if you look at the Sunil Batra 2 decision, you will find in the concurring opinion of Justice D.A. Desai, is adverting to the visit to Tihar jail by the judges of the Supreme Court. This is one of those rare instances where judges went from Tilak Marg into Tihar jail. I'm not sure even today they do it. And they saw for themselves what Sobraj had talked about in his letter petition to the Supreme Court, that they were being forced to keep standing with fetters around their ankles and wrists. So what you see about Abu Ghraib, for instance, those videos are there, Guantanamo Bay, which is happening even today, straitjacketing, waterboarding, all of this, the treatment of prisoners was talked about way back in 1978. And in the Nandini Satpathy case, which is about the rights of women not to be forced to attend a police station after sunset, there's a clause to that effect in the CRPC, and I'm sure in the new avatar of it. Justice Krishna actually uses the word third degree and says that is not a permissible means of interrogation at all. So we're talking of 1978. And it is no different in 2025. It is still the only, not only, the most prevalent tool of investigation for the Indian police, subjecting people to torture. So even when an anticipatory bail application is moved in our courts, you will find the prosecutorial team, the assistant PP or the PP, actually tell the court that we need custody of this person for custodial interrogation because he is not cooperating. So these are the standard words and phrases used. So as judges and lawyers appearing before judges, everybody knows what this means. When you say custodial interrogation, it means torture. When somebody says he's not cooperating, it only means that he will cooperate only if he's subjected to torture. So torture is internalized. So although you have 3 new laws now, they're called new, but they're only new in form, not in substance. We don't have a law against torture. We have not ratified the Convention Against Torture and all the indignities that accompany torture. Torture is a pure form of physical violence is one thing. But torture in various forms which affect your dignity is another. So recently I was arguing a case for the persons accused of the bomb blasts in Mumbai of 2007, train blasts. And this was under the quota. And admissions can be made before, so-called confessions can be made to a senior police officer. So police officers have their own reputation. So within all the Mumbai police stations, there is one who has acquired a notoriety. He's notorious for being able to torture victims, torture suspects, and get the truth out. So even when the police station, the policemen of a particular police station are torturing a particular suspect, they warn him that if he does not admit to the crime, he will be sent to this particular police station for proper treatment. So all this comes out in the testimony of these people who were accused who stepped into the witness box. So we now have testimonies by prisoners talking about how the wife and mother of the prisoner was brought before the prisoner and stripped of their clothing. So as part of this custodial interrogation are these practices of indignity, urinating on a person, forcing a person to drink urine or eat excreta. These are all parts of the custodial interrogation techniques. I don't know how many of you have read about Guantanamo Bay and Abu Ghraib, and that should be compulsory reading anyway. This US Senate report, which has been discussed elaborately in a US Supreme Court judgment, and the opinion of Neil Gorsuch is very telling about what kinds of practices were deployed. So you begin to understand that baseline violations of dignity appear in various settings. So in the criminal law setting, it's not about the physical torture part of it, which is easier to understand from a legal perspective, but the indignities suffered by a person facing interrogation that requires our peculiar attention. The Bandhua Mukti Morcha case and the PUDR case are very important cases for understanding Article 23 of the Constitution, that is forced labor, begar. So the Supreme Court has actually said offering less than minimum wages to a laborer is violative of Article 23, even if that laborer doesn't complain. Because one of the arguments put before the Supreme Court was, this person is not complaining, what's your problem? So Justice Bhagwati had to explain that Article 23 cannot be waived. There cannot be a waiver of fundamental rights. I found this one passage in this judgment, which goes by the name of Shankarlal Gyarsilal Dikshit versus State of Maharashtra. It's a regular criminal case. The Supreme Court is acquitting a man who is charged with committing rape and murder of a 5-year-old girl child. And the man is visibly a poor person with very little or no economic means. And the senior Chandrachud, this is a judgment written by Justice Y.V. Chandrachud. Towards the end of the judgment, he talks about the prejudices that the villagers had against this one person who was a man of poor means. So I'll just read this passage. The folks of Karanja, this is the village Karanja, had a grouse against the appellant. He had made a nuisance of himself to his family and friends, neighbors, and tenants. The small world of Karanja was up in arms against him. He had assaulted his mother and a brother a few days before the incident. He had a quarrel with Sheelabai, his tenant, on the very day of the incident. He was an idler and had no means of livelihood. The description of his clothes at the time of his arrest is an eloquent commentary on the way of his life. He was wearing 2 full pants, one on top of the other, not because he had one too many to wear, because one of the 2 pants was torn at awkward places and he had to hide his shame. It was torn both on the hips as well as the center. The left leg of the pant was torn over 2 feet and the right leg over half a foot. The shirt on his person was torn all over. The right arm of the shirt was hanging precariously by the rest of the torn portion of his shirt. The Karanja community must have heaved a sigh of relief that a person who was so good for nothing was ultimately in the hands of law. Such people have no partisans, but that does not mean justice can be denied to them. So without using the word dignity, it's such a powerful passage. And I remember as when I had not even started doing law, by pure accident, it's a story for another time. I happened to pick up this book and accidentally read this passage and struck me so hard. Until date, I can, this is what we mean by compassion. If a judge refuses to see this, and I would urge as a law student, if you refuse to see this, you're not a person to be doing the course on right to dignity. So this is what you need to recognize, what Indian society is all about. So if you want to understand the dignity tropes, one is to pick up the law and poverty trope, right? Begging is still an offense in many states in the country. It's been illegalized in Delhi. It's been struck down in Jammu and Kashmir. It's not struck down in Gujarat. It's not struck down in Bombay. It's called the Bombay Prevention of Begging Act of 1961, which is applicable in Delhi. It's been struck down in Delhi, not in Bombay. So today, under that act, a vagrant is defined as a person without any visible means of sustenance. So the passage I just read, wearing 2 pants, one over the other because the other pant is torn at awkward places, wearing a torn shirt. And if you're wandering in the street or even standing in the street corner or sticking out your hand, you're a person without visible means of sustenance. So the social welfare department has its teams to conduct raids. They can pick you up and take you before a magistrate who will remand you to the beggar's home. So you enter the criminal justice system and you're in a penal custodial institution from which you cannot exit. You can exit under these rules, under this act, only if you give a bond assuring that you will not beg, which is so ridiculous. The man was, first of all, brought into your system only because he had no means of sustenance. So this is something that we need to constantly, fight against. Criminalizing acts of poverty. Likewise, sex work is criminalized, as if the woman has a choice. So the mere act of standing outside a doorway and soliciting customers is an offense. That very act, you don't have to actually have a customer. If you're found soliciting, it's in a wandering mentally ill person is brought into the criminal justice system, even under the Mental Health Care Act. So all activities of the poor, sleeping on the pavement can be an offense. Encroachment, illegal occupation of public land arising out of poverty. So all these are invasive of human dignity in the first place. On top of it, you criminalize it. So understanding dignity to the trope of poverty is another very useful trope in the Indian context. You will not find much literature on this, but I would urge you to read Barbara Harris White. Some really powerful writing has been done by her on this. And of course, Upendra Bakshi. So one judgment of the Delhi High Court, which is less noticed, and you will find this discussed in detail in Usha Ramanathan's article on ostensible poverty and beggary. If you go on Google, you will find this article. She discusses this judgment in great detail. It's a judgment of the Delhi High Court in Ram Lakhan versus State. It's a 2006 decision. So the conviction under the Bombay Prohibition of Begging Act was set aside by the Delhi High Court in a criminal revision petition. And the judge notes, it's very, very interesting. This is Justice Badr Ahmed. Unfortunately, it's not a reported judgment, but it's discussed in detail in this article I just mentioned. He observes all of this. He says the Metropolitan Magistrate had recorded that, and I'm quoting, the accused was begging by raising his front paws, PAWS, paws from the passers-by. It moved the irate judge, the irate judge is Justice Badr Ahmed, to exclaim, beggars are not beasts with claws. They are human beings and they should be treated as such. For any civilized society, the judge observed, to have persons belonging to this category is a disgrace and a failure of the state. To subject them to further ignominy and deprivation by ordering their detention in a certified institution is nothing short of dehumanizing them. Prevention of begging is the object of the said act, but one must realize that embedded in this object are the twin goals. Nobody should beg and nobody should need to beg. So this judgment is all about dignity. It may not use the word dignity, but this is how judges are expected to respond by recognizing inherent dignity of individuals. But unfortunately, this is not being consistent across the judiciary. And these kind of cases come in before the judiciary very rarely. I've talked of this entire trope of Nas, Nalsar, Puttaswamy, Navtej Johar. I'll just read this one formulation in the majority judgment in Puttaswamy. Privacy of the individual is an essential aspect of dignity. Dignity has both an intrinsic and an instrumental value. As an intrinsic value, human dignity is an entitlement or a constitutionally protected interest in itself. In its instrumental facet, dignity and freedom are inseparably intertwined, each being a facilitative tool to achieve the other. The ability of the individual to protect a zone of privacy enables the realization of the full value of life and liberty. So there's a recognition of both the facets of dignity, which is the respect of the person and treating the person equal, or conversely, not discriminating against the person. That is one facet. And recognizing the autonomy or agency of the person. These are two facets stemming from the value of dignity itself, and both have been recognized in this privacy judgment in Puttaswamy. I now move to the three major cases very shortly. First is the Delhi Jal Board versus National Campaign for Dignity and Rights of Sewerage and Allied Workers. It's a 2011 judgment of the Supreme Court. I was part of the bench in the Delhi High Court, which decided to award compensation for sewer cleaning deaths. I just spoke about sewers. Actually, people enter physically into the sewer, and there's enough documentaries now available in YouTube on all of this. And They go without any protective gear. Many of them die of asphyxia. And it continues till date. There are many of them employed by municipal corporations, but through the device of outsourcing, because the corporation does not want to take responsibility. So it was that context we were faced with. When we asked Delhi Jal Board, how can you allow this? They said, no, we ask contractors to do it. We don't do it ourselves. They tried to wash their hands off, which we didn't allow them to. Fortunately, our judgment was affirmed by the Supreme Court. And this is what the Supreme Court said. It is the duty of the judicial constituent of the state, like its political and executive constituents, to protect the rights of every citizen and every individual and ensure that everyone is able to live with dignity. Given the option, this is what the Supreme Court says, given the option, no one would like to enter the manhole of sewage system for cleaning purposes. But there are people who are forced to undertake such hazardous jobs with the hope that at the end of the day, they will be able to make some money and feed their family. They risk their lives for the comfort of others. Unfortunately, for the last few decades, a substantial segment of the urban society has become insensitive to the plight of the poor and downtrodden, including those who, on account of sheer economic compulsions, undertake jobs, works which are inherently dangerous to life. People belonging to this segment do not want to understand why a person is made to enter a manhole without safety gears and proper equipments. They look the other way when the body of a worker who dies in the manhole is taken out with the help of ropes and cranes. In this scenario, the courts are not only entitled, but are under constitutional obligation to take cognizance of the issues. This was in 2011. We have two statutes. One is called the Employment of Manual Scavengers and Construction of Dry Latrines Prohibition Act, 1993. Because we have a practice of dry latrines in this country. Those dry latrines are cleaned by untouchables, and a majority of them are women. So there's a documentary which goes by the name of I Am Dalit, How Are You? So you can make a note of it. It's all there on YouTube. The second statute is Prohibition of Employment as Manual Scavengers and Their Rehabilitation Act 2013. You will find very little courses specific to all these statutes that I'm talking of, whether it's the Prevention of Beggary Act or these statutes. They will be at the best part of a social justice module or something, I suppose. But I think taught less and less in law schools these days. And many of you may not opt for it because this is not going to look good on your CV or not give you entries into corporate law firms. It will probably categorize you as being left of center. And you have a phrase for all of this, Jholawalas. Have you heard of that? Murli, you will know it. So it's very important for us to acknowledge what the parliament has acknowledged. Now, these two statutes, like many other statutes, have not been implemented. That's a long and short of it. So we had to file a public interest, a class action litigation, which goes by the name of Safai Karamchari Andolan versus Union of India. It's a very important judgment of 2013. So we collected a large volume of data. I became a judge in 2006. I had started the PIL in 2003. So it was continued, fortunately, by my associates. And a large volume of data was presented to the Supreme Court. And the court noticed that these two statutes are relatable to Article 17 of the Constitution. And the court then said for each death of a sewer worker, there should be a compensation of 10 lakhs given to the family of the deceased. And a whole slew of directions. People released from managed scavenging should not have to cross hurdles to receive what is the legitimate due under the law. I want to point out to you that a majority of people working in dry latrines is women. The majority of those cleaning sewers is men. Many of them have lung diseases naturally, and many of them are alcoholics, not surprisingly. So they have very short spans of life. There's no question of any insurance, no health insurance, nothing, no security of tenure. So these are the people who actually cease to work. You will have a health hazard in the city. And their value, there's no value given to their work, which is really the true irony of this whole thing, right? If young children stop picking garbage, in those landfills, you have a crisis on hand. You know, they're actually segregating degradable from non-degradable waste. It's a skill. And you have a 5-year-old or a 4-year-old doing this in those landfills. And it's, I mean, it should not be done by a child in the first place. And it's hugely underpaid, not even subsistence levels. So these are the questions we really need to raise. So studying the law around dignity is one thing, but doing something about it is very important. Raising awareness about it is something very important. And you can do so much through your university clinics that you have. Take it up as a project. Visit the landfills in Hyderabad. Find out how children are surviving all of this. Sewer cleaners in Hyderabad. The state is always in denial. And it's not just about corporations employing these people. Private houses. You have so many unauthorized colonies in Hyderabad, right? You have septic tanks. They can't get regular connections to the sanitary system. Those septic tanks are cleaned by whom? By actual human beings. We're not deploying some machinery for that. And they go in without any protective gear. So this is something that needs attention. So it didn't stop with this. The third judgment is Dr. Balram Singh, which is a 2023 judgment. What is important in this judgment? It recognizes Articles 15(2), 17, 23, and 24 of the Constitution as in what it calls as emancipatory code. These were the provisions which were meant to bring about social transformation through law. But Ambedkar very early on recognized that without social democracy, all this talk of democracy is meaningless. So if you go through his speeches in the Constituent Assembly, you will find the pain and anguish coming forth again and again, where he says it's like a top dressing on a loose soil, right? Democracy is a top dressing on a loose soil when he's talking of constitutional morality. Because if as a society we don't practice it, you're not going to see the transformation. And it is for us who are not doing that job to do it. So this passage in this Balram Singh is very powerful. This is what Justice Ravindra Bhatt says. If we are to be truly equal in all respects, the commitment that the constitution makers gave to all sections of society by entrenching emancipatory provisions such as 15(2), 17, 23, and 24, each of us must live up to its promise. The union and the states are duty-bound to ensure that the practice of manual scavenging is completely eradicated. Each of us, this is the horizontality, each of us owe it to this large segment of our population who have remained unseen, unheard, and muted in bondage, systematically trapped in inhumane conditions. The conferment of entitlements and placement of obligations upon the union and the states through express prohibitions in the Constitution and the provisions of the 2013 Act mean that they are obliged to give real meaning to them and implement the provisions in letter and spirit. And this is the important line. Upon all of us citizens lie the duty of realizing true fraternity, which is at the root cause of these injunctions. Not without reason does our Constitution place great emphasis on the value of dignity and fraternity, for without these two, all other liberties are chimera, a promise of unreality. It is all of us who today proudly bask in the achievements of our republic, who have to be awake and arise so that the darkness which has been the fate of generations of our people is dispelled, and they enjoy all those freedoms and justice, social, economic, and political that we take for granted. Now, in the context of the Sabarimala case, for those who may not be aware, I'm sure all of you are aware, because this is something that law schools have discussed threadbare. The problem was barring the entry of women between the ages of 10 and 50 into the Sabarimala temple. Curiously, this ban was imposed in 1991 by the High Court. So two judges of the High Court took it upon themselves to say they are barring the entry of women. So till then, you had instances of women going there. In fact, there was a woman collector who went there. Some film stars went there. A film was even shot there. All this happened. Suddenly, in 1990, one person went to the High Court in Kerala, and two judges of the Kerala High Court agreed with that person. It said male, and said, yes, we are barring the entry of women between 10 and 15 to the Sabarimala temple. Then you have rules made under the temple entry statute, which actually incorporated this ban. It is very strange. So they're using the law under 25(2)(b), which is supposed to open up places, to place a restriction on women entering, which is what led to the filing of the petition in the Supreme Court. So you had a split verdict, 4 judges agreeing with the petitioner that barring the entry of women between the ages of 10 and 50 was illegal. And in developing that argument, Justice D.Y. Chandrachud talks about dignity. So here he says, exclusion is destructive of dignity. To exclude a woman from the right of worship is fundamentally at odds with constitutional values. Then he also picks up the untouchability trope, because one of the arguments was menstruating women will defile the sanctum sanctorum and make it impure. So an argument of purity was brought in, and that was negative by saying the menstrual status of a woman is deeply personal, an intrinsic part of her privacy. The Constitution must treat it as a feature on the basis of which no exclusion can be practiced and no denial can be perpetrated. No body or group can use it as a barrier in a woman's quest for fulfillment, including in her finding solace in the connect with the Creator. And he treats this as a form of untouchability. And he develops a whole narrative, which then comes into Sukanya Shanta. I find that he's picked up that whole narrative and developed on it in Sukanya Shanta judgment. Because what happened to the Shabarimala judgment, you know very well. The presiding judge was Justice Deepak Mishra, and this was on the eve of his retirement that this judgment was delivered. When the review petition was filed, Justice Deepak Mishra was substituted by Justice Gogoi. And while 2 of the judges, Justices Chandrachud and Nariman, stuck to their original view, Justice Khanvilkar, who was part of the majority, changed his view and now sided with those who said the judgment was reviewed. And this is all within a matter of a few months. So it's a very powerful dissent that you will find by both Justices Nariman and Justice Chandrachud in the review order. Strangely, the majority in the review referred the matter to 9 judges. And now it's before a 9-judge bench. So the next judgment you will find in that is the Kanti Veera Raju judgment, which is on the maintainability of that reference. They have not actually answered the real question that has been referred to them, because it is also supposed to consider questions of law which would have bearing on the pending writ petitions relating to entry of Muslim women in dargahs. So this is what I meant by spanning all religions, right? Indignity is heaped on women by denying them entry into places of worship, not just for Hindu temples, but also Muslim places of worship in dargahs and mosques, and entry of Parsi women married to non-Parsis in the holy fireplace of Agyari, and the challenge to the practice of female genital mutilation in the Dawoodi Bora community. So all these questions are pending before the 9-judge bench. We don't know when they're going to answer it. The third, and this is the last, is the Sukanya Shanta judgment. Again, I think it's been discussed threadbare. Basically, Sukanya had covered in a series of articles in the Wire the practice actually being followed in many Indian prisons of segregating prisoners according to their caste. So in Palayamkottai in Tirunelveli district in Tamil Nadu, a separate prison, the Tevars, Maravars, and the higher castes are kept in separate prisons. The ostensible reason is if you keep them in the same prison, there'll be violent clashes. But the real reason all of us know is segregation for the purposes of work in prison. So much of the work within the prison is performed with prisoners themselves. One of the work is, of course, cleaning toilets. So toilets are cleaned by Dalit prisoners. So segregation of prisoners for the purposes of work, and it's written into the prison manuals. This is what is remarkable. It says cooking will be done by upper caste persons. Cleaning will be done by people habituated to that. So these provisions were declared illegal. Fortunately, the case has been kept back in the court for monitoring because we wanted directions to each of the states to take out these provisions from the prison manuals and also to remove provisions concerning habitual offenders. Because habitual offenders were understood as persons who belong to the denotified criminal tribes in the pre-independence era. And that has percolated into all the provisions of the principal manuals today. And that's why you have a lot of discrimination being practiced within prisons against persons who are just deemed to be habitual offenders if they happen to be born into those communities. So you have many such communities like the Banjarans here in Hyderabad, the Gypsies. They're one such community. You'll find that there's a theft in the neighborhood. They'll go to this community and pick up the males there. So these three judgments do help you understand how the judiciary is understood practices violative dignity. But where it all breaks down is what actually happens in the court, and I'll end with this. One is what we call the male gaze of judges. How they view women. So again, one important article which all of you should read goes by the name of Reasonable Man, Reasonable Woman, and Reasonable Expectations. How many of you have read it? So this is naturally, this is a must read because it powerfully places how judges look at women. And I don't want to bore you with too many passages from it, but the author basically says, we have all known who a reasonable man is, but we don't know who the reasonable woman is. And in that context, she, after discussing all the judgments, the whole trope of judgments between 1920 and 1950, it's a period of 30 years, the author says this: the reasonable woman is a wife. She becomes one with the family of her husband. She's sexually available to her husband. She doesn't expect to be treated as a wife, only to be maintained. She's entitled to shelter and safety, though she is not entitled to stay in her matrimonial home. She has no marital honor, so she cannot encash her honor as her husband can. So you actually had adultery cases ending up in compensation being paid to the husband because the woman is treated as chattel. She's chaste and keeps unsullied the bed of her lord, even when he deserts her. She belongs to a man, generally her father or her husband. She's married young. She does not exercise choice. She has no politics. She's incapable of being a legal guardian. So the Gita Hariharan case, if you see it from the dignity trope, you'll get to understand this even better. She does not have children. She bears her husband's children. She does not complain of rape. She's incapable of being dishonored, especially if she's of a low caste and this assault is by a high caste man. So the Vishaka judgment, the background to the Vishaka judgment was Bhavri Devi's case. One of the grounds for acquittal of Bhavri Devi was that how can an upper caste person rape a person of a lower caste? Although this article talks of judgments between 20 and 50, we find all those prejudices of the male judges have further traveled into the 20th and 21st century. A reasonable man, after saying all this, okay, the prostitute woman is not a reasonable woman, and she's not to be judged as a reasonable woman would. The reasonable man gets married and gets a dowry for it. Maybe he marries again. He chastises his wife in moderation, perhaps with small beatings, but he doesn't cut his wife's nose. He has control over his wife and his daughter. He's entitled to the custody of his wife, even if she is not yet reached puberty. If he can't have her in his possession, he has her sent away from her mother into institution. I must tell you that these prejudices have continued till date. We were having a conversation with judges from the Allahabad High Court in the Judicial Academy in Bhopal, where we were discussing of the growing trend of habeas corpus petitions by runaway couples. It's very common, whether it's Delhi or Punjab or Haryana or Allahabad, maybe even in Andhra Pradesh. It could be an intercaste, interfaith couple saying that parents of both families are going to, finish us off and we need protection. So in Delhi High Court, as a practice, routinely we would give them protection without insisting on proof of, your age, a proof of your marriage and this and that. And in the next hearing, would call the parents and ask them. When the Allahabad High Court judge heard me say this, he said, no. In Allahabad, we don't do it this way. if this couple comes before me, he said, as a judge, first I will ask, what if this girl was my daughter? And he said, no parent can ever think badly for their children. No mother can ever, intend to cause harm to a child. So, you come with these cultural specific prejudices. It's very difficult to overcome that. So this clash of, the cultural orientation and the male gaze continues. The other day in Punjab and Haryana High Court, a live-in couple was denied protection. A couple so-called living in adultery was denied protection. Because judges, some male judges in the country still feel that this is all against Sanatana Dharma. So they say it in that many words. I mean, this is not left to our imagination anymore. They say it in passages in their orders and in judgments. So these prejudices, the male gaze has continued, mansplaining continues. So we have this glossary brought up to the Supreme Court. I must say it's a very difficult glossary. But it is not something that is developed in discussion with judges who have the male gaze. So for many of them, it's Greek and Latin. They say, don't show us all this. So this is really a problem in the Indian judiciary. Trial court judges, I find, are in denial of dignity violative practices. For instance, if you walk into a trial court, how many of you have been in a trial court? Many of you have. Many of you would have found that the person who's accused of a crime, not the criminal, although we very loosely say is the criminal brought into the court. The person accused of a crime is brought into the court. He has to stand before the court like this, correct? If he stands like this, the lawyer will correct him. No, 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 put your hands like this. And he'll also say, put your head down. Completely violative of the so-called inherent dignity of that person, correct? But we don't think twice. As a system, we completely endorse it and say this is the right way to be in a court. So in Orissa, when we were designing a new court complex in Bhubaneswar, the little thing I could contribute was two. One is in the witness box to have a chair. Because in American courts, no witness is made to stand. In Indian courts, a witness has to stand. The witness will behave disrespectfully if he tries to sit before a judge. Likewise, the person accused of the crime has to be standing in the corner of the room. So when we designed, we said we'll have a seating for the... And many judges said, sir, are you sure we should do this? I said, as Chief Justice, I'm telling you, you have to do it. So, because where do you start? Like lockups. How many of you been to lockups in the court? And the toilet in that lockup, have you seen it? It's an open toilet, not covered. So these are all practices, active practices, violative of dignity happening in our courts. And we're not doing much about this, not doing anything about it, in fact. So why don't we write about what our court complexes have come to signify? How many magistrates look up and speak to the person who's produced for remand? I found in Beggar's Court at that time, before the law struck down in Delhi, the man did not even lift his face. They brought a sheaf of remand papers. They had conducted a raid, picked up some 200 people outside temples, outside public places. And he did not even pause to see any of them. He did not even ask, who's this person? He's overburdened with work, certainly. But what does it do to the dignity of the person brought before him? You're not even treated as a person. You're not even worthy of a question. So within the judiciary, a lot of sensitizing has to happen on dignity respecting practices. So we may talk in various forums and academies, but when it comes to actual practice, many of us have lived comfortably, even in the bar. So you're looking for lawyers with greater sensitivity to human rights, you won't find them. It's a very, very small number. Only the Jolawalas. So even among lawyers, you have Jolawala lawyers. They're called that. So we look to you as law students to carry these things forward. See, these are all the expectations of the Constitution or the preamble. These are the promises that we made to ourselves, right, as people. If we continue to live as fractured societies, there's very little that will happen in terms of change. We will regress. And I think we've regressed very, very quickly. On the social front, we've regressed enormously. In the last 10 years, the regression has actually accelerated. We have to do something desperately to stem the rot. And therefore, I'm glad you're having a conference like this. I'm glad Professor Erin is here to conduct this workshop because it's much needed. We're not discussing this in public forum. It's not happening at all. So thank you very much. Thank you for the patient listening.
Thank you, sir. Thank you very much for that elaborate discussion on the question of dignity. Sir, I just flag one or two questions that I have. One of the criticisms against this Safai Karmachari Andolan judgment is that it considered the question of manual scavenging, especially in the railways, as a question of health instead of a question of dignity. So the Supreme Court exempted the railway department from this judgment, saying it can engage human beings for this work, provided adequate safety equipments are provided. So this is something that is really bothering me for a long time.
Yeah, just to have a small correction. This is written into the 2013 law. Actually, the parliament has made this provision. So when they made the provision, they conveniently gave an exemption to the railways. Oh, okay. Is this working? It was written into the 2013 law. So what the Supreme Court did was to reproduce those provisions in judgment. Okay. And without actually asking whether these provisions are valid or not. So it is, I would say a huge lost opportunity. But from what I heard, because I was in the Delhi High Court on the bench, from what I heard is whatever the written submissions were given with the petitioners were summarized and given as a judgment. Oh. So they didn't have time to really apply themselves. You'll find a very sketchy judgment. The main, Balram Singh does a slightly better job. Okay. And says this has to be narrowly read down. So Balram Singh does not exempt the railways the way that Safai Karmachari does. Okay. So Balram Singh is some kind of a better written judgment.
The second thing is, sir, especially about the habitual offenders. So far, the debate is about certain communities, like Parthi and other people being branded as a whole, as a habitual offenders and also denotified offenders, from which they have not yet liberated themselves for. They're still there being targeted in the name of denotified tribe. But if you see all the ways of controlling habitual offenders of this traditional nature, those provisions are again appearing in BNSS now.
Yeah, absolutely.
But this time, the habitual offender is not confined to any particular kind of community. And it is appearing in multiple ways, and I think it's coming back again.
Absolutely. So this is an extension of what we call history sheeters.
Yes.
So people who live in slums are invariably in the zone of illegality. They already are encroachers on public land, so they're easy pickings for the police. So theft happens in an apartment, go to the next nearest slum, pick up the mails, and keep filing separate cases against them continuously. So many of them will be certified as history sheeters. So this is that same practice now. When you include these kind of provisions, it becomes easier for them. And I don't think that practice is going to end very soon. It has to do with poverty. It has to do with vulnerability. And you're on that underbelly of the urban space. So you're bound to be, and this habits of the police die hard. In fact, police are habitual offenders. So habitual offenders create more habitual offenders. Only some are in uniform, some are not. and they become important informers for the police. So they're implicated in the whole system of control. Social control through criminal law, the entire habitual offender community is implicated. They have no option. If they don't participate in that project, they'll get further sucked in. Many of them have, had several cases, 20, 30 cases. And these are the same people who will be stock witnesses. So there is a pattern that emerges. See, there is a huge stake involved in this. I have to solve a crime. So pick up, if it is a terrorist crime, go to the slum, pick up as many Muslim males as you can. It's become a pattern. And baad mein dekha jayega. We'll see when it goes to trial. They anyway not get bail, And meanwhile, we can keep finding newer cases. So the bomb blast case that I was talking of, when they picked up these people, they added offenses relating to an earlier bomb blast and said these people also did that. It becomes so easy. So it's all part of that larger project of social control through the criminal justice law system. And we need to understand all those connections. You have to map it. Then it becomes very clear. It's a class prejudice, and in India, it's overlayered with a caste prejudice. So that is really what we are fighting against.
The third one is not a question, it's just a comment. When I realized, when I interviewed a prisoner who was a manual scavenger, the depth of the problem really disturbed me. His father was a manual scavenger in Visakhapatnam, and I can give this case study for the clinic. And this guy involved in the manual scavenging from the age of 14, and now is 25. He himself is a manual scavenger. Suddenly after his father died, he became a manual scavenger. He enters the drain. Like his father, he also drinks. Without drinking, he can't do this.
Correct.
And every day he does this job from morning to afternoon, 2 o'clock, and he drinks and sleeps. His wife, who could not take stench from him, committed suicide, and he is convicted of murder. He is in prison now.
So this film called Court, how many of you have seen it? Chaitanya Tamahanes. So it might be useful again to screen it for the part of this course that you're having, because it'll give you several points for discussion. All of this is somehow captured in that film, because it mirrors reality. But it's interesting to see how lawyers fighting these cases cope. Many of us are asked, how come you're not depressed? How come you're not frustrated? I used to constantly be asked by colleagues, why are you doing this day after day? To add to all of this, I was representing several prisoners on death row. So there's no question of a good day in court. So they would keep asking, why are you going on doing this? But if you don't do it, there'll be nobody. There'll be one person less. So there are many people waiting so that they can have their day in court, which is why as a legal professional, you can't afford not to be there for them. And I hope some of you will therefore come into litigation and take up these difficult cases.
Yeah, the floor is open for questions, please.
Yes. Vishnu, you can take it to her. Yeah, you can speak loudly, I think.
Yeah, sir, what do you think can be considered as solutions to this thing? On the note that yeah, I mean, on the note that generally the thoughts revolving and tracking out from resistance. Resistance is that.
I want you to stand up; it will be more audible to all of us. Yeah.
So.
Yeah, I'm trying to switch it off.
Solutions to this whole thing. What can be considered as solutions to this whole thing? On the note that generally the thoughts revolving around resisting to these sorts of thing is that system is too big to change. But the thing is, we are the system, in the sense the people are the system. So how can this be catered?
Yeah, first work on yourself. Deeply search within yourself to see, do you maintain these prejudices or not? First, that's starting point should be you. If you're not convinced that this should stop, then you can't make a case for it. So the Gandhian philosophy there is very useful. I mean, when he started cleaning toilets in the ashrams, that was also a self, it's an introspective act. That's number one as a personal level is concerned. And all these constitutional values we talk of, if we don't practice this in a personal sphere, you can't project it in the public sphere. And when you're a lawyer in the court, you're performing in public. And it'll all be transparent, which is why judges get called out. See, judges have to write. And through the writing, all the prejudices come out. So if somebody had no human rights orientation, no civil liberties orientation, let's say he was a corporate lawyer or she was a corporate lawyer, now becoming a judge, dealing with habeas corpus, that gap is very evident to everybody. That's why the language is so different from different judges. Some people get it, some people don't get it at all. Solutions, don't look at it in the form of problem solution framework. It's the wrong framework to have. All right. Look at RBG. You know, I don't know whether you know what I mean when I say RBG. Ruth Bader Ginsburg. Okay. Her thing was about incrementalism. You fight small battles one at a time. So that's a good way to go forward. Take up the immediate battle. Let's say you found next weekend somebody cleaning the sewer here in NALSAR. I'm not saying it is going to happen. With Krishna here, I hope it doesn't happen. But if you come across something and you can think you do something in your clinic, start there. Because those persons are entitled to rehabilitation under the law. So make a survey, find out how many of them have stopped doing it, how many of them got rehabilitation, how many of them got the money which they are promised under the law. So start in a small frame. Pick up anything. If you want to see manual scavenging, even sweeping streets, all of that. Or like I said, landfill. Start in that one at a time, right? The whole thing can't change. And you can't change entire society. Your own family you won't be able to change. But you can change. It will be a difficult path, but you have to take it. And it's very political. I also want to make this very clear. This is highly political work. It's not apolitical at all. It's proper politics. Human rights is all about politics. Working for the poor is a political work. Because you're giving voice or you're giving visibility to something that is unrepresented so far, correct? So understand that. Please understand that and go with that understanding. It's important to be that. There's nobody who is not political. A corporate lawyer is equally a political person. Palkiwala was a political person. He was a brilliant lawyer, but a very, very political person who brought his politics to the court. So he shaped the politics of the Indian Supreme Court in that first 40 years of the court in a very major way because of his brilliance. But to discount his politics is to miss the point altogether. So now you look at the bank nationalization, privy purses, you'll find a whole pattern emerging, right? And the brain behind all of that is one person. So this will be a clash of politics, no doubt. But that's what democracy is about. So go with that awareness and then you'll feel less frustrated.
Hello. So, sir, first of all, thank you so much for coming and making this discussion truly enriching. I have a small question regarding contesting right, as you talked about in terms of termination of medical pregnancy. To my mind, I think it's a legal question as well as a moral question. It's a recurring theme. Before law school, I remember during that entire Shaheen Bagh episode, two contesting rights came up, the right to passage and right to protest. One right being pitted against the another. To my mind, I thought the right to protest inherently involves right to blocking of passage because that's the way to pressurize the state. So is there a way out or do we just have to trust the discretion of our judges on this?
No, always all of these are ways out. Even Shaheen Bagh had way out. You had alternate routes or you answer their problem, you discuss with them, call them for a dialogue. What else were they asking for? Take a relook at the law. Like farmers' protest, they were blocking highways, right? I don't think there's any clash. We can make up a clash out of anything and everything. Creating a binary is the easiest thing to deflect the whole argument. So you avoid falling into that trap. they will always draw you into a binary. And like whataboutery, for instance. Oh, you're saying this, what about that? Earlier, the same thing happened. You never said anything about that. Forget all this, because this is a very, it's a rhetorical, it's polemical, right? So don't fall into the trap. I'm saying you can see, like, for instance, in the MTP instance, Parliament has recognized that suppose it's a victim of rape or a child which is going to be, not a healthy baby. So there are certain categories that the Parliament has identified, and also has given a time limit. You're talking of cases that fall outside the time limit, but you can use the same parameters. The parameter that now the Supreme Court is using is not what the Parliament intended. And if the law is a valid law and you're only carrying forth that law, why should you introduce new criteria? Because the heartbeat of a fetus starts much earlier. If Parliament permits 22 weeks, the heartbeat had started, I think, in the 12th or 10th week itself, or probably even earlier. So we are suddenly waking up to something which is not illegal. So you can always pit one against the other. We should not fall into that trap of binaries. If you're clear about respecting the autonomy and dignity, which what Parliament does when it comes to women, we can't have this.
Good morning, sir. Sir, I wanted to ask this, that in terms of marginalized children, when we have to knock doors of court for with respect to implementation of their right to education or maybe right to shelter, in terms of marginalized children, how can we talk of right to their dignity along with these other fundamental rights?
Yeah, so this is what is called a cycle of law and poverty, right? If you're displaced from your regular habitat, let's look at the tribal communities in the Narmada Valley, right? They have a peaceful existence. They're not dependent on the state. They have their access to education, access to primary health, whatever is there. You displace them because of a project. You push them into colonies where these facilities don't exist. Let's take up slum demolition, right? You're removing a whole population and relocating them, some of them at least, because many of them will form ineligible. The eligible persons will be relocated, let's say 50 kilometers outside the city. No transportation, no access to education, no access to health facilities. So it's a bundle of rights that you're taking away. So you can easily make the correlation between a dignified existence and an existence without dignity. It's direct and immediate. So they have to come into the city to seek arms. So these are the people you find under the flyovers. So if you trace back their histories, their personal narratives, like Murli was telling us about one narrative of a prisoner inside prison. But if you actually did a subaltern kind of narratives of persons under the flyovers, let's say in Hyderabad, you will find very interesting connections about what happens when you deprive people of their existing habitats and livelihoods. Like many people who are farming or working on farms, if it's all taken up for so-called development highways, expressways, malls, residential colonies, whole lot, the whole urbanization plan, they're forced to come back. I don't know how many again have you seen Do Bigha Zameen? You heard of that film? No. It's a 1952 film. Anyway, I'm just saying because what happened in 1952 continues in 2025. So you can make the direct correlation between deprivation of, and living a life of indignity. Straight connections you can make. So many of the children, instead of going to school, are in work. They're in mechanic shop, tea shops. They're working on landfills. Or some of them are forced into prostitution, early child trafficking. The selling of girl children is continuing in India. A lot of children from Orissa, Assam, Bengal are sold to Haryana. There's a whole trade because there's an economics of it. I think that's something that we didn't talk about. The economic costs of all of this. And nothing comes for free in this country because somebody is making money out of this. So there's no incentive to stop it.
So you mentioned that how dignity can be a relative concept. So that makes it a bit vague. So, but in one of the
No, I was saying that is an argument that I don't buy into, at least in the Indian context.
yes, sir.
Ah.
So yesterday we were presented with the dilemma that it's sometimes hard to find a philosophical base for community-based dignity. But don't you think that this aspect of dignity, that it is culturally relative, actually adds to a base for that, that for anyone to exercise their personal dignity or to have their personal dignity? So, yesterday we were presented with the dilemma that it's sometimes hard.
Some echo. Right.
So for someone to have a personal dignified existence, they also need an existence that is dignified for their community. So does that not strengthen the base for that? What are your views on?
No. What are the examples you have in mind? Because see, when you break it down to actual illustrations, there'll be clarity.
Right, sir.
Ah.
So for example, if I'm a
Like for instance, suppose you say permitting Parsi women who've married non-Parsi men,
right,
if you permit them to enter the Agyari, will the community get lose its dignity? Is this what you're suggesting?
no, sir.
Ah.
It's more the other way, sir.
Ha.
So for example, even if I as a person have a more dignified existence,
Ha.
but if people in my community are being subjected to, say, violence by members of the upper caste or something like that, so does it not become integral to my personal dignity that where in India we have high values attached to the community, that my community also exists in a dignified manner?
No, that is pragmatism. That's not law. So I think what you're trying to say is, should we not be pragmatic about it? Should we not say that, no, the community's collective dignity is very important, and therefore you subsume your individual dignity for the preservation of the community's dignity? Isn't that what you're asking?
Yes.
That's not permissible because the preamble is very clear on individual dignity. Dignity of the individual. So I think once you clear in law, everything else that you're suggesting is pragmatism. And there will be a clash between this and that. See, this whole theme of dignity written into the Indian Constitution is, we've always made these compromises throughout. When it came to untouchables, we said we have a Sanatana system. We don't want to disturb that. We have a certain social order. People who cleaned our toilets will continue cleaning our toilets. Manual scavengers, children will continue to do manual scavenging. So we used our so-called community values to perpetuate indignity. And we have to therefore break that. There's no difficulty in Indian context at all, therefore. In the Indian context, when we talk of this whole area of Dalits, scheduled castes, graded inequality, no difficulty at all, according to me, in clearly calling out what are dignity violative practices. Women will never have their autonomy in the Indian society. Today we're going back, isn't it? They're putting women under pardas. What else are we doing? Valentine's Day, this vigilantes going around in parks. What are we doing? This is precisely what we're doing. We don't want to do it. Women can say, and women are saying. There are women saying that, no, I don't want to cause any disharmony. I don't want any violence. I'll settle for, going along with the community. That's a choice. But it's not a free choice. It's a choice out of pragmatism, out of safety, which is not a desirable outcome at all. So when we discuss what is permissible, not permissible, constitutional, not constitutional, I don't think we should start making compromises even when we start the dialogue. Some things may take many generations to work out, but it does not become therefore acceptable. Correct? That's what the whole struggle is for. This document, why do you keep on? Why is that statue of Ambedkar have a book in his hand here? Just ask. Have you asked, why is he having this book? What is so important about this book? He says this comes first. And when he talks of education, it's about educating yourself out of these things, right?
Thank you. Thank you, sir. We have to stop here because we already stretched our limits of time. So let's reassemble by 12:15. Yeah, because we have to start another session. And I take this opportunity to Thank you, Justice Muralidhar. It's an extremely interesting session in the sense that I hope that some of you are really inspired by, I mean, it is not yesterday we had a lot of confusions about what are the manifestations of indignities, but definitely not today. Because though some of us had some clarity, but still the way that our discussion went on yesterday really made some of us feel that doubt about our understanding of what are the conceptions of dignity. But you gave us a lot of clarity, and I hope that some of you really are inspired by this talk and choose the path that are not taken by students already. Thank you.
We'll take a short tea break and reassemble at 12:20 for the next session.
Hello. Uh, hi, sir. Can you hear us?
Yeah, I can hear you.
Can you switch on the video once just so that we can check that as well?
Yeah. This. Yeah.
Yes, sir. Perfect. We can hear you and we can see you as well.
Yeah. Clearly audible, no?
Yes, sir.
Sorry.
Perfect. Yeah. Uh, if you don't mind, speak a little bit louder. The volume is very loud.
Okay, I'll just fix it. That is why also. Yeah. Is it now fine?
Yeah, it's perfect now. It's perfect now.
Thank you.
All right, sir. Thank you very much. The session will start at 12:20. We'll see you then.
Yeah. Thank you.
Thank you, sir.
Hi, everyone. Please settle down. We'll be starting the next session soon.
से वाकिफ नहीं है. Yeah, you got to keep this away from me. Okay? Yeah.
So we can begin the next session. Thank you, everyone, for joining us here today. Thank you, ma'am, for chairing this session. And we're really excited for this panel. So over to you, ma'am.
Thank you. Good afternoon, everybody. Thank you for allowing me to moderate this important session. Good morning to Judge Nanda. I hope you can hear us. Very often technology fails us. So, okay. Could somebody please modulate his voice, okay? Otherwise, we'll not be able to hear a word he says. Right now, it's coming through as very deep. So let's be clear that we can hear him. Huh? Okay, okay. So good afternoon, everybody. And I realize that it is Sunday, and I was just telling my young colleagues over here that because it's Sunday, I was sorry to have them come out. And she said to me, she loves to hear us talk. And I said, that's because she doesn't have a social life. So yesterday, we spent yesterday understanding the contours of dignity as a concept and its value as a fundamental constitutional construct, and as well as an obligation that it creates within the criminal law. Justice Murlidhar asked us to see, if you could hear what he said, see the person before you and see him as a man clothed in rights, in dignity, and then what would be the treatment that you mete out to him. Particularly, we heard how it helps, how the notion of dignity helps constitutionalize criminal law, both substantive and procedural. So we heard about those things. And I'm glad that you both could hear Justice Murlidhar also this morning. Yesterday also, Erin speaking about the whole theory around dignity and how it enriches the notion of equality, equity, procedure, was really a tour de force on understanding what it means, though it's a concept we all talk about when it comes to ourselves. We want the dignity, but it doesn't translate so well when we're looking at others. So today's session is where the rubber meets the road. We shall be hearing from two judge magistrates, Magistrate Asadullah Sharif and Trijib Nanda, and a civil rights advocate, Mr. D. Suresh Kumar, about the dignity in action, dignity in court. I suspect, sir, that you are one of the Jholawalas that he was talking about. So about how dignity manifests itself in our busy and overburdened courtrooms, especially the subordinate courts, because that's where the majority of people go to for everything. So how does it find a place in that arena? Or how does it not find a place in that arena? So very welcome to both of you. Judges, especially in the trial courts, are everyday custodians of dignity. Dignity of what? Not only dignity of the person, but dignity of the law, dignity of the chair and the position that they occupy, dignity that is delivered through fair process, dignity that is practiced or not practiced every single day. Dr. Ambedkar, who wrote the Constitution, saw dignity as a shield against humiliation. Now, especially for those who were vulnerable to power because of their caste, their gender, their poverty, the disabilities, or simply their circumstances. And yet, even the basic idea, freedom from humiliation, is so routinely bypassed in court that it has actually been replaced by another set of processes which has no legitimacy, but which has become the norm and the practice and the pattern, so that it has become very hard to resist. And I would even venture to say that in my own lifetime, I have seen it become so much the practice and the norm that the actual procedure is entirely no longer in the minds of the practitioners or the duty holders. So that is the reality. True, it is true that the conditions under which you are asking a judge to work are suboptimal. The India Justice Report, where I work, I am the chief editor for my sins, assesses that in Andhra Pradesh and Telangana alone, there is a constant shortfall, perpetual shortfall between 11 and 25% judges, okay? In the subordinate courts. Nationwide, a judge has the burden of, say, something like 2,000. Please don't quote me on this. You please look in the report and see what it is. Approximately 2,000, 2,400 cases of differing complexity that a judge has to deal with a year. It is unsurmountable, impossible task. At the same time, support is unavailable, superiors want speed, superiors want targets fulfilled, peers are competitive, lawyers are fractious and disrespectful, and technology is patchy, and there are 1,000 other duties besides sitting on the bench and adjudicating. I understand this. Holding on to dignity, your own dignity, and the dignity of process in those circumstances is very difficult. It's hard. But we also know another thing. We know, and I wonder if judges, especially young judges who come out of school and come out of these academies, I wonder if these judges realize this. Is that we also know that the judge on his bench represents the Constitution, represents the majesty of the law. He is the king of his court. In a way, he is the rule of law. And that should give him so much power, so much confidence, unbreakable, unshakable. And yet I do not see it in practice. So it is only he who can imbue the whole court and those before him who are entitled to it with dignity. So that's a heavy responsibility. So with so much of a mandate, being overburdened or working in poor conditions, like all the rest of us all across India work, whether we are in the executive or the legislature or students or whatever it is, it cannot become an excuse. It is not open to the judge to say, or to any public functionary to say, I can't follow procedure, because I'm under a lot of pressure. Or I really think this is a very unlovely person who is standing in front of me. And shall I or shall I not give him the dignity that he is entitled to? It's his entitlement. Whatever you do outside the entitlement is a digression and a legal wrong. And so a judge on his bench cannot play the victim card when you are the umpire and when you occupy a position of authority. So Justice Muralidhar laid out an all too common scene for us. And sorry, I said Justice Muralidhar. Also Dr. Murli Karnam, when he was talking, he laid out the first appearance. An accused is brought before the court. I'm sorry if I'm repeating this, but I wanted to say it for our colleagues here because I'm sure that it is very much in their minds. That the first appearance, an accused is brought before the court. If I look at under trials, 98%, 99% are poor, uneducated, unlettered, etc. Perhaps he's beaten. Perhaps he's in handcuffs. He doesn't have a lawyer. The remand order takes less than 3 minutes. No one asks whether there is a real case to answer. That is a fundamental. Is there a case to answer? That is not looked at. Whether the arrest is justified, or if he needs medical help, does he have a lawyer? It is a brief encounter. It's a brief encounter with so-called law. But it sets in motion a chain of injustice. Now, unlike what should be, the onus of this most vulnerable person is to beat the system somehow. He has to apply for bail if somebody tells him. He has to find securities. He has to become dependent on a lawyer to steer him through a system he doesn't understand and he doesn't know the rules about. It is like asking Justice Sharif here whether he will come and play baseball with me. He doesn't know the field. He doesn't know the rules. He's never heard of baseball. I'm sure he has, but he's never played it. And so if I were to say to him, listen, there's a diamond and you have to run around him, he'll look at my fingers to see whether I have a diamond on, but he doesn't know that this is what it's called. Okay? And this is exactly how you ask people to navigate a system. So, from the Constitution to the BNSS, the law demands procedure is followed, and within it is wrapped dignity, which is one essential feature of the justice delivery system. The courts are bound by it, yet no one is accountable for the havoc that disobedience to this procedure wreaks. The only person who is paying the price of that is the person who comes to ask for justice to the court. Because even if he's accused, even if she's a victim, she is coming to the court for ask for justice, but the procedure has created a system whereby you will not go that path because you have deviated from it right in the beginning. So the problem is embedded, but we are here today to work out pathways how to break it. That is the practical use of this session. So I look forward to hear from our panelists, not only why does this happen? I really want to know, sir, when everybody is imbued with so much authority, why does this happen? But most importantly, how can a judge in his high chair, in his black robes, repair it and bring it back to being pure, to being clean, and to save the dignity of law itself from debasement and distrust? So I won't ask any more of our panel. I've introduced them, and I hope, sir, that I've made the direction of what I would hope to hear and what my colleagues and friends would like to hear. And with that little beginning, I will hand it over to Judge Sharif. Of course, of course. I hope you could hear me, Judge Nanda.
Yes, ma'am, I did.
Good. Also, I should be sorry that you hear me.
Good afternoon, everyone. To the Honorable Vice Chancellor, Professor Muralikarnam sir, Professor Vasanthi ma'am, who taught us Constitution here about a decade ago. It's been a decade, I can't imagine. Every time I come to campus, I feel nostalgia. I don't know how many of you have been forced to come here on a Sunday or how many of you are here for an attendance for clinic, but I've lived through that experience and I don't know if I should pity you or be happy that you're here. Now, a few pointers because we're already running late. I am the problem of the system. I work as a judge. I'm a judicial magistrate. So there is, you know, all the criticism that you would have done yesterday. Yeah. And everything that Justice Muralidhar was also saying was correct. So I'm not here to defend my folk. Okay, there is a problem. But however, I must say that while there is, of course, there's a blanket of denial when it comes to dignity, you know, for the accused, etc. We often overplay the infrastructural issues in the courts. There is good infrastructure in the courts. It is a very easy thing to blame that, you know, there is a lack of infrastructure when we don't get things done. But that is not really the case. At least I can speak for my state or a few states where the infrastructure is pretty decent. As far as judges are concerned, the lifestyle, I guess, again, is pretty good. It's not as bad as often it is portrayed saying there's, you know, there's too much work or hectic. It is. But you need to understand a few basics with how we work as well before I actually come to this topic. You see, what we are given are targets. So in every state, the High Court has made certain rules as to the targets we are supposed to achieve. I speak for Andhra Pradesh and Telangana because even after bifurcation, none of those rules have changed. Both the High Courts, both Amravati and Hyderabad, have simply adopted the same rules as it is. So there's a thing called units that we have to achieve. Now, in this state, we are supposed to attain 17 units as a judicial magistrate, 17. How do you, per month? Now, how do you get those 17 units? Is each matter is given a specific unit. So for example, let's say there's a civil dispute for perpetual injunction. Someone has tried to occupy your land, but you're, you know, you've instituted a civil suit saying that that interference should be refrained from. Dealing with that civil dispute, you get 1 unit if you dispose it after full trial. Okay, we call it AFT, after full trial. You get 1 unit. For a CC, which is calendar case, let's say, you know, criminal cases, you get 1 unit if it is done after full trial. If there's a compromise, there are no units. If it is disposed of in Lok Adalat, there's a 0.25. Now, whether that happens through compulsion or with that person's consent doesn't matter, but it's 0.25 units. What makes it worse is that there are additional units for matters which are older than 5 years and 10 years. Now, I'm saying it's worse is because, see, on the outset, the intention is good. We want older matters to be disposed of very easily. But that creates a psyche, a thought process amongst judges that if there's a matter of 2020 pending before me right now, I have 3,000, 4,000 matters pending before me, ranging from, let's say, maintenance cases, domestic violence cases, civil disputes, money suits, all of that. Obviously, criminal cases as well. Now, if there's a matter of 2020 before me right now, If I dispose it of this year, I'm going to get 1 unit. But if I simply wait till the end of this year and dispose it off in January, I'm going to get 1.5. So you see, to reach our targets, I honestly think that, the human in us dies a slow death once we join the process, because now we are obviously thinking of the units that we have to achieve. It's not just sufficient to get those 17 units. Then there is grading. If I get 50% more than that 17, my ACR will say good. If I get double of that 17, 34, my ACR will say very good. And very recently, the High Court has said if I get triple of that, my ACR will say excellent. And all of this will be taken into consideration for my promotions. Or if at all there is any problem, in any allegation, then this will defend me saying, I've been disposing so many number of matters, so allegations are very natural. Some person who is not happy with the judgment might have made those allegations. So this is the atmosphere that we work in. That's one. Second, when we were talking about remands, because Justice Muralidhar had specifically, spoken about remands, it is absolutely true that the judges do not really converse with the person who is being sent to judicial custody. Now, there are a few problems there. I'm not defending judges here, but also the way the FIRs are written and the power, the discretion that the police have in framing the charges goes a very long way. I'll give you an example. Very recently, let's say last week or 10 days ago, there was a remand that came before me where the allegation was of section 326 of IPC, which is causing grievous death by using dangerous means or weapon. So grievous death, grievous hurt, I hope all of you know the definition of grievous hurt. If grievous hurt is caused by using a weapon, a dangerous weapon, then that is covered by section 326. Non-bailable offense, triable by magistrate. So remand comes before the magistrate, yes. But the remand file also has sections from the SC/ST Prevention of Atrocities Act. The victim, of course, is a person who comes from the SC community, no doubt. But the first question that, the inspector had come with the remand, and the first question that ought to have come, in a judge's mind is, was there an offense based on caste identity? Or at least, did the accused know that the victim belonged to certain caste? If no, then he was obviously oblivious to the fact that he had this caste identity. So 326, maybe you can make that offense, but will the provisions of SC/ST Act attract to that? That's debatable. So when I asked the inspector saying, you've said SC/ST Act here also, but there is nowhere in the remand report saying that the accused had assaulted or hurt the victim because he belonged to certain caste or they even knew of them. He openly said, no, sir, I don't think they knew that he even belonged to a caste. Okay, then why did you put the SC/ST Act there? Because the victim belongs to that thing. But what's the reason? And the inspectors, see, generally the police, thankfully they're quite frank also, that they simply go on to say that we have to create a history sheet on this person. So the more number of FIRs that are registered against a person, there is a history sheet. Now, when we say habitual offender, and this is what the remand reports also say, that the person has to be taken on remand and sent to judicial custody. The SHO, the station house officer, writes this in the remand report, that the accused should be taken on remand and sent to judicial custody because he's an habitual offender. Offender implies that he has committed an offense before. He simply is named in several FIRs, but he's not an habitual offender because not a single case has yet been proven against him and he's not been convicted yet. But even when a person who has 3 FIRs, 4 FIRs against him, they're still in crime stage, being investigated, that the case did not even come to the court, charge sheets are not filed. Even in such cases, you have remand reports very commonly referring to such persons as habitual offenders. And there are judges, and it's a very routine matter, where judges remand such accused on this ground, saying that it has come to our notice that so-and-so FIRs have been lodged against this particular accused earlier. Hence, it appears that prima facie, on the face of it, this accused is a habitual offender. So letting him out right now, there can be multiplicity of crimes that can be committed because it is his propensity to commit such crimes. Hence, what we are going to do is we're going to send him to, judicial custody. He has done nothing yet. It's just allegation. And in this particular case, they wanted to create that history sheet. So the question was this, that, okay, fine, let's remand him right now. But there are no allegations on the under the SC/ST Act, only under the IPC 326 will send him to jail. Where does he have to go for a bail? Where can he file a bail petition now? Can he file before a magistrate? No. Because if it was only 326, he would have filed before the magistrate. But since there are charges under the SC/ST Act as well, he will necessarily now have to appear before the special court, Sessions Court, which is designated as special court for offences under SC/ST POA Act. Even though the inspector or the SHO investigating officer agrees that SC/ST Act was wrongfully included there. Similar things will happen. Similar things normally happen with PDPP Act, which is Prevention of Destruction of Public Property Act. Same thing, mischief done on the road. It's very easy for an investigating officer to add a charge under Section 3 or 4 of the PDPP Act. Suddenly, it becomes bailable only by the special designate court, which is Sessions Court. And then the process then goes on to be really cumbersome. So that's one thing. Second, when we talk about dignity now here, when a person comes from, let's say, a marginalized community or an economically weak background, it's just the police who have arrested him, sometimes the investigating officer, who comes to the magistrate along with the accused. There is no advocate, there is no counsel present there at the time of remand. But when you have a person with means or with sufficient human capital that he can actually have a bigger voice, you will see that a lawyer or an advocate will also accompany the accused at the time of remand itself. And at the time of remand itself, the counsel or the advocate will argue against judicial custody and say that this person has to go. So that one thing, the law does not mandate for a counsel to be there at the place of remand, which ideally I think it should. Because at least at the place of remand, you have a counsel representing the case of the accused, which does not happen now. That's one. Second, then there is a problem of remand extensions, and this has been increasing quite a lot these days, especially in the last 1-2 years. It has come up, it has multiplied. Remand extension says the magistrate can only send a person to judicial custody for 15 days at the maximum, because that is what BNSS 187 or CRPC 167 says. The habit of producing these accused persons for remand extensions, that is dying down. So you will see either, fine, video conferencing, it is allowed. So from the jail authorities can do video conferencing and the accused can be produced through video conference. But there is a practice which is in vogue, not just in this state, but across the country, where the accused is not at all produced. There is absolutely no information from the jail authorities. And despite that, the judges go on to say, accused is not produced, remand extended for the next 15 days. And there are cases which have about 6 months, 9 months, and even a year of remand extensions with absolutely the accused not being produced. There is no whereabout of the accused. If the judge directs someone from his office to contact the jail authorities will simply give 2 reasons. Reason number 1, we do not have enough staff, escort, to send this person to this particular court. Reason number 2, he has several cases pending, against him. So he has been produced in another court because there we needed him for remand extension. And that keeps going on. So much so that the jail authorities have simply lost the warrants that were issued by the court, saying, we don't think there was a warrant issued against this person from your court. So imagine when there is no warrant, and if this person now goes to let's say, High Court for crossing of the bail, and the High Court does insist for the case file to come to the bench, and then they want to go through it. Tracing out this file itself will take weeks of time. So that's an issue. You see, when we talk about dignity, it's very obvious that there are these practices which are in vogue. Then there is, of course, as Justice Muralidhar also pointed out, that the issue of like if you might have visited the trial courts, but it is very common. I've seen this. It has happened quite a lot in my court also, where the accused are even asked to leave their footwear outside the court and enter. Whereas even the attenders or advocates, everybody, obviously they have their shoes, chappal, everything, but the accused are supposed to leave their footwear and then enter the court hall and stand, with their hands folded, and then keep, even when you ask the accused to sit, there are 10 people objecting, saying, no, sir, this person is accused. He's not a victim or a witness. How can he sit? And that itself, even for the accused, you see, it's so internalized that when you ask the accused to say, he hesitates at least thrice, saying, is it me, or is the judge telling someone, behind me, or like, how am I allowed to sit? Because it's so out of fashion for him to even sit in the court hall, that when you ask him to sit, he'll go like, okay, I'll sit, but then he sits without comfort, and then he's sitting on the bench, but he's half sitting, half standing. And the moment, any time during the evidence, the accused is referred, he stands up, and then he says, okay, my name is taken, so I have to stand up. So that sort of thing. So much so that the advocates have also thought in many cases that when a judge asks an accused to sit, there is an apprehension that the judge might be siding with the accused because, okay, well, this doesn't normally happen with other people, then why is it this judge being too kind to that accused? So now the judges have to be like, no, if I ask the accused to sit, the advocates will think I'm, talking to the accused outside the court, so I'm not allowed to do that. Now that fear comes again. So you see how this is reinforced. It's so normalized that only when you come to places like this that you talk about these issues. But the biggest gap, happens where, before I was actually posted, I went through 1 year of training. Not a single time that we actually spoke about, let's say, the aspect of dignity in our judicial academy. Not a single time, not a single lecture, not a single minute we spoke about dignity. We talk about remands. We talk about giving benefit of doubt to the police. You know how benefit of doubt is given to the police? Let's say, for example, there are several violations in remand. Accused comes. And the first thing, let's say, I would ask the accused is, what's your name? Because I want to tally that person's name with the identity, saying if this is the same person or not. Okay. First question then, when were you arrested? He'll say, okay, today in the morning. Are you sure you were arrested today in the morning? Yes. It's necessary because he cannot be kept with the police for more than 24 hours. So you need to identify that. Now, let's say the accused says, I was arrested 3 days ago. 3 days ago, you were arrested. I was asked to come to the police station. I was made to sit. I was put in the lockup for one entire night also. Next day, I was let go. But today, I was again arrested. So what was that 1 day for? Because he was let go for, let's say, 1 hour. Then there's a break. So the police is not counting that as a part of custody. All right, you were arrested, let's say 3 days ago. Were you beaten? He hesitates because obviously there are police around. So you have to send all the police outside and then you ask him, were you beaten? Then he hesitates again because he thinks that obviously telling the judge would mean that the information will pass on to the police and then it might happen. Third time when you ask him, he might admit saying, yes, I was beaten. Okay, maybe to admit or maybe to elicit information about who are the other co-accused accomplices in the crimes, for whatever reason. Or if there's a theft or robbery, then recovery of property. It's a very, this thing that he was beaten to, trace out the property. These are obviously gross violations. The practice is this, and this is what we are taught at the Judicial Academy, that despite all of this, if there are good enough reasons to remand, you still send him to judicial custody. And you simply make a note that the accused has reported ill treatment in the hands of police in the remand order. Hence, explanation is called for from the investigating officer for these violations. And the investigation officer is given 1 week time. This person is sent to jail. The letter goes to the investigating officer. The IO then replies to that letter. And now the IO says that, all of what, obviously he's not going to admit, he's going to say everything that the accused has stated is a lie and that did not happen. We arrested him on the same day. He has, enmity with the police, so he's making accusations against us and all of those things. And I have yet to come across a case in about 4 to 5 years of, me working in judiciary, where any action was taken against the police. The judges simply say explanation perused, noted, no further action, they sign it and they leave it. Worse, it doesn't even go into the same file. So if, let's say, there's a conviction and if an appeal happens, or whatever reason, let's say there's a bail petition that is filed in the High Court, the High Court does not come to know that this has happened. An explanation was called for and this was the explanation. Because that communication with the police is treated separately. So where you see lapses in that process, those lapses are covered up so well, but the normalcy then continues. And this happens, and the Judicial Academy is not supporting or not conducting any session, obviously has this thing of like the judges are not sensitized enough to even know that there are these issues that they need to this thing. And obviously there is that, internalized, you call it casteism, communism, or even patriarchy, that obviously comes in and the judges don't realize that they're behaving from those perspectives. Even if you prod them and think that you did this, there are 100 excuses where they find that it was on merits, but it was not due to such prejudice. Then there is issue of legal aid, because this is one big thing, and Professor Mullikan also has been working on this. The problem again with legal aid is this, that lawyers who are appointed as legal aid counsel are not really interested in this matter. I'm not mincing the words at all. They have no stake in it. They are appointed by DLSA, District Legal Services Authority, has a panel of lawyers who work as LAC, legal aid counsel, but there's absolutely no stake that they have. They're not getting any fee. So for them, they simply have to file something for the sake of doing it. There was this thing about 2 months ago where I got a bail petition which said that the accused is a Nigerian citizen and he's a student, he's studying in Bangalore and he has come here for his education, and because of his race, he was arrested, etc., etc. The accused was here and I asked him what was his name, and he said, sir, my name is Ramesh. I said, are you a Nigerian citizen? No, sir, मैं तो झारखंड से आया हूँ, यहाँ पर काम करता हूँ. Why does the bail petition say Nigerian citizen? Because 1 week ago, there was a bail petition which was actually filed by a Nigerian citizen there. And this legal aid counsel simply went to the clerk and said, can you please give me a bail petition with this person's name? He did not change the contents of the bail petition. It was copy pasted. The names and the number, crime number and the names were changed. The petition was filed as it is. And this is what the legal aid counsels do. So even if the bail is given, the problem then comes of sureties. It's a huge problem of how sureties are. Number one, sureties, especially of those people who have means to produce surety, is a big thing. You either need a person who has a government job to act as surety because he'll come with his salary slip and say, you can attach my salary. You need a person with some land or house to say that this is house valuation certificate and this is this thing. Or if the judge is kind enough, then fixed deposit as surety, but again, money has to be paid in the bank immediately. Fixed deposit receipt has to be taken, saying 10,000 rupees ka fixed deposit has been done, and that fixed deposit receipt has to be filed. Will the surety pay the money for fixed deposit receipt? He won't. Again, obviously, the burden is on the accused that he has to get all of this arranged. Then the bigger problem is of insisting for local sureties. If a person coming from UP, Bihar, or Jharkhand comes and commits a crime in Telangana, and you insist that he has to furnish local sureties, he's not going to get a single one. His own employer will not come as surety. If he's coming in working as a labor here in construction business, his own employer will say, I don't know this person. And this person is in jail only not because he didn't get bail. He got bail, but only because he's unable to furnish local sureties. And that's a big problem, even though the Supreme Court highlighted it many times. I mean, Justice Krishna Iyer, in this case, Moti Ram versus State of Madhya Pradesh, 1978, he said, when you insist for local sureties, the judges are betraying the idea of unity in India, because you're saying that a person from, let's say, Tamil Nadu cannot stand as surety for someone from Bihar, because then you're saying that, these people are different and the entire unity of India itself at stake. Several instructions, but despite that, the prosecutor, the police will come and say, we need, local sureties, because if local sureties aren't taken, then we will not be able to trace this person again during trial, and the case will be pending. He'll go back home to Bihar, and we will not be able to do it. So there are these issues. Then I'll simply conclude because I think I'm taking too much of time. Then we come to trial. And at that time of trial, number one problem, of course, is witnesses turning hostile. And how do you handle that? As I mean, the advocates do it pretty well of how doing this. I'm not arguing against the advocates, but sometimes it so happens that I often say the pendency in the cases, I think you can ascribe the liability of up to 90% to the advocates at trial courts for why there's such a large pendency in the trial courts. Because even if an advocate, I have seen this anecdotal evidence, of course, personal, but I've seen many advocates simply say, even if they're winning the case, they would still want to be winning the case next year rather than this year, because they would want to keep the case file with them, for as far as possible, because that's a recurring income for them. But there is that problem of, advocates prolonging for sure. They lead, to these hostile witnesses, and the witnesses come simply and say that we don't know anything about this case. And even if there's a conviction, a bigger problem is that when, let's say, there is good evidence that a person has actually committed the offense, at the time of sentencing, the problem that a lot of judges face is that the process itself has been such a huge punishment for the accused that sentencing just appears to be an additional punishment that you're giving, which is not how it's supposed to be. That the fact that he has come to the court every month, once every month, or maybe twice, for about 5 years or 6 years, that itself is such a big punishment that even if that person is let go, I think he has served his punishment for whatever he might or might not have committed. So that's one thing. And whenever you're taking liberty out of, liberty of an accused, the intention of the police is very clear, that it is sort of to teach a lesson to such persons, saying if we don't send this person to jail, then others may be emboldened and commit more crimes, and it sends a bad message to the society, or he himself might take law to be, a very light matter, and he might commit further things. So the reason as to why an arrest is happening, and the reason that are put on paper as to why the arrest happens and why the person is sent to judicial, custody, they are completely different. You will see that the reasons recorded in a remand order will say it is essential for this, person to be kept in judicial custody because he may abscond, because he may tamper with the evidence, because he may threaten witnesses, or because he may commit further crimes. So I'll conclude, just 1 minute. So there are reasons that are written, but the actual reasons that the police have are none of these. The actual reasons, of course, is to make sure that that power structure is maintained, and and to ensure that, lesson is taught immediately at that juncture, not at the conclusion of the trial. There are many other issues that I wanted to flag out during the trial as well, but I guess there are other speakers, so I'll conclude here. Maybe if there are questions, I'll take it. So thank you so much.
Thank you. I think for all of you who are going to be part of Dignity Clinics, this is a very good practical story. How do you overcome it? The solution part. We really have to work at the solution part, and I suppose jointly. May I now ask Judge Nanda, sir, Murli, what is the time? 20 minutes each. Sir, if you'll keep to 20 minutes, I'll be very grateful. It's 4 minutes past 1. And please, if you can't hear him right at the initial because it's fuzzy or whatever, please put your hands up, because otherwise all the 20 minutes we'll be looking at our watches or something. Okay, please. Judge Nanda.
Thank you for the time, and I'm indebted to the organizer for this privilege to speak in your presence. But at the outset, permit me or pardon me perhaps to to begin not with law, but with love. Because had it not been you, people like you, had it not been people like Dr. Murali, my teacher, had it not been for your nurturing, mothering, then perhaps I, once confined in a juvenile home as a child in conflict with law, may never have reached this space to adventure with dignity. While I'm not sure if I have fully reformed, I still cultivate a confusion about the politics of law. You know, when the JJ Act itself acknowledges that a child in conflict with law is essentially a child who is also a neglected one, either by the parents or parents' patri, then I fail to comprehend why it confines the child instead of correcting the neglect, if not punishing it. In this background, since I am asked to speak on how the promise of dignity interface at the grassroots level, I will not go into the detail as my friend has already spoken in detail about the day-to-day work, but I will try to put lights into why the situation the way it is. And to begin with, let me invoke another contradiction, which are fundamental, but that has repercussions which are beyond the purview of law. For example, the doctrine of ignorance, that is, ignorance of law is not an excuse. You know, the widely accepted, but and even which is prevalent since the origin of law itself. But the repercussion of it when it interacts with another fundamental doctrines of procedural law, there is audi ultum partem, that promise for a fair hearing. And when we see it from the lens of Section 12 of Legal Services Authority Act, which provides for the category of people, those who are entitled for free legal aid. And if you make a simple calculation of the categories, then you will find that almost more than 90% of the population of India, as per Section 12, are in need of legal aid and awareness. So you mentioned about the playing games without knowing roles. So I mean, as a presiding officer, when I compare it with as a referee of a football match where 90% of the player do not understand the rules, a batsman getting out, imagine, or a bowler celebrating just because the umpire raised hand without knowing why. So this is how the day-to-day work in the court. This is how the day-to-day work in the court is carried out. So here I want to ask a question. While most of our talk and deliberation are confined to the 10% who knows the law, so when you talk about rule of law, is it rule of law or is it the rule, those who know the law? So from here, I want to give one insight which we all know from the field, but not very often theorize. That is, that much before the trial began, in fact, it is about setting the criminal law into motion. As you know, there is no principle of locus standi because the violation of the penal code itself victimized the people and the republic as a whole. But I want to ask, who actually set the criminal law into motion? It is always the victim who has suffered harm in terms of injury to his body, mind, reputation, or property is again burdened further to travel to the police station and file the case. The next important question is, which is directly related to the repercussion of the doctrine of ignorance and the efficacy of the doctrine of audi ultum partem, is who scribed the FIR. And a clinical survey or review will reveals that though the CRP, the procedural law says that the SHO should write it. But in fact, it is most of the FIRs are written by people who are beyond the reach of law, either retired police officers or advocate clerks, or even semi-professional lekhankar, those who are popularly called. So when a lekhankar writes an FIR, it removes the agency of the victim. He introduced his own bias into it, and his knowledge of official language, not law. Whereas when an SHO writes it, he is the senior most official of a police station who face cross-examination in the court on a daily basis. That's why the law expects him to apply the fact into the provision of law. But when a lekhankar writes it, and there is a rate chart unofficially that in fact the rate chart is directly proportional to the mens rea and the offense involved. For example, if the offense is variable, let's say they will charge some 100 or 200 rupees. If the offense is non-valuable and if it's session tribal, then the rate will increase. And these lekhankars or ghost of FIR writers, I say them, are in fact beyond the clutch of law. So what this suggests is about the grassroots of law is a reminder that the root is not native, it is imported, rather it is imposed. So from this, when I try to understand that the history of this root of law, you see, from the Vedic system of exclusion to the Victoria rule of Victoria, and beginning with Plato's Republic to Aristotle politics, and even be that Augustine's original scene or the secularization of it by Thomas Hobbes in the name of state of nature, and even the Kant's categorical imperative or Hegel's realism, absolute realism, or Marx materialism, to the Bentham's pain and pleasure. What they do and what is common in them is all proposes one universal order with utter disregard and disrespect to the diversity and dignity of the people. Here I want to ask a question on behalf of the 90% of people, that can we imagine dignity, or can we imagine coexistence of dignity with dependency? Because if we see the colonial history of India, which is in fact an illustration of this, one or singular universal order, then you see that law was used as an instrument of perpetuating cruelty and loyalty. For example, while the Criminal Tribes Act and the Forest Dwellers Act, Permanent Settlement Act impose cruelty by making people criminal by birth, by making forest dwellers homeless, and by making wandering sovereign bonded labor, and the pre-trial detentions that confine people without even a promise of trial. It all imposed cruelty. Whereas on the other hand, the law also nurtured loyalty, by conferring titles to the local princes, gun salutes, privileges, signing channels with local rulers. So this culture of cruelty and loyalty defined the history of colonialism in India, which, in my opinion, the Indian Independence Act, the Indian Independence Movement, the freedom movement, was also an endeavor, an endeavor against arbitrariness and absolutism, which was in fact culminated into the Constitution. And I see the Constitution of India as a rupture of this colonial culture of cruelty and loyalty. How is it in rupture? Is in Article 17, it criminalized cruelty by not only abolishing untouchability, but also, you know, uh, by making it an offense. In Article 18, it abolished titles. So thereby it reversed the order. Before the constitution came, against the law, if against the law, an adventure with dignity was that we had only one option, that is to resistance violence, which was itself a exclusion, a form of automatic exclusion. But after constitution came into force through Ambedkar, it gave a third path. That is how I referred Article 17 and 18. But it was not automatic. As you know, Article 372 legitimized the continuity of colonial laws, and Article 13, on the other hand, put a filtration that pre-colonial laws, those are not in consonance with the Constitution. Application of them is void ab initio. So, the last 75 years of the constitutionalism, in fact, I sum it up as a conflict between the continuity of law on the one hand and a constitutionalization of it, or a due of its constitutionalization. So before I go into discuss some of the more field-based experience, I must here bring that in the last 75 years, the contention between Article 372 and Article 13, that while, in the first 3 decades of constitutionalism, Parliament, took credit of bringing some landmark reforms and thereby even curtailing the jurisdiction of court and thereby limiting the scope of participation of people in the process. But until 1974, the CRPC came, the pre-colonial laws and policy remain in force. The judicial magistrate, despite having Article 50 that speak about separation of executive from judiciary, remain within the control of district magistrate, who was also the head of police. It was only in the 1973 CRPC that judicial magistrate was made independent, which came into force after the latter part of 1970s, when Supreme Court in fact recognized the right to dignified life as a fundamental right under Article 21. So this is where I understand when in the last few decades the Supreme Court has went on even acknowledging the rights, but even fixing accountability not only on the police but also on the magistrate, judicial magistrate, while using discretion in judgment like Anesh Kumar, Satinder Kumar until, while guiding the use of discretion, how it fails to translate at the grassroots level is because while the Supreme Court took about 30 years to realize the constitutional aspirations, I believe the trial courts are yet to reach there. In this background, I want to bring the latest case discussed by my former Chief Justice, who about the Sukanya Santa case and the constitutional transformative potential of the Indian Constitution. In that respect, when I look into this judgment from the lens of a trial court judge, how I see it is Article 17 as a constitutional crime is not only available against the state but also against the individual. But it remained, in force for 75 years. And when after 75 years, it was identified and acknowledged that the prison rules that provides for division of labor based on caste is a violation of Article 17, and in fact is a constitutional crime, it only passed an order of conviction without sentence. without even naming those who are the violators of Article 17. So it's when you see it from the perspective of dignity on trial, a warrant that remain unexecuted for 75 years, in fact, reduce Article 17 into a moral code. Why I refer to this is because it speaks, on the other hand, the reality of the working of the trial court at the ground level. When we see that in the prison, majority of population are from SC, ST, and people belonging to backward class, then we see that this continuity of law over constitutionalization of it. I am I'll bring the our discuss topic of bail and remand and bail jurisprudence. I believe that it is not only about the liberty that the bail is discussed with such intensity, but also it is because of the stigma that society attaches to it when someone visits a jail. Why I say so? Because it is equally important whether someone is inside the jail or on bail. The liberty is conditioned until the end of the trial. One is bound to appear on each date of posting of a case, and if not physically, through an advocate with the permission of the court. So when we limit the scope of Article 21, person in custody, and the scope of speedy trial only to those who are in the custody, we undermine the conditioning of liberty of lakhs of people, those who are on bail. And the other aspect of bail is, again, the consequences of the conflict between the continuity of law and the constitutionalization of it. Because historically, we know that most of the people belonging to SC, ST, and marginalized people had never owned property. Even if they had land, they did not have document. So when the financial system of bail expects them to, a property-based bail system expects them to provide furnished security or surety to, enjoy the conditional liberty, then it goes beyond the purview of law. Sometimes while they stay inside the jail despite being granted bail, sometimes the whole family is victimized. They are pushed into forced labor and migration, which are not even within the scope of law. Then another point, a contradiction with which I will end.
Sorry, Judge Nanda, you have 3 more minutes.
Okay,
Just to take.
Thank you.
Sorry about that.
So the last contradiction that I will bring maybe is the, while in the last 75 years, the Supreme Court has in fact passed many landmarks judgment guiding the discretion at the ground level and constitutionalizing the, colonial and pre-colonial legislations. How do you see the recently, enacted BNS, Bharatiya Nyaya Sanhita, that replaced IPC, which in fact replaced the penal with Nyaya or justice, but in content, it enhanced the punishment. It over-criminalized certain behaviors. So here I ask a question, if BNS equates justice with punishment and followed by another, that if the purpose of a penal law, substantive law is punitive, how much justice can we expect from the procedural law? Because we know that the object of procedural law is to execute the mandate of substantive law. So yes, I will stop here with one line that we all are either product of cruelty or loyalty, but the third path that Constitution gives is of to live a life with dignity. And I want to ask a question to everyone, that when Article 13 says that pre-colonial laws cannot be applied and it declares it void ab initio, shall we wait for the Supreme Court or the higher court when the definition of Article 12 includes all the institution of governance as under the definition of the state, is it not an obligation of all the citizen and all the institution of governance to automatically not apply those laws because they are void ab initio? Thank you.
Thank you, Judge Nanda. You bring up a point that hasn't been touched up to now, is that if the colonial laws and the substantive laws are indeed punitive and do not stand up to constitutional scrutiny, then is there a duty cast upon judges and also ordinary citizens perhaps to do something about it, academics and those? I don't think you could just throw them off the books, but Vidhi has just done a really, really good study on crime and punishment. 7,200 laws which have in them to some degree or other punishments. And some of them are extremely absurd. You know, like one of them I remember is not adequately walking your dog may lead to penal consequences. So one of the things that Vidhi is advocating for and should have your attention is depenalizing, decriminalizing. At the same time, you have the BNSS or the new laws, which have actually increased some of the punishable acts. And in many others, they have also decriminalized some, but in many others, they have actually created mandatory sentences or longer sentences. Now, what is this going to do to the jails? And what kind of burden is it going to put on the magistracy? Only another year or two will see. In regard to bail, there is what you have said, Judge, and what you have adverted to, Judge Nanda, is very much the problem, and the solution to it at the moment has been just a sort of band-aid that we will create a fund for the most vulnerable and we will pay their bail or stand surety, which seems to be a bit circular. The state is asking somebody to appear and make a condition for appearance, but then the state is paying for that. But if he doesn't appear, then the state will pay the state for the state to do something. It's a bit roundabout, but if somebody else can explain it to me, I'm full of it. I'm so happy about it. So that brings me to Advocate Suresh and the Jholawala advocate. Yes.
Next time, I'm so thankful for inviting me. It's a great opportunity for me to share my views on the topic that we have been discussing since yesterday. Because so much of theory has been already discussed, I'm not going into that. And as a lawyer, because what we discussed is when put into practice, has issues when it comes before the court, how the court is reacting or how with that issue we are approaching the court is what I'm going to share with you all. And before I start, as a young lawyer, you're all going to be lawyers. When I entered first time to the court, I saw a writing, be howsoever high you may be, the law is above you. It really fascinated me in those days. But with few months of my practice, I realized that that means that everyone is equal before the law. But in practice, some are more equal some are less equal, is what I understood. And with that understanding, as I have been an activist in civil liberties organization as a law student, and we dealt many, I have filed cases, and some of related to the topic which we are discussing, I confine to that. And because we are speaking about the dignity, dignity, it has different meanings and different different situations with different people, where when they face a problem, legal problem, when they approach the court. The first case I would like to discuss with you all is that it was a 10 years long legal battle. Recently, judgment is also passed. A young couple approached me who got married, who are belonging to different religions. When they want to join their baby in school admissions, because they are belonging to, one is to Hindu and another is a Christian, they want to bring up their children without any religious influence on them. Outside the religion, they want to bring up. And they are, not they both, but husband is a non-believer, and wife, though she is a believer, but she too agreed to bring up their children in an atmosphere of no religious influence are there on them. So when they went to the school admission, in the admission form, they are asked to fill up the religion of the parents. They put there no religion before the religion column and no caste before the caste column. Then the school admission, they rejected that application. Before rejecting, they said that if you are not, as father, not willing to write this, at least you give your wife's religion. Then he said that we both are decided. Then they said that we cannot help it. The rules are saying so. So we have to follow the rules. We will not give admission. He approached first to the Human Rights Commission, SHRC, State Human Rights Commission. In the Human Rights Commission, what they passed an order is to the authorities, that the education department, to follow the law in work. The law is that every admission forms, invariably they have to fill that it's a fixed format. So they have to give the religion name. So for those who doesn't believe religion, who are religious, what they have to do? And then that matter has come before me to file a writ petition. I filed a writ petition when the child was 3 years old. Interestingly, I got an interim order in admission stage itself, observing that right to practice religion under the Constitution means right not to practice also. It is a fundamental right. So interpreting that, an order is given to as an individual relief to the baby to admit in the school. And then my friend got that this is not a problem for me only. It is a problem for many of the couples who are with this kind of ideology. So their identity, here comes the identity of their, is a forced identity is being given to them. By looking at their names, they themselves fill up. And it's not at the stage of school admissions, even at the stage of giving birth certificate by the register of births and deaths register. And even at the stage of at different stages, it comes up. And in the census also. In the census also, that problem arises. And in the census, if you observe, there is one column, after giving 6 major religions, one column is left with the words that no religion stated. So under that column, all these persons, whoever are saying that they have no religious practice, they are giving under that column, they are counting and enumerating under that. But here the problem is, he is stating that he has no religion. It's not that he has not stated any religion, or the stated religion is not under the before 6 columns. The 7th column is given for that purpose. So it's a problem, legal problem. Then we filed a bill before High Court. And while we are approaching, we have categorically stated that the girl who is a minor, till she attains 18 years, she will be, we are the guardian. So we want to bring up her without any religious influences on her. And after 18 years, it is her choice. That also stated in the affidavit. She can go back to any religious of her choice. And we also stated that we are not against, because when we filed this writ petition, giving so many reasons and grounds, because every politician says that we want to end up religious differences and caste must go, all that they give speeches. But when it comes to practice, there is no such provision to give up the religion or caste. It haunts you everywhere for different reasons. Even for who want to voluntarily renounce their religion or caste, they are not given that opportunity. So that, as a case, when we raised seeking a column, to provide a column in all the official records as an identity, no religion, no caste, NRNC, we named it NRNC, as a direction to all the departments, wherever this is being registered. Interestingly, the counter filed by the state, we have made the parties as a central government also, union, because census as a party, where they also, they raised this point that we have provided a column, which we denied that column will not suit to me. And the state government, several departments we made them as parties, but they never chosen to file any counter. Only when it came to final hearing, then they filed a counter saying that we have collecting the data of religion or particular caste only to give the social benefit of reservation facility. So here I have stated in the affidavit, voluntarily we are renouncing, even the reservation facility also we are foregoing. Despite of that, when they are insisting that this is for a purpose we have created, so they have to write. Or they said that they can, if they want, we will give that, we note it. But in practice, now, because all this has become in an electronic system, because when I filed this petition, it came to final hearing after 7 years, almost 10 years. And the girl has reached 10th class. In the 10th class hall ticket, it is not a written format. You have to fill it in the, what do you call? So unless you fill, you will not get the hall ticket also. So there, again, a problem has arisen. And I went to court saying that this is the problem. My identity is being enforced on me. So then the court, interestingly, said before the court also we have brought this identity is as old as Hinduism. All the other religions are after Hinduism they have come up. With the population, very less population also, they are being given a column. And the persons who are non-believers are religious people. If they take the census, even as per the census records also, to Jainism and particularly the state of Andhra Pradesh, there are more number of people than Jainism practitioners. So you are denying a fundamental right for me of my identity, and you are giving an enforced identity to me. So that when we brought before the court and giving the data of outside India, This is not being in India, we are practicing, but when we go and look at around the world, irreligion, they do not have caste, we all know, but religion, religious practice, religious people they call. That when they are enumerated in the world, after Christianity and Islam, the third largest population is religious. But that such a big identity outside India is not being recognized, and I have to fight for a 10 years long battle in the courts of law. And ultimately, when final hearing is going on, judge asked me, how many people are there with this prayer? So I cannot give the data because I approached by way of a pill seeking, there are so many people, and have given the data also. Then the judge has, in view of the counter filed by the respondent saying that they have no objection to record your religion as no caste, and in view of the fact that you have not brought with any data, you have not quantified how many people are asking, since it is a pill, we are not dismissing your case, we are not allowing your prayer also. So I am disposing with this accusation, is what they said. But immediately after this has happened in October of last year, and immediately after the next month, in November, Telangana government, first time in India, they have given a call and they have put into practice that caste enumeration they started. In that, then we got an opportunity to raise this issue because our bill is disposed with an observation that quantified number is, it is not quantified, so we are unable to pass orders. Now an opportunity is given by the state of Telangana. Since you are enumerating the caste census, you give this recognition of no caste, no religion people also. We got the order on the same day because the next day onwards, it has started in the month of November. We got the order, and in the enumeration, which census went on, this column is created. No religion, no caste. His column is provided, is what we were succeeded. And for the first time, Telangana government has enumerated how many people in India are there, in Telangana are there without religious practice, is what this is. Though it is an identity, it is also an identity, and their dignity is identified with their identity, which is being denied in all the other states. And I came to know in Madras, and High Court has recently given an order like this. This is, I am unable to bring before the court. The court has specific orders. Can you show any orders? Yes, there are no any similar orders so far. There are no precedents. But with this, I came before this court. This court can pass, is what I thought. But anyhow, I got the order before a single bench. I did not get the order in pill, but again, Colonial Nirmula Sangam, with which in view of the government of Telangana's initiation, we were able to do that in success. We successfully got that. And moving on to identity of, because naturally two lawyers argue before the judge. Now here two judges are there and I'm one lawyer standing before you. But going to, in the magistrate courts, so I want to this because so much is discussion regarding the lower court practice is also taken. Other two speakers have spoke. But my question here is the magistrate in a case where 153 IPC is the offense with which Usmania students were taken into custody and produced before a magistrate. The magistrate who has remanded them, when I filed a bail petition, because bail can be granted by the magistrate, he refused to take my bail petition, saying that this is not a special court. This offense can be is to be has to come before a special magistrate court. He is not available. So as an in-charge magistrate, I am doing this. I can only remand. I will not do that. Then I question that under 153A, and the case is there, if you are able to remand, you can also grant bail also. Then the judge, of course, he sent back the case to the original magistrate, who the next day we got the bail also. But here my question is, the magistrate who are entrusted with any in-charge responsibility, they will get that full responsibility, and they have to do that. And such things we come across, and of course, I have to now share with you another case of UPA case, where here comes of course, we have to see this, all these are as part of rights of prisoners, and their rights to be honored as per law. In Mancheriala, Chennur Magistrate Court, in a UPA case, a couple of 70 years and 65 years old, a couple were granted bail by the magistrate when charge sheet is not filed under UPA within 90 days. But immediately on the same day, the APP he filed a revision petition before the Sessions Court, saying that it's a UPA case, bail cannot be granted by the magistrate. And no opportunity is given to the PP is also one of the objections, with which the Sessions Court has granted a stay on the order of the bail. And in fact, that matter before the Sessions Court judge, we had to fight for 1 year. For all 1 year, the Sessions judge went on giving dates till the charge sheet is filed. And the next day only, after filing the charge sheet, he has dismissed, he has allowed the revision petition, saying that since the charge sheet is filed and a prima facie case is made out, bail is not being granted. Now we filed the case under 167(2) clause. It comes under CRPC chapter 12. It is not a bail law. It is under the chapter of investigation. So it is within the jurisdiction of any magistrate for any offense to take to use his judicial power and take a decision. When charge sheet is not filed in 90 days, then bail is to be, we all know it is a statutory provision, so bail can be granted. It may be an offense under UPA, but the magistrate has got that power. And at the same time, APP has to file a petition before the magistrate to obtain further time to file for investigation time. He has to file a petition by an affidavit by the IO. So such is the law. In the UPA also provisions are there. Without in the absence of all this, the magistrate is fully empowered to pass bail. Is now what we challenged before the High Court, and High Court has granted that order. And that is how the magistrate level, at the district sessions level, the courts and judges are casually, here the magistrate has shown his he is with the law, but the session judge has interpreted in different way, and he has denied it. And of course, High Court has finally got this order. And I'm moving on to my other cases where, since we are speaking about discussing about the dignity, dignity is not only for persons who are living. Dignity has to be shown, has been shown to the persons who died. But except the state. State, because I am bringing a recent case where a Maoist leader Nambala Keshav Rao was killed in an encounter, said to be an encounter, and along with him, some 27 persons were killed. But 6 persons' dead bodies were kept there, despite of the near and dear going there to Chhattisgarh from Andhra Pradesh and Telangana to claim the dead bodies. They were not allowed to see the dead body. So without even showing them, postmortem is conducted. Without even allowing them to have a last look, they kept the bodies there. And when we moved the High Court of Andhra Pradesh, High Court has given an order saying, observing that we have no jurisdiction because the Advocate General of Andhra Pradesh appeared and Advocate General. So in that, the order is basing on the Advocate General statement of Chhattisgarh. We have, after completion of the dead bodies, we will give back. But completion of the postmortem. But the postmortem is completed and dead bodies are not given back to them, and they were cremated on their own, the police. So the person, the near and dear of the family members who went there from Andhra and Hyderabad, Telangana to Chhattisgarh, they were not allowed to see the dead bodies also. But in fact, NHRC has given it detailed guidelines and tradition for centuries together, how to respect the dead bodies. Each religion has its own practices are there that is being denied. Of course, obviously, this is the reason why they may be outlawed persons, but law will not be applicable to any person died. Here, I only can say one reason why they have cremated the bodies without even showing them even for once. Because dead body speaks no lies, is what we all know. If they are allowed to see by the near and dear, they may bring the torture marks, or so they want, they may go for a repostmortem and they may bring the real facts. So the entire story by the police will be defeated. That's the reason why they are not even allowed to show to give the dead bodies, handovering them, or to even to have a last glance. So that is how here, when we are speaking about the dignity at various aspects, this is also one of the issue which I would like to bring to your notice. In such cases, our legal intervention, we got the order, but that is basing on the statement of the Advocate General, when it is not also respected by the Chhattisgarh government. And when we file the contempt case, interestingly, contempt is closed, saying that we have no power. In fact, for writ petition, he has jurisdiction to deny us to go and approach the High Court of Chhattisgarh. But he cannot do so in a contempt. Having passed an order, you have to either implement the order or call for the explanation why the order is not implemented. But without doing all this, the case is, in fact, closed there. And we are, of course, we are trying our, we are taking this to Supreme Court level. And with this, I think now the time seems over. I want to share so many other cases also, but these are some of the aspects as lawyers, when we approach and deal these cases, the real facts, the real way of institutional responses we can see at the police station level, at the court level. All these are all the factors who are the actors who are coming in way of disrespecting or denying the dignity of the persons, where we have to fight. Of course, we are fighting. In some of the cases, we are getting orders. In some of cases, we are still fighting. And this kind of interventions will make all of you to know these are the acts, these are the interventions what we have to make. And as a human rights lawyer or a civil rights lawyer, what one has to do, go on fighting. And believing that tomorrow we'll get a favorable order. These comments I'll come to.
I'm sorry, I'm in the unenviable position of having to stop people who have much to say and much experience to share. And I hope that you will share it over lunch. How far over time are we so that we can take questions? Or, and of course, Judge Nanda is even more disadvantaged because there's no riposte that he can supply. Vasanthi, I'm looking at you because you've been glaring at me. Okay, ladies and gentlemen, it depends on how devoted you are to lunch. My colleagues are here. They have much gyan to give you. I will abjure making any remarks except to say that when we are asking, please ask for clarifications at lunch. But right now, does anybody have any suggestions, including my panelists, one suggestion each in 2 lines? How do we ensure that honoring dignity as a habit in the courtroom, in the subordinate courts, how do we extend that habit and make it a space where dignity is respected because procedure is respected? You have given me the problem, many of you with examples, etc., but not the solution. And perhaps someone here of us can bring forward at least short-term solutions. For myself, I will quickly say, I think that the lack of training or the lack of speaking about dignity at the outset, I think is a fundamental flaw in how we are bringing forth judges to come and be, I hate the word sensitization. I don't think anybody needs to be sensitized. That's for their mothers to do. What you have to do is just follow the law. So anybody, please, and my colleagues, of course, on the panel. You've got 10 minutes, quick words. I've been told we've got less time than I said because there's something happening that should not be delayed or curtailed. I can see lunch is winning.
Yeah. Okay, I just wanted to, I'll conclude with this, that sensitization, of course, I won't use the word, but what I'm suggesting is that the high courts across the country should develop a standard operating procedure, SOP, as to how courts should be conducted. There is a glaring gap. There is no guidance as to how a judge should conduct the court. There is no, I mean, if the accused is coming, standing, sitting, there is no rule as to whether he should be standing, whether he should be provided a seat or thing. So it all has to come from the high courts as supervising authorities for all the trial courts, saying that this is the set, these are the set of guidelines that each trial court must follow. That has to be drafted and that has to be circulated, and then judges have to be trained as to how that should be done, so that they start following a new procedure as to how they meet the accused or even the victim or the witnesses, etc. So I think that institutionalization of that dignified practices has to be brought into the system, not just by training the judges from the outside, is what I believe.
Thank you. That's a very practical suggestion. Judge Nanda?
Yes, I want to make, in addition to that, and maybe I partially disagree with that. When I want to ask a question at the beginning that whether the court at the ground level should be executing court or independent. While there can be no replacement of the High Court being the superintendents, and in Odisha we have seen how during the Chief Justice of Justice Muralidhar, we could see the transformation that in fact yielded result. And and to address your question also, when we talk about independence or impartiality from the perspective of the judge, are we talking about a judge being an umpire in a cricket match, or we should cultivate bias, I mean constitutional bias, in terms of, for example, setting the cause list when we equate the cause list of a domestic violence case or a case pending for maintenance with any other case, the timing, the delay I think the independently the constitutional ISM of it or constitutional bias is more important than understanding the earlier notion of just an umpire sitting as a yes, if I could comment.
Thank you.
Maya?
Just to say, because you might not have heard that Judge Nanda says that we talk about independence, but are we just to be umpires looking at the facts of the case, or are we to have a bias that is toward the constitution? That's how I understood it. It also occurred to me that the same SOP that Judge Asadullah talked about how to conduct the court might also provide us an opportunity to ask the high courts to have an SOP on how to supervise lower courts, because that too is full of contradictions. Yeah.
When the institutions are not addressing, then only litigants come to court expecting a judicial wisdom will be exhibited by them. But instead of in their orders, when they are approaching for an order solution, they are passing orders, consider the case with the law that is invoked. Like these orders will never get the real solution, because when we are asking to exercise the judicial discretion approaching the courts, they are again putting it back to the executive's discretion. So what a judge has to do is, a judge has to judge. You reject, you refuse, or you dismiss the case. But do not pass this kind of orders. We experience when I approach a court for a jail manual, the same kind of order is passed. No, we did not get any jail manual, Telugu translated jail manual. Like the case, encounter case, the order passed by the judge is of no use when he has not taken the contempt proceedings. To at least to some extent, to get the explanation from the authorities, no less than Advocate General. It is the government speaking before the court. So that's how the judge has to judge.
And without accountability, you're never going to incentivize duty holders to do what they're supposed to do. Murli, did you have, Murli, one sentence, because the lady there is glaring at me.
Yes. See, I only want to say what Nanda is saying. You seem to be saying, despite Article 50 about the independence of judiciary, in practice, it seems that the lower judiciary doesn't have any independence from the executive. He's giving 3-4 examples. Until 1977, when CRPC was written, the lower judiciary was reporting to district magistrate, who was also the head of the police. 1. 2, even today, it is the SHO who has to write the complaint, but not an independent authority who can give a complaint. Which means, and also he says it is the SP who is permitting what kind of charge sheet has to be filed. His conclusion is, these are the colonial methods of controlling the prosecution, which is still being followed in practice. Therefore, it is not faithful to the principles of Constitution, where judiciary has to be independent of executive. This is the crux of what he has said.
Thank you. That's very helpful and also very courteous to Judge Nanda. Thank you. Ladies and gentlemen, I have moderated this session extremely badly, for which I apologize, but you can make up by cursing me at lunch. Thank you.
Hello, really sorry for cutting off on the questions. It's just that the next segment is, we have some young scholars presenting their papers on dignity law, and we couldn't push that session. That's why we're really sorry. And sorry to Maya ma'am as well for forcing you to finish so early. We'll go for a lunch break and come back by 2:40. Thank you.
Good evening, everyone. My name is Satya Prasoon. I am an assistant professor at NALSAR University of Law. I welcome you all to the final and the concluding session of the conference. I welcome all the presenters to whose abstracts I have the chance to read, and they are all coming from very riveting and different angles. So I'm thinking that this final session is an apt conclusion to understand the construct of identity and its application to disadvantaged and marginalized identities in the Indian public realm. The common thread, although these papers can stand on their own or can stand on their own limbs independently, but the common thread running through it that they speak about marginalized identities, some ascriptive, some historically marginalized, some systematically marginalized, who have been at the receiving end of the power discourse. So we have 6 presenters who are coming from different vantages and are important stakeholders. One of whom is an academic, one is a practitioner, one is a policy shaper, one is a doctoral student, and one recent graduate and one currently undergraduate student from NALSA. So I'll quickly lay down the themes of the paper. 2 papers deal with the question of tribal identity and the application or the misconstruction of understanding this tribal identity through Indian laws. One is a dignity affirming exploration, and another one critiques the non-identification of tribal identity through a dignity stripping perspective. One paper will interrogate this structural indignity framework heaped on people with cognitive disabilities and their consequent erasure from right to political participation. From marginalized and ascriptive identities, we will then segue into the construction of labor identity, where there is non-recognition of right to disconnect in labor laws and the implication it has for dignity discourse. Then the next presenter will speak about the stereotypical and the prejudicial effect of oral observation by judges from the bench, and what role, how is it that we can capture, or what does it say about our legal culture when these observations, which don't register themselves in form of judgments, these have a discriminatory and indignified impact on the litigants. So that is an interesting paper that will speak about the non-registration of some of these judicial practices, and how can we capture that in the dignity discourse. And after that, we will conclude by a presentation that looks at philosophical roots of dignity. I think it can be seen in succession to Professor Preetham's paper, where he's trying to locate dignity. So this paper also tries to understand the philosophical roots of dignity and tries to map the decisions of the Indian court to one of these schools. Now, there is a slight change in the format for these sessions, as the papers can stand independently. So each presenter will be given 15 minutes to present, with 5 minutes for question and answer. So with that, we'll start with the presentations. We'll start first with a presentation by Assistant Professor Ezekiel Jariam, who is an assistant professor at the Faculty of Law, Delhi University. Then we'll move to 2 online presentations, one by Abhisha Isaac from Isaac Chambers Law Firm. The next one will be by Mr. Shashank Pandey, who is a research fellow at Vidhi Center for Legal Policy. And next, we will have our own NALSAR student, Shetrangna, who will be presenting on tribal identity, and Robin Jaswal, who is a doctoral student at NALSAR. And the final presentation will be by Mr. Abhineet Maurya, who is a recent graduate of NLU Delhi. So with that, I invite Professor Ezekiel to start with his presentation. 15 minutes is a time for the presentation. Thank you.
A very good afternoon to everyone. It's a privilege for me to be here. It's my first time, and hopefully it's not to be the last time. It depends on how you rate me as a presenter. Okay. Well, my topic is a very long title. Maybe I can summarize. I mean, I can make it a little shorter later, but the significance of coexistence of customary and state laws in upholding the dignity of tribal people. A brief study of the justice system under the 6th schedule in Meghalaya. I just want to begin by mentioning a brief facts about Meghalaya. Okay, one of the 8 states. Meghalaya is the abode of clouds. Yeah. Let me just use here. I think that's I could see it. Yeah, one of the 8 states of the Northeast. That it means the abode of cloud. It means that's Meghalaya. A few facts about Meghalaya before I touched on the points that I will cover. Meghalaya was, of course, became a state in 1971. The entire state actually falls under the 6th schedule. That is the topic on which I'll be touching on, linking with the dignity of tribal people in Meghalaya specifically. It has 12 administrative units, districts, which in these administrative districts, we have regular courts, since I'll be touching on the judicial system. So I thought I should make it clear to you that there are, like, say, 2 sets of judicial system. We have the regular courts where the Code of Civil Procedure, CPC, and BNSS are, of course, being followed. But then you have also the other sets of judicial system that falls under the precisely under the 6th schedule. So from the point of view of the 6th schedule, the state is being divided into 3 autonomous districts. Okay? So you have 12 administrative districts with regular courts, and then you have 3 autonomous districts with its own judicial system, where CPC and BNSS are not followed strictly, but in spirit. Okay, they have their own rules of administration. Anyway, the points that I'll cover here is, of course, just a few pointers about the decision schedule of the Constitution is an instrument to protect the tribal identity. And of course, I will try to link this with, of course, with identity, sorry, with dignity. A brief study of the judicial system as outlined under the 6th schedule with a focus in the courts in Meghalaya. Analysis of a case decided by a district council court, which is the apex court in the judicial system or under the 6th schedule. And then, of course, through this, my point is to highlight the importance of the coexistence of customary and state laws for the tribal people of Meghalaya, a judicial system that takes into consideration the tribal ways of life helps to protect their social identity. I would like to refer to the brief discussions, debates relating to the, so when the Constituent Assembly was debating on the 6th schedule, Dr. Ambedkar, I'd just like to highlight here, let's say, one of the reasons as to why he supported the idea that some level of autonomy should be granted to the people, to the tribal people in the Northeast. Basically saying that, okay, their laws of inheritance, the laws of marriage, customs, and so on are quite different from those of the Hindus, saying that, referring to the, precisely to the, let's say to the Assamese, rather the non-tribals who are mostly, let's say, are following the Hindu religions. Reverend J.J.M. Nichols Roy, one of the members of the Northeast Frontier, basically the subcommittee for drafting of the subcommittee under the fundamental rights, which during, again, this for the drafting of the Constitution, he made this observation as to why some level of autonomy should be granted. He says that it will create, of course, a feeling of friendliness and unity, that certain measure of self-government should be granted so that they may develop themselves according to their own genius and culture. Anyway, we have then, of course, the constitutional provisions, Article 244, Clause 2, which says that the provisions of the 6th schedule shall apply to the administration of the tribal areas in the states of Assam, Meghalaya, forgot the comma, okay, Tripura, and Mizoram. Okay. So the 6th schedule applies basically to these 4 states. Now, the 6th schedule, Para 3, talks about the legislative powers that are being granted on. So I mentioned at the beginning that there are 3. I'll of course restrict myself to Meghalaya. Meghalaya has 3 autonomous districts. Each autonomous district has a district council, which is a legislative body, which enacts laws, and this is precisely Para 3 of the 6th schedule, and talks about the legislative power of the district council, that it can make laws on these subjects like allotment of land, succession, inheritance, etc. Para 4 specifically talks about the administration of justice, which wherein it's here then that I mentioned at the beginning again that courts constituted under the 6th schedule, they have exclusive jurisdictions in disputes, or rather in cases between tribals, which I will elaborate later. Judicial system under 6th schedule with a focus on the courts in Meghalaya. So I'm here now coming to the basic structure, explanation about the judicial system within the 6th schedule. So basically they are being structured into 3 levels. You have the village courts, then you have the subordinate district council courts, and then of course at the top you have the district council court. A case of a decision of which I'll be discussing in highlighting this aspect as to how the coexistence between customary and state laws actually helps in upholding the protecting the dignity of the tribal people. Well, I have just simply here put in a few cases that was dealt with by the Supreme Court in interpretation, clarifications of the jurisdiction of the district council courts, which basically the bottom line is that in any disputes, in any here both civil and criminal, okay, where let's say that between a dispute, a legal dispute between 2 tribals, let's say in Khasi Hills, one of the districts, in the Khasi Hills autonomous districts, it's the either the district council court or the subordinate court, of course, of the courts under the 6th schedule, which will have jurisdiction to actually entertain that that case, and not the regular courts, where I had mentioned that the regular courts, meaning that CPC and CRPC are being followed. But in these courts, the CPC and CRPC, BNSS, okay, are not being followed strictly, but then they are being followed, let's say, in terms of spirits. The procedures. So just to have a little better clarification as to then which procedural law is actually governing these court system. So we have here again as a sample. So we have the Khasi, of course, Khasi Hills Autonomous District. Sorry, I missed the hills. Okay, Khasi Hills. Okay, and then you have the Garo Hills and then the Jantia Hills. I'm just taking here the procedural law which is applicable to the Khasi Hills, which more or less they are similar, practically the same as those of the other autonomous districts. So it's this particular rules which is being framed by the district council, which is the legislative body that is applicable in the code procedures of these codes. So I have mentioned there just these two provisions, Rule 43 and 47. They say that in criminal and civil cases, procedure of these codes basically constituted under the 6th schedule, shall be in spirit of BNSS, RPC earlier, and CPC. And further, it says that in all civil matters before these codes, adjudication was to be done per law, justice, equity, and good conscience. Though formally, of course, these procedures, I'm talking about the CPC and BNSS, are not being followed strictly. But in my recent survey, in my recent research, talking to senior advocates of 10 years plus of experience of litigations, when I put one or two questions as to what is the extent that these procedures have been actually adopted by these courts, most of them, they have put it that it has been adopted, significantly. That is about, I put in terms of numbers, precisely between 70 to 80, more or less. That these courts even actually follow to that extent these other procedures. Of course, in 2022. CRPC, now the BNSS, was actually made applicable to the whole state of Meghalaya for the first time, okay? But there is in that notification for application of BNSS to the state of Meghalaya, there is a para which precisely says that the district council codes shall continue to derive powers under paragraphs 4, supposed to be 5, sorry, of the 6th schedule of the Constitution of India. Meaning that, of course, that aspect of that this code for these codes under the 6th schedule should follow their own procedures is still, of course, valid.
Professor, last 2 minutes.
Just 2 minutes. Okay, thank you. Quickly, I'll just highlight you about this case. I mentioned that a decision where the district council courts basically had to deal with a situation where relating to the grant of successions. So it was here the petitioner and Mr. X basically got married in the year 1988, so 87, and it was basically the marriage that was solemnized. Then during the lifetime of Mr. X, during the subsistence of his first marriage, he married a second wife, and in fact, married here, in fact, I have highlighted the word cohabited. So they cohabited and lived together and had children, and in fact, he died in 2017 while staying with the second wife. Now, the dilemma before the court, of course, was that when the suit was filed for the grant of succession certificate, of course, the petitioner, the first wife, claimed, of course, she's the rightful heir. The respondent, on the other hand, as well, claimed that she was, the rightful heir because that her late husband died. She was the one who was taking care of him, and that, of course, that he lived with after he separated from the first wife. He had been living with her throughout till his death. Okay, so therefore, basically, issues of frame. I have touched on just 3. Whether the petitioner is the wife of the deceased, talking about Mr. X here, with whom did the deceased live, that is Mr. X, and cohabited together as husband and wife at the time of his death? If so, who bore the expenditure for performing the last rites of his dead body? who is legally entitled? Now the question is, who is legally entitled to inherit the debts and securities left behind by the deceased? Now, of course, here, the fact that, okay, the petitioner was declared, yes, she's the legally wedded wife because the marriage was never dissolved. This, to the second question here, of course, also the court answered in favor of the respondent that she was the one with whom Mr. X, the deceased, lived. Okay, so therefore, to the answer to the third question now. Okay, who should be actually the one the rightful legal heir to this? So just to mention that in the Khasi society to which I belong to, it's very common. It's like a customary law and practices that somehow when a couple, they live together, they cohabited, they are actually recognized as husband and wife, though officially it was never solemnized. So it's not a live-in relationship as we would say, but it has been always recognized as actually as a marriage. When they themselves, they would acknowledge to the relatives that we have lived as husband and wife. Anyway, the point is here, then the court said that, of course, both of them, they are entitled to inheritance, to succeed to the debts and securities left behind by the deceased. For the second wife, of course, the court had mentioned the fact that, okay, she is entitled based on customary law, customary practices. Okay, so in that sense, and okay, it may appear to be like a conflict of, let's say, in the context of state law to say, okay, if you go strictly, only the first wife is the legally wedded wife, is the one who should be inheriting everything. But somehow the court has actually invoked customary law practices to say that even the second wife, even the respondent was actually a wife. So in that sense, they were equally entitled to inherit the property. Anyway, I think that I'm already overshot.
Yeah. Thank you very much for your presentation. The paper looked at an instance of legal pluralism when it comes to understanding the Khasi identity. And now I open the floor for questions. Please keep your questions short. We have 4 minutes for questions. So in the meanwhile, I'll take the liberty of asking the first question. So we understand that in these district courts, there is preference of customs and there is a codification of Khasi customs. I would want to know from you, from an experiential standpoint, that to what extent does this codification take into account that the codification is not majoritarian, and it also takes into account the customs and the concerns of marginalized identity within this minority, which are the voices of the women and the voices of, say, other religious groups? Or what is the codification force for this? How democratic it is?
Thank you for that question. So it's not district code, district council code.
District council.
Yeah, so because if you say district code, then you mix up with the other, which is the regular code. Anyway, thank you for that. At least I just want to mention here, of course, another aspect, for lack of time, I couldn't mention in a way indirectly answering your questions, that in the context of law of maintenance, we say, under CRPC or BNNS, okay? So what happened in the past at least, the very few wives, let's put it like that, or women, would come forward to actually seek maintenance from their husbands. So it so happened that either the husband would just leave, desert the wives, and they never come forward. But these days, they more and more they actually let's say using the state law. But then the question is, their marriage actually it was never solemnized, or so it's the on customary law, it was neither, let's say, okay, so majority are Christians. Not that even they have got married under Christian Marriage Act or under Special Act. So marriage is basically under customary law. So in a way, then okay, the interplay of customary law and the state law coming to the, of course, to the in a way to the help of of those wives who actually seek for maintenance. In fact, many of the customary laws that have been codified. For example, customary laws relating to succession of what we call these traditional chiefs. Now you have the village headman or the sirdars we call, where the customary law for succession or the election have been actually codified, and then in terms of inheritance, and then in terms of lineage. So many of these customary laws actually now have been codified, and in a way, yes, it has helped to bring clarity in that sense. Though there is always an argument to say that okay, customary law is supposed to be dynamic. Once you codify, then it stops growing. But anyway, at least it has helped in many aspects, and particularly relating to maintenance, relating to, of course, I would say in the context of domestic violence. It has also a case that, of course, guardianship. These are the aspects that also it has it has helped quite a bit.
Thank you for your presentation and your comments.
Thank you very much.
Hello. My question was, is there an option for a person belonging to that particular tribe to opt out of these customary laws and decide that he would be governed by the normal state laws? In the sense that when we talk about dignity, that requires that a person should have individual agency to decide whether those laws should be applicable. So can a person belonging to this tribe decide that no, he will be governed by the normal laws and he does not want to be governed by the customary laws in these matters?
That's an interesting question, actually, because what happened? I mean, generally, for example, in criminal cases, because the cases, they do not go directly to these courts. They go to the regular courts, and then the regular courts, sumoto, they transfer to the district council courts. Now, okay, it could be that, yes, they can apply to say, no, because I don't want that I should be prosecuted there. So they can of course, make an application to the court but generally what happened when it is between tribals, in most cases, okay, I say most cases, not all, okay, they generally go to the district council courts if they have the jurisdiction. Yeah, but the only option is to actually apply to higher courts to transfer either the case from the district council courts to the regular courts. That can happen either for maybe for bias or for for reason that they think that okay, it's too far, because there are only three. There are only, let's say, there are only three autonomous districts and then 3 district council courts. But the regular courts, there is a regular court in every district. So it could be that because of distance, because of some other, then they may prefer that they be prosecuted or they go to the regular courts instead. I hope that's it. Yeah.
Thank you.
Yeah.
We'll move on to the next presentation. The next presentation is by Ms. Abhisha Isaac, who is a partner at Isaac Law Chambers, Mumbai. Her paper is titled Dignity in the Courtroom, a discourse on reinforcing verbal restraint and judicious dialogue in court proceedings. I now invite Ms. Abhisha to start with her presentation.
A very good afternoon to all of you, esteemed members of the panel, and to all the entire gathering there. Unfortunately, I'm not able to join all of you physically, but I deem it a great privilege to, at least be able to present it online. I must thank the conference team for giving me this opportunity. So I have a short presentation to make, just a couple of slides to show, but I'll be mostly doing the talking. Yes. I think I need permission to share screen because it's not permitting me saying I need permission of the host. Is somebody gonna? Yes, thank you. Can all of you see the presentation? Can I just get a confirmation, please? Yes?
Yes, but I think, yes, it's visible now.
All right. Thank you
Cool.
so much, sir. Yes, so I'm an advocate practicing in the High Court of Madras, and Isaac Chambers Law Firm is based in Chennai and Madurai. So the reason I chose this topic for discussion in this forum is that this is a topic which is rarely spoken about, although this is something lawyers and litigants face on a daily basis. Now, what happens is the higher courts, especially the High Court and the High Courts and the Supreme Court, have the power to punish for contempt of the court, for any act or action or even an oral remark that might in some way affect the dignity and majesty of the court. But what happens in the case of litigants and lawyers? And as all of you know, now we are living in an era where every single word that is uttered, especially in important benches of the High Courts and the Supreme Court, is being reported, and mostly in an irresponsible manner because it is sensation for the people out there. But what happens to the litigant in the court, and often to the lawyers who step into the shoes of the litigants as well? So, the premise on which this paper is based is that dignity is not just a substantive right, but a procedural right as well. And by procedure, it is not just restricted to what is recorded as procedure in the verdict or in the judgment or what happens during trial, such as, audio alterum partem, things like that. It is a very alive one, which has to be respected and protected, even in courtroom discourse. That is the crux of this paper, and I will go on to show why it matters and why it is important with a couple of examples of my own experiences as well. So, why courtroom decorum is important and how it is connected to dignity. Just two academic literatures which I have relied upon: 2018 research of judicial demeanor and legitimacy. Although it happened in a different jurisdiction, the findings found, the study found that litigants read courtesy as a proxy for impartiality, and that there's a direct correlation between calm, inclusive language and declared confidence in the verdict. And a 2010 socio-legal research where thousands of Australian court hearings were observed found that even fleeting displays of impatience, including even sighs, raised eyebrows, jokes, altered litigants' belief that the hearing was fair and personally dignifying. Now, these might be, actual research studies that happen, but out of experience, I'm sure all of us who are practicing before the courts can vouch for it. In fact, a very recent episode, what happened in one of the cases in which I appeared, there was a government service employee who was at the verge of retirement. And right when he was about to turn 62, a punitive transfer order is passed. All of you might know that a punitive transfer is transfer, which is basically a punishment for some alleged disciplinary issue. But even before an inquiry is done, a transfer order is just passed by way of punishment, and courts have time and again held that punitive transfers have to be set aside. They are not sustainable. Now, what happened? This matter came before the learned judge, And the learned judge, without even reading the papers, just makes some oral remarks saying that we know what these fellows do out there, we know what these fellows are. And in fact, the real situation was that the person even had an aged mother who he had to take care of, who was obviously much older, and he was already a widower as well. So, unmindful of all that, this litigant was present in court and he was already with folded hands, because at the verge of retirement, he was being transferred to a place that was literally 500 kilometers away. And the learned judge just went on to make very castigating remarks, saying that he was in the minibus sector, the government bus transport sector, and made very castigating. We know how they collect money. We know what kind of corruption happens right and left. But all these were just oral remarks. And finally, what was recorded in the judgment was that we find no merit in this petition, so and so the writ petition is dismissed. Now, by the time the hearing got over, this man was literally out in tears, saying that I came to court thinking that somebody would hear me, something will happen, and all that I have got is even a worse situation. I have ended up in a worse situation because of this. And this might seem a regular event in court for us every other day. And in fact, in moot court, we are trained to deal with very tough judges. Now that I think about it, in law school, the toughest of judges were called so that, the lawyers get grilled well enough, the participants get grilled well enough and get prepared for court. But what are we not seeing in this? The larger outcome. We are not seeing that these remarks lead to stigmatization. One is affecting individuals' reputation, which is dignity itself. In fact, in one of the judgments in 2014, the Supreme Court said, speaking from the words of Justice Deepak Mishra, reputation is a nobility in itself for which a conscientious man would never barter it with all the tea of China or for all the matter of the pearls of the sea. When a court deals with a matter that has something likely to affect a person's reputation, the normative principles of law ought to be cautiously and carefully adhered to. Now, this might be just another case for a judge, but this is the man's entire life standing right before him. And to him, at the end of the day, he comes to court for justice. And somebody sitting in a position of power just casually makes these remarks. Will he ever, after that, trust the justice system, or will he even, when his colleagues or somebody else aggrieved says, I go to court, what will be the response? This is an actual systemic issue, because as I will go on to say, India does not have any checks except where the courts by itself can, take suo motu cognizance. Only the higher courts, especially if the matter gets reported far and wide. So it causes stigmatization, where especially affected minority groups such as, for example, religious minorities or women especially, I will just quote a couple of examples, can get stigmatized in a very tangible manner through remarks in court. And second is process-based harm, which adds basically to the emotional cost of coming to court, which is already much prevalent, let alone the financial cost of it. So process-based harm is another issue where public perception matters. And all of us know from the research works of Jeremy Waldron, right from Jeremy Waldron to the very recent ones, that public perception and legitimacy is needed for the courts and the judicial system to function as it is currently doing. So this is a process-based harm as well, adding to the already difficult process for a common man to approach the judicial system. And third one, of course, precedential diffusion, because more than the written verdicts and judgments which get published a couple of days later, judges' remarks in court, the discourse, the injudicious verbal talks and dialogue that they have with the lawyer and the litigant standing there, it does have an impact, because as all of you know, we get especially the junior judges sitting in the same court, once it is known through the words of a judge that this is what his thought process is, this is how it is going to be, it is not the understanding, the stigmatization doesn't just diffuse through the written judgment, but through the spoken word as well. So that is how it affects from my study through three ways of stigmatization, process-based harm, and precedential diffusion. Now, what can be done about it? I just want to highlight two other jurisdictions and see what the situation in India is. Now, in US, we have the Judicial Conduct and Disability Act of 1980, where every remark of the judge, every intemperate comment or any biased remarks or prejudices, if it occurs, can be complained against. They have a particular system where, first it is taken to the staff, of course, a complaint is filed, then it is taken to the circuit chief judge, and from there it goes to a committee and then a council, and finally it has a 6-tier system. In India, there's nothing like that at all, except, as all of you know, an in-house procedure, which we recently saw in certain episodes, though they were not really for oral remarks, but for certain other acts. I will give you a good example in the US. In 2020, in the Trump versus Biden case, which was live streamed publicly, the sitting judge made certain remarks stating that, okay, this is pure racism. You are doing this just to keep your king in power, alluding it to you know who. This was taken cognizance of. There was a 20-month confidential probe done on the judge for this remark, just these 2 lines. Report was filed and a private warning was given at the end, but the judge was good enough and she just published it publicly as well to show that all of this has to be respected. Another case was when a particular judge yelled at a lawyer with an unparliamentary word, and that was complained against, and corrective measures were immediately asked to be done, where there was compulsory training on ethics and courtroom conduct. Now, all this might be, too far-fetched and too far away for Indian system in the practical sense, but still, especially in the live streaming era, and where court reportage happens on a daily basis with all these fancy thumbnails and fancy headlines, it is time that we also bring in certain systems, whether it can be even inside the court, where something is done. In fact, I would just like to quote 2 recent incidents in the Indian judiciary which created a lot of furore. One was a recent episode of the Karnataka High Court judge, where he openly said, when a lady lawyer was trying to answer a question that was addressed to a male lawyer, he said, oh, you seem to know everything. Perhaps tomorrow morning, if I ask you, you will even know what undergarment he is wearing. So imagine the plight of the litigant standing there. They are seeing that a lawyer is disrespected in this way, in such a manner by the sitting judge there. So he or she will know, one, it affects the lawyer's livelihood. The public will immediately form an impression that, okay, if this is how this lawyer is going to be treated, then probably the lawyer is worth only so much. Second, what will the common public think about what is happening in the court? And if a lawyer himself or herself is not respected, how will any layman with nothing, no means, no resources, what will be his plight? That will be the thinking. And in this incident, what happened is the Supreme Court, of course, took suo motu cognizance for such sexist remarks. And public apology was, of course, done, and the matter ended there. Another incident was that of a former Chief Justice of India itself, which I know all of you might have definitely heard, where he asked an accused rapist to marry the victim. And in fact, in that case, it was a matter of record that that girl was stalked for a long time. She was tied up, gagged, and repeatedly raped. And a casual remark is just made. So are you willing to marry the girl? And the very same judge in another case said that, what is wrong with marital rape? How can we stop it? The man might be just brutal at times. These were the exact words. I'm just quoting the extract. The
Ms.
husband,
Usha, last 1 minute. Please
yes,
continue.
the husband may be a brutal man, but can you call the act of sexual intercourse between a lawfully wedded man and wife as rape? So all these have far-reaching repercussions. So I don't want to go into the other aspects. I just want to end with one thing. What can be done? I have just 3 suggestions for that, finally. One is having some sort of a conduct commission, like I said, which is prevalent in the US, UK, and Singapore, other jurisdictions, where the number of complaints are even displayed to the public in the website, and the verdicts. I can even later share a couple of them, where everything is given importance. Courtroom decorum is given the utmost importance. So some sort of judicial commission where our judges at the end of the day are humans, and it is silly for the courts to just assume that once you become a judge, automatically and magically you become a very good person, leaving aside your past. There's no sort of formal training at all to judges. So the second suggestion would be some way of continuous professional development, because in jurisdictions like UK, they have the Judicial College, where it is mandatory to attend a certain number of class hours on ethics in the courtroom, decorum in the courtroom. And in fact, in Singapore, an interesting module was started in the judicial training classes called as Judicial Dignity and Courtroom Decorum and Managing Difficult Litigants. Now, these are very mandatory ones, not optional ones like how we have in India. In India, we just have the National Judicial Academy where nobody is forced to. And for the lower court judges, it is even worse. And in fact, recently, the Supreme Court Chief Justice bench said that at least 3 years, one should be practicing as a lawyer to become a civil judge. And it created so much furore. We in the court, as practicing the high courts, we were all talking that, somebody finally did it. If somebody has no practice at all, how can you just assume immediately after law school that they will uphold the dignity of the court, they will know how to conduct cases, so on and so forth? It is not just any other executive or administrative body. This is the court. This is the nerve center of the entire, the fundamental rights of the citizens. So these two suggestions, and apart from that, a practical suggestion. We call ourselves courts of record, the high courts of India and the Supreme Court. Courts of record basically mean that our judgments are considered as conclusive evidence of themselves. But more than the written one, it is the oral remarks that affect people on a daily basis. The written ones are just consolidated versions in most cases, except in constitutional law matters or other appeals. So some sort of transcript. In Singapore, when we went and saw, all courts had a live transcript system where every word the judge utters is displayed live in the court hall, so that
Thank you, Advocate Avisha. Probably
Thank
we'll
you.
unpack some of these threads in the question and answer
Thank
session.
you so much.
Thank
Thank
you.
you for this opportunity. Thank you. Yeah.
So thank you for foregrounding the stigmatizing effect of oral observations, which generally goes unnoticed and is not something that can be appealed against, because judgments can be appealed against. But how do we account for the effect of oral observations? And it is a very important issue, because even the Supreme Court last year brought out the handbook on stereotyping, where it sought to attack this culture of using certain words which has a wrongful stereotyping effect, which the lawyers as well as the judges should never use. So with that, I now open the floor to questions. Yes, Saksha, please go ahead.
Hello, am I audible?
Yes, yes.
So I had two questions. You clearly
Please keep it to one, because we have 5 minutes.
two part of one question.
Please carry on.
So you clearly problematize the whole problem. What are the consequences that should follow for a high court judge or a Supreme Court judge if such observations are made? You provided a mechanism of how they should not make, but if they do indeed make, how should the same be tackled and what should the consequences of the judge should be? And secondly, in tandem to this, is that there's an established precedent that judiciary cannot violate fundamental rights, at least in its orders. So should there be a differentiating position as to say that can observations then be treated separately from the orders themselves, and if 21 reputational damages are made, then something of such sort should be then taken up by the appropriate forum, that is the High Court or the Supreme Court? So thank you.
Thank you so much for the questions. Yeah. See, that is why for the first question, with respect to what can be the possible procedure, to tide over the situation, we have other common law jurisdictions around us. The best I can say is Singapore, although by population there's a vast difference and burden of cases is much higher for Indian courts. Some sort of rigid in-house procedure, because on the one hand we have to balance the independence of the judiciary and on the other hand the litigants' right as well. At least the websites of the court can have some mechanism, like how we can register complaints with respect to other things if a sexist remark is made. or if some unwarranted comment is made, both for the lawyer and the litigant. Some way to register a complaint whereby an in-house procedure is set in place, like how we have the posh sexual harassment committees, like in for other industries and regular workplaces, some in-house committee which can have, you know, appeals mechanism, all of that as well. So the litigants will at least know, okay, there is some redressal for this. A judge cannot just like that say anything that he feels like an escape from that. An in-house procedure, it can have multiple levels, and in worst case scenarios, I can quote the example of one of the judges, I forget which high court, where skin to skin contact, she said, alone constitutes POCSO offense. That created a major issue, and she was removed as a permanent judge. She was just an additional judge at that time, and the Supreme Court committee at the final level of probe said that, you know, you have to be removed. But all these are for only written verdicts and judgments. For oral remarks, there is no system, and the US is the best example because their Judicial Disability Act cites biased remarks, intemperate comments, racial remarks, all of that as reasons for complaint. So that is to answer your first question, some in-house procedure. And with respect to the second question, what was that exactly with respect to reputation you were asking?
Question was about compensatory mechanism for reputational damage suffered because of oral observations by judges.
Yeah, so basically oral observations do not form a part of the written verdict or judgment. That is the main issue at all. We don't even have stenographers in our court, except in criminal matters where evidence is recorded. There is no live transcript system. Supreme Court in 2023 came up with a live transcript system for constitutional benches alone. But since then, 25 constitutional benches were constituted, only 9 transcripts are available, published in the website. So some, at least if the judges, you know, feel like, okay, everything that I say is just coming alive on the screen or somebody is recording it, that can be some sort of restraint. Here, it's like the jungle. You are the king, and even judges have acknowledged in their judgments, the judicial seat is a seat of power. And once you sit up at the bench, everybody, you know, it's the human mind, it's natural. The researchers on psychology, all of that show that positions of power can lead to a lot of irresponsibility. So some real-time live transcripting or a regular continuous professional development course on judicial decorum, all that will definitely help. Yes.
Thank you.
Thank you so much.
I think tentatively, I'm also thinking that what could be the remedy. Maybe if the court can try and think about how to differentiate, if this kind of stigmatization can be concretized into a bias, a personal bias against the litigants, and can be seen as a violation of natural justice. So maybe that can be one framework, rather where they can ask the judge for recusal on a ground of that. How is it that this kind of stereotyping, when done institutionally, has become biased?
Correct.
Yeah. With that, we stop here and we move on to the next presentation by Mr. Shashank Pandey from Vidhi Center for Legal Policy. His paper is titled Dignity Denied, Benevolent Ableism, Political Rights, and the Constitutional Exclusion of Persons with Disabilities in India.
Hi, am I audible?
Yes, you're audible.
Yes, good afternoon to the esteemed panelists. And on the onset, I would just like to express my apologies for not being able to attend the conference in person. And also, just another disclaimer that because I often use screen reader, so if there is any interruption between by my screen reader, so please excuse that. So I don't have a presentation, so I'll be focusing on the pointers that I've made. I'll try to be brief, try to be within my time span. So I'll start with, before going into the academic part and the more legal doctrine aspect of why the dignity denied is an aspect for persons with disabilities in general and persons with psychosocial and cognitive disability in particular. I would rather like to underline the significance of the subject matter from a more policy and political perspective, because that underlines why there was a need for such doctrinal research, or why there was a need for such academic deliberation. And there are few instances that I would like to quote. beginning with the foremost, which is the invisibilization of the disability during the deliberation of backwardness during our constituent assembly debate. Because when our lawmaker, the constituent makers were deliberating upon the aspect of backwardness, with Dr. Ambedkar at the helm of it, many identities, sub-identities, and even intersection identities were pointed. Unfortunately, disability was something which wasn't there in their deliberation of what would constitute a backwardness, and hence the obvious outcome of that is that we see that there is no mention of disability in the entire fundamental right part of it, apart from just one article within the DPSP. Especially, there is no mention under Article 15 or 16, wherein identities are mentioned. So that's one thing. The second thing that happened, because there was this complete absence of deliberation on the backwardness of this vulnerable community. So there was also naturally invisibilization of this community. And whenever there is invisibilization of any identity group, the foremost right that is often infringed is your political right, because often the other rights directly flow from your political and civic right. And what I mean by political right is very expansive in this, but in this paper, I have limited that scope by only looking at the capacity to participate, to contest the election, and also the capacity to be part of the voting process. So within the paper, that's the limitation on the political right that has been deliberated. But in the wider context, the political right is far more wide from which other rights flow. So that was the other aspect, that often that absence of deliberation in the Constituent Assembly resulted in the invisibilization of this community. And unfortunately, that has still continued in some form. We have developed, the doctrines and the different understanding of disability, which I'll deliberate later on in my presentation. But unfortunately, it does materialize in some form or the other, and often in a very paternalistic form. So that was the second component. And the third component, which unfortunately historically led to this deliberation, is that that there has been no attempt since independence, unfortunately, to actually make to identify the person with disabilities within the political discourse. And the most obvious example is that there is no official data set that we know of lawmakers with disability, because the official documentation, which is the nomination form and the affidavit that is filed by the candidates in the general and the state assembly elections, doesn't have a column on disability. So historically, we don't have any official data per se of who are the lawmakers who have been in our houses, in the parliament and the state legislatures, who identify themselves as disabled. And this directly, there is obviously this direct absence of any identification of any leader, and then the natural flow from that from that is that there is also no leadership to look at. So that is the more underlying political and policy issue that warranted why I sort of deliberated in this particular issue. Now, what I mean in this paper by dignity denied, and so I look at it from what are the exclusions of persons with disabilities with cognitive and psychosocial nature, from a both constitutional and statutory perspective. What has been the outlook of the government and also the courts in terms of what they have been deliberating when it comes to political rights of persons with disabilities, and how do we actually understand the nature of this right from a dignity principle. And therein I adopted the Waldron's principle of dignity, right? I'll start with my sort of core argument, which is that inclusion from a political life is not always overt. It often sort of operates in a very indirect fashion, indirect form, and often is materialized or operationalized rather through the exclusion by providing the procedural mandates that exclude a certain degree of individuals. And that is what the statutory laws in our states do. That often in multiple state local legislation for the third tier of governments, there will be procedures that are there which are providing certain mandatory provisions which a person with disability won't be able to suffice. And hence there is this by default exemption, by default exclusion of that. And often the argumentation that is taken is very functional oriented, which is why that the duty or the obligation that is to be performed are in a nature which is very functional, and hence this disability understanding is looked at from a very functional perspective. So that's the first limitation of our political laws. Then we come to the second aspect, which is what is there even in our constitution, which is under Article 102, under Article 91, and under Article 33 to 6, which does mention phrases like unsoundness of mind or disqualification of person with disability persons on the basis of unsoundness of mind. That's what mentioned in the constitution. Interestingly, when I mentioned that there was no discussion on the backwardness aspect from a disability perspective, there was also no discussion on this aspect. So whatever the documentation that we do have on this aspect is observations from two of the members of the Constituent Assembly, one of the member being Naziruddin Ahmed, who interestingly made a very, sort of a very progressive deliberation or input on the phrase of unsoundness of mind. He said that in some capacity, from the vantage point that we are in, every person is sort of unsound in some form. Although he just spoke on this limit, but the ramification that his statement makes is what we understand today is what we call social model of disability. That often disability is not inherent or individualistic in nature. It's caused by what is being posed by the society in general. And the interaction of this person with the barriers that is being put by the society is what is causing the disability. So what Mr. Nazaruddin back then mentioned about this, understanding of unsoundness from a very social perspective is exactly what we have today. Unfortunately, that didn't lead to any materialization. And the second point, which sort of speaks of the other extreme of the spectrum, was another observation made by another Constituent Assembly member. And he asked for complete, exclusion of person with unsound mind without there being any declaration by the court. So currently we have this safety wall which says that this unsoundness of mind has to be declared by a court. Only then a disqualification can occur. And the argument by the member was that how many people in this country back then are actually being declared unsound by the court. Even the people who are in then at that time in asylum are not so declared by the court. So do you really think that this provision is actually is going to be effective? Now that was another extreme point of view from a very exclusionary perspective, but his rationale was something which was very practical, because if you have this declaration by the court of disqualification, how many people are actually and who has the onus of such disqualification? And this is something which even the courts have not been able to provide the answer clearly from. The response that we do have from court is somewhere of 2008 judgment by the Apex Court in Hari Singh, wherein they equated this unsoundness from a political perspective or political right to the mental illness. That was what they equated with. Now, that leaves an entire community of person with mental illness from excluded from the political participation or being able to participate in the political process in terms of contesting an election. So that's another, that was the another limitation that we have. Now, unfortunately, our constitution, though adopted this unsoundness of mind and almost 150 other legislations also do use this unsound mind or insanity, these two phrases. But apart from the Contract Act of 1872, we don't have any such clarity on what this phrase means, apart from the criminal laws perspective, wherein this phrase and there has been extensive deliberation on this phrase from a defense perspective. But how it operates in criminal perspective and how it operates in political right framework is a very different thing. And unfortunately, the first part, the latter part, which is from the political perspective, is something which hasn't been deliberated upon from a satisfactory perspective. Now, interestingly, even if we take the definition of Contract Act, you'll realize that Contract Act definition is very functional in nature, as in they do allow that if a person entering into a contract is in the ability to understand the ramification of what they're entering into, they do have the contract will be considered as valid contract. Now, whether we can stretch this understanding to a political right. So Jeremy, and wherein the Jeremy Waldron's idea of dignity comes in, which is that is dignity is recognition of individual as responsible agents, and this responsible agent principle of dignity of Jeremy Waldron is what I have sort of utilized to argue that often, even when you stretch the understanding of what we have in contract law to political right, that does serve as an empowerment from a democratic principle. Right. So that is one of the arguments that I have taken in this paper and have expanded upon. That it does serve to within the democratic principle. It does serve as empowering right for person with disabilities. Now, the last part of it, which is understanding it from a disability perspective, wherein the idea of benevolent ableism comes. So benevolent ableism is something which is
Shashank, you have last 2 minutes.
Got it. So benevolent ableism is something which is inspired from benevolent sexism, the theory of Catherine Frencher, which often speaks of paternalism. So what we have right now in our political, what we have right now for person with disabilities in political discourse is operated from this benevolent ableism perspective, wherein this is operationalized by putting person with disabilities under the garb of guardianship or under the garb of protection to deny them the right. Now, a great instance which we saw last year was that person with disabilities were allowed to vote from home. Person with benchmark disability, which is person above 40% disability, were allowed to vote from home. But person with disabilities in general were not allowed. So for instance, person below 40% were not allowed. So the idea was that person with 40%, above 40% need more protection, and hence they should be given preference for voting from home. Now, what it meant was that the idea was to, which was something which is visible from the documentation that was published officially, that they are not allowing a person with disabilities the right, the experience of going into the political, into the polling booth to have that democratic, to be part of this democratic process, which is quintessentially a very basic aspect of dignity. So this was something that they thought is going to be substitute. So this was a provision of a substitution and not participation. That's one of the argument, and there are a couple of other instances which is cited in the paper that elaborates upon this. And in the concluding part, I think the Supreme Court in the last 2 years, especially in the Vikas Kumar versus UPSC, wherein it elaborated upon how reasonable accommodation is itself a fundamental right, and it identified reasonable accommodation not just in the Article 14 but Article 21, interestingly. And reasonable accommodation is very individualistic in nature. It's different from accessibility, which is universal in nature. Reasonable accommodation is individualistic, and when this dignity principle is inspired, this reasonable accommodation inspired from dignity principle is applied on a political right of person with disabilities. We see that often there is structural exclusion of person with disabilities on 3 fronts. First, the non-recognition through constitutional exclusion and statutory exclusion. Second, the structural exclusion through the procedural mandate. And the third, operationalization of the governance system through benevolent ableism that often causes indirect discrimination. So that's 3 sort of concluding remarks or identified factors that I have dealt in this paper. So that will be all.
Thank you. Thank you, Shashank, for your presentation. I think we'll straight away open the floor for questions. I must tell you, I thank you for so clearly asserting that it is the society or the polity which is diseased, which is applying the medical model to invisibilize and exclude the peoples with disability from participating in the public realm. Probably the virus is in the society, and that is something that when we are thinking about anti-discrimination law, we should remember.
Correct. Yes.
Hello. Hi, Shashank. Thank you for that. That was really interesting. I think you mentioned Mr. Nasaruddin's comment from the debates, and I thought that was interesting because the way you saw that comment was sort of being indicative of grounding that there is some, way of social model of disability that can be found in the CAD itself. So would you say this is a one-off instance, because you did describe that there was not much discussion about disability in the CAD, which is right? Or would you say there is a larger pattern of something that can be, seen as understanding the CAD in way of supporting the social model of disability?
So you are right. So on the first part, yes, there was very limited deliberation on a disability perspective, even on this provision, because when this provision was being deliberated, incidentally, there was a protest in Constituent Assembly being done by few members. So there was a lot of confusion within the when this provision came up for discussion. So that's one thing, that CAD was very limited in its deliberation on understanding of disability. That's first thing. And the second thing was unsoundness of mind as a provision was accepted because there is a history that is associated with it, not just Contract Act, but the earlier IPC and other laws also use that phrase. So Constituent Assembly thought that there was no need to deliberate because there is already a substantial jurisprudence that exists in terms of understanding. But what I think they were limited in their scope in terms of understanding was a lot of this jurisprudence was not from a political perspective. A lot of jurisprudence was from a very different perspective, from criminal law, from contract, from civil, and from other point of view. What Mr. Nasruddin mentioned was something which has to be given credit for, because what he mentioned was absolutely correct, that often the disability categorization, the unsoundness of mind categorization depends on the vantage point of which you are looking at. And hence he termed it as a more, as a spectrum rather than a category. I wouldn't know whether he actually understood this from a social model, because social model is something that we got very late in 1990s and 1980s. But if we want to track the origin of it, even in the CAD, I think this particular instance on this day could be something which can be identified as one of the instances. But apart from this, there is no specific instance that I can point out.
Okay. Yeah, please keep it short.
Hi, Shang. Thank you for the presentation. While we are discussing constitutionally how political representation for persons with disabilities could be ensured, what the Nepali constitution does is that in their upper house, it provides for either one reserved seat, either for from each state, either from a minority, a person of minority, or a person of disability. Do you believe that such political reservations are a mean are a tool which provides due or adequate representation, or is just a cosmetic exercise that is being done?
So I'll answer that question from a point of view which I initially mentioned was the deliberation on backwardness, because the discussion on backwards is actually what transpired the affirmative action of reservation for SC, STs and other class. Unfortunately, disability was not there. So we don't have that discourse of what is the backwardness of person with disabilities. Yes, it's very well known that they are one of the most backward socioeconomically and even civic, in a civic sense, they are very backward. So in that sense, if we are taking that parameter, I think there is a very strong case to be made, because if there was a reservation for Anglo-Indian community, why can't there be a reservation for PWDs? There is a very strong legally case and constitutional case that can be made. However, if I think that will make a difference, no. What I think will make a difference is what is happening right now, which is at the third tier of governance at panchayat and state level, wherein states like Tamil Nadu have last month passed a amendment in their panchayat and municipal laws, reserving 1 seats in each panchayat and municipal in rural and urban areas. And what it does is that it automatically expands the absolute number of persons with disabilities who are directly coming into the political discourse. Now, the chances of these individuals moving up the ladder is far higher because you have greater number of absolute numbers than having just one or two nomination at the highest level, which can't guarantee you that there will be representation. So I think this bottom-up approach is going to be more democratically successful, more constitutionally sort of aligned, and I think politically more representative. So that's my opinion on this.
Thank you. I thank you, Shashank, for your presentation and taking those questions.
Thank you.
We now move on to our next presenter, Kshetrangna Pinnamaraju. He's a fourth-year NALSAR student, and his paper is titled "The Empire Strikes Back: The Empire Strikes Back: Eroding Community Forest Rights and Tribal Dignity." Very powerfully and evocatively phrased paper.
Good afternoon, everyone. First of all, I would like to thank Professor Vasanthi, Professor Murli, and the entire team of the IGCL and organizing committee for giving me this wonderful opportunity. It's truly a privilege to be able to present with this esteemed panel today. I'm Kshetrangna Pinnamaraju. I'm a fourth-year law student at NALSAR University of Law. Today, I'll be presenting a paper called "The Empire Strikes Back: Eroding Community Forest Rights and Tribal Dignity." This paper interrogates the Indian forest regime, and I make a simple argument. It is a simple but a pertinent one, that the state has together constructed a legal architecture that renders the tribal dignity, both tribal dignity and the forest rights, illusory and nugatory. To examine this, to examine this erosion, I shall use the ideas of Giorgio Agamben's idea of bare life and homo sacer, to show how forest-dwelling communities are reduced to politically invisible beings, governed, displaced, and easily disposable. I argue that this is not a product of oversight, but a product of design. Before we move on, before I dive right into my argument, I wanted to establish the history of forest legislations in India and governance per se. The forest governance in India began in the pre-colonial era. The order was decentralized, community-driven, and embedded in local customary systems. Forests were governed through knowledge, systemic obligation, and relations within each other. This logic was completely inverted when the colonial regime took over. Forests became economic commodity of the state. The Indian Forests Act of 1865 and 1927 institutionalized this extractive sovereignty of the state. It criminalized access and introduced a central exclusionary forest bureaucracy. Post-colonial governance did not rupture this model. It actually refined it. The Forest Conservation Act of 1980 was born out of environmental concerns largely. But what it did was it still retained the colonial template. It introduced, the forest still remained state-owned, and the people that lived in the forest through generations were kept out of the system. But this historical arc that I'm displaying right now, while important, is only the prelude to what should have been the discourse and shift in the discourse, a legal alignment that never fully came. Now, moving on, my primary focus of this paper is going to be on the scheduled tribes and other traditional forest dwellers' recognition of Forest Rights Act. This act, if we observe the preamble of this very act, it becomes very clear that the object of this act was to correct a historical injustice that was done to the forest dwelling communities, and also the tribal people that have been living in this forest through generations. And for the first time, forest dwelling communities were recognized not as encroachers, but as rightful custodians of forest land. The FRA granted a spectrum of right to these individuals, such as habitation rights, and most importantly, the right to protect, regenerate, and manage forests under Section 5. But this wasn't just merely a symbolic gesture on paper. The law embedded this authority in a participatory multi-layered claims process. The procedure begins at the level of the Gram Sabhas. The Gram Sabhas typically involved the village elders, which again, where claims are filed and reviewed by forest rights committees. These committees must be composed from members of the community with adequate tribal and gender representation. The FRCs could conduct field verifications and submit their findings to the Gram Sabha, which then passes the resolutions. All the people, all the members from the forest dwelling communities and the tribal communities were required to file claims under this procedure under the FRA to be recognized as the rightful custodians of the land that they've been inhabiting since centuries. From there, the claims move to the subdivisional level and the district level committee, which is headed by the collector. In design, this was not just an administrative process, right? It was a constitutional mechanism of decentralizing power and restoring self-governance back to where to the people whom it actually belonged to. But this promise comes with a built-in contradiction. If we look at section 13 of the Forest Rights Act, if I may read it out, the provisions of this act shall be in addition to and not in derogation of the provisions of any other law. I want that thought to sit with all of you for a moment. On surface level, it appears very harmless, right? It appears benign, like it almost appears cooperative. But in effect, it functions as a Trojan horse within the system and scheme of the act. What it does is, as I pointed out, the preamble of the act recognizes and understands that the Forest Rights Act was enacted to correct a historical injustice that was done to these communities. What this particular provision does is it ensures that these systemic frameworks that created and reinforced and continued this systemic exploitation and historical injustice continue to survive alongside the Forest Rights Act. On the surface, rather than repealing or overriding the colonial legal framework that criminalized tribal presence in forest, Section 13 allows it to survive alongside. Laws like the Indian Forest Act, the Forest Conservation Act, and the Compensatory Afforestation Fund regularly have provisions and are constantly reviewed and amended that have provisions that not only contradict the particular provisions of the Forest Rights Act, but also the direct object of the Forest Rights Act. And Section 13 also enables the state to introduce new rules, such as the forest conservation rules, alongside that are outside the sphere of the Forest Rights Act, but still relegate this Forest Rights Act to subvert the object of it. This is not legal harmonization. For a state that is known for excessive use of its non-obstante clauses everywhere, non-obstante clauses are typically used for clarity, but the state has exceeded its use so much that it causes more confusion now than clarity right now. But if you see the importance of the act like this, and you see the provision that is Section 13, it very much embodies a Trojan horse within the scheme of the provisions. I attempt to demonstrate why this provision is typically breaking the spine of the Forest Rights Act and its emancipatory promise. The Forest Rights Act contains within it a provision that says that the prior and free informed consent must be obtained of the tribal communities and the Gram Sabha before any forest land was to be divested. What the Forest Conservation Rules of 2022 do is that under the Forest Conservation Act, the Union government still holds the authority to divest forest lands. What the Forest Conservation Rules do is they delegate this responsibility to the state government once the approval is obtained from the Union government. Once the funds have been collected, once the compensatory afforestation payment and the net present value payment is done, they delegate this responsibility to the state government, which are now obtaining consent ex post facto, which directly runs contrary to the progressive judgments that came out in cases of Orissa Mining Corporation, which is popularly known as the Vedanta judgment. And secondly, the Forest Conservation Amendment that came in 2023, which constitutionality is now under challenge, the 2023 amendment goes further. It allows the land to be diverted freely if the forest land is not part of the government records. This is again directly running contrary to the progressive judgment that laid down that even the definition of forest should be the layman term as laid down in the T.N. Godavarman case. What this effectively does is this creates a dangerous friction. The forests without paperwork do not legally exist. It ignores the lived reality of the Adivasi communities who have conserved and depended on this forest for generations, regardless of colonial record keeping. In one clause, Forests become invisible. So do the people who protect them. But why does the system function this way? What sustains this architecture? In practice, many of the if any of us open our browsers in our devices at this point and just Google or like search Forest Right Act claims rejected, we will find about thousands of articles of different states, different territories, different districts where en masse these applications are rejected for insufficient evidence and the hierarchical approach of Gram Sabhas. In the state of Chhattisgarh, the Forest Department actively passed an order that precluded any NGOs from supporting the Gram Sabhas in making these adjudicatory claims. What this effectively does is that you are asking to justify their presence in a place where they have considered home from several centuries, but also asking them to provide documentation which they were never allowed to have in the first place. Moving on, I want to present 3 case studies. And before we move into this, I want to understand this from the perspective of the state as well. The state earns from forest diversion through Compensatory Afforestation Fund Act, net present value payments, and mining licenses. In contrast, recognizing tribal rights is often met with delays, bureaucratic hostility from the Forest Department, and it invites resistance from groups because the Forest Rights Act has been challenged, its constitutionality has been challenged by ecological conservation groups right now. This is why rights claims are rejected without review, why Gram Sabhas are ignored. It is not efficiency, it is incentive. The system does not go beyond its scope. It works exactly as intended. And when this incentive structure collides with the powerlessness on the ground, it produces patterns once we can observe through these live case studies. These 3 case studies that I've gathered here, in the state of Odisha alone, they were about 140,000 applications that were 140,000 applications that were rejected of this. In the year 2019, the Supreme Court passed an eviction order against 16 lakh people who live in this forest. So what we understand from this is that the Forest Rights Act was enacted for the purpose of granting the community and forest dwelling communities the community rights that they've always had. What is being done is that once their claims have been rejected, this rejected claims are being used to evict them from the forest that they have inhabited since years. This effectively, to me, turns the object of the Forest Rights Act on its head. And lastly, there are many ecological concerns that come that point out that how can they are coming from very paternalistic spot that point out how can a forest dwelling community or how are people who are living in the forest from several years can contribute to its effectiveness. For this, I want to point out the third case study that I've gathered here. The third case study is particularly in the village of Odisha, where the governance and the forest right claims were accepted by the community, by the Gram Sabha, and it led to a revival of the forest and revival of an endangered crops and other things. And this is how I would like to counter the dominant narrative of ecological concern versus tribal custodianship of the lands that they've always belonged to. Moving on, I want to understand this governance.
Last 2 minutes.
Yeah, and I'll conclude, Professor. That this governance model does conceptually. I turn to Giorgio Agamben's concept of bare life and the figure of Homo sacer. So Agamben divides life into 2 components. He has bios and zoe. So what he says is that, as Professor Daly pointed out during her presentation, the Supreme Court likes to keep saying that Article 21, the right to life, means more than mere animal existence. The zoe is the biological fact of merely being alive, and the bios is the political life. It is not just the manner or existence of life, but how you live it, your involvement in social and political life. This too, Agamben argues that when you are stripped of your bios and only zoe is remaining, you are what is known as bare life. To demonstrate this concept, his primary example is that of a Homo sacer. I'll take 1 minute to briefly run you through the concept. Homo sacer is an ancient figure in Rome, a historical figure in ancient Rome. He was sent out when the war was already lost, when the battle was already lost. His only role was venturing out and killing as many people as possible as a tribute to the gods. In the rare scenario that he was effectively sacrificed by the state to perform his duty, to perform this tradition. In the rare scenario that he was found alive and he returned back to Rome, he was stripped of bios and any social and political involvement. What remained purely was bios. What remained purely was his zoo. This argument points out is stripped to bare life. He had no legal standing, no right to be mourned. He existed in a place where the law saw him but no longer protected him. This framework is what I argue should be placed on the forest dwelling communities and the tribal people who are being forced out of their forest, forced out of the place that they've protected since centuries. This is what India's forest governance does to tribal communities. They are acknowledged in census records, statutes, schemes, promised recognition under the FRA, referred to in government guidelines. But when it comes to power, to self-governance, to protecting their forests, they're already sacrificed. Their consent is bypassed. Their claims are rejected. Their resistance is criminalized. They are alive, but in the eyes of law, they have already been abandoned. Like the Homo sacer, they are present, but outside the protection of the legal and political order. Governed, but not represented. Counted, but not heard. And this is not neglect. It is systemic structure, a structure that legally produces bare life while invoking the rhetoric of inclusion and dignity. Now, lastly, just concluding remarks, Professor.
30 seconds.
Yeah. What the state calls dignity in forest governance is not empowerment. It is administrative mercy. If we understand the 2019 judgment or the order that was stayed right now about the eviction of about 16 lakh people, it does not treat the Gram Sabha adjudications as a possible administrative discrepancy. It treats it as a final verdict, and it is forcing them to move it out. A recognition that arrives only after displacement, a consent asked only after clearance, a right framed as a privilege, and that is the logic of bare life. To appear inside law, but only through exclusion, to be seen, but never allowed to speak back. Dignity is not something we stitch together from state approvals, procedural scraps, or delayed recognitions. It is grounded in self-determination, autonomy, and custodianship of the land that they have continued to protect since centuries. That is where my presentation ends, and where I hope the imagination begins. Thank you.
Thank you. Questions? Yes.
Hello. Brilliant presentation, Shetagna. Really insightful, really passionate. I just wanted your and I agree with you on all the points you mentioned. I just wanted your response on one thing. So, what Section 13 of the Act does is, it does not say that other acts are somehow superior to the other. It just sort of like clarifies, and to quote, it just mentions that this is in addition to other acts. Okay, so it does not create a hierarchy. And at the same time, what the Supreme Court's judgment in Vishal and Kalsaria versus Bank of India does is that it holds that when a factual matrix is governed by two laws, and in those two laws, one of them is a social welfare legislation. In such an incident, the social welfare legislation's interpretation and application should be upheld over the other law. The act, the case dealt with Rent Regulation Act and SARFAESI. Now, in lieu of this, how do you respond to this, like the apprehension that you raised, and the answer that how do you respond to that?
Thank you so much for that question.
If there aren't, then I thought I'll just ask you something. You were there yesterday.
Yes, ma'am.
So I was wondering, how would you respond to what Professor Barua was saying, that this idea of community rights has no philosophical foundations? I thought maybe you will start with that and then also take.
No, I got the question. Thank you so much for both the questions. With respect to the community forest rights and how it recognizes it, the Forest Rights Act clearly delineates between the individual rights that a member from the tribal community or a forest dwelling community has, and vis-a-vis what a community right is. A community right is garnered in the fashion that the right to harbor produce and sell it and like use the produce in a equitable way. And when it comes to forest particularly, and the communities that are living in the forest from generations, it becomes very difficult to separate the individual from the community. What I remember is in one of the judgments, I don't recall the exact judgment, but and it pertains to one of the questions that Saksham asked previously too. When you're talking about liberty in the framework of the Constitution, it not just means liberty in the community, but liberty from the community as well. But in my opinion, the Forest Rights Act embodies both individual rights and community rights, which allow you and enable you to do so. And if in practice it is operative, but right now I don't think it is. And answering to your question, Saksham, as if you refer to Section 13 directly, it says not in derogation and in consonance with other rights. But as I pointed out, the framework of Forest Rights Act is never diluted directly. What the state is effectively doing to subvert the law is it is passing amendments and new rules under the Forest Conservation Act, the Compensatory Afforestation Act, and other things. So what it effectively does is that none of the provisions are directly in derogation of the Forest Rights Act and any of its social justice provisions. What it inevitably does is that when you have a particular provision that says that you have to mandatorily obtain free and prior consent of the communities and Gram Sabha, and then you're passing another rule under another act which falls outside the sphere of this act and saying that this consent can be obtained ex post facto, you're diluting it indirectly. And there are doctrines that say that what you can't do directly and what you can't do directly, you can't do indirectly. But sadly, very rarely you use that doctrine in cases such as social justice to justify this theory of, or hold the state justifiable. And that is it. And when it comes to the social justice provision versus this case that you pointed out, it becomes very tricky in this particular thing because this Section 13 does not operate as a non-obstante clause. And when you're talking about Forest Conservation Act, how would you exactly interpret, or how exactly would you identify the nature of the Forest Conservation Act or other things? Because end of the day, the Forest Conservation Act, the Wildlife Protection Act could also be social justice provisions because they are protecting it. Thank you so much.
Thank you, Shetrangna, for allowing us to think from the perspective of, or bring in the work of Agamben to think about how state can operate outside of legal norms and what it does to people who are living on the margins. With this, I now invite Mr. Robin Jaiswal. He is a doctoral student at NALSAR, and his presentation is titled Decolonizing Dignity, Plural Legal Imaginations and Constitutional Personhood in the Struggle for the Right to Disconnect at Work.
So, hello everyone, and good evening to all. So, I will be presenting on the topic is recognizing dignity or decolonizing dignity, and I'll be linking it to something that I would like to know how much or how many of you are familiar with: the right to disconnect at workplace. So just a very quick question before I start. How many of you are familiar with disconnect law? Any global or anything? Just a hint, we don't have any in the Indian context, but then there are countries which already have laws in place. So we will just start with this particular thing. So first of all, why is it a legal and a cultural right? Okay. Now, first we need to understand what exactly is the right to disconnect, because quite like a few of you only know what do you mean by a disconnect law.
So the first thing, right to disconnect is basically a proposed human right. And it basically talks about a certain right where a particular employer cannot disturb his or her particular employee post work hours. And how do we establish or how do we expand the meaning of the word disturb? It usually comes upon to the fact that the employer cannot make any kind of work related communication to his or her respective employee post work hours. So on the surface of it, this is the meaning of right to disconnect. Now, but then when we see the situation, let's take for example the sector, IT sector in India, where this particular thing usually lands in a conflict zone because you don't have fixed working hours, and even if you have fixed working hours, your employer has a right to disturb you related to any work related requirements even after work hours. And why stick to just the IT sector? We have a lot of other sectors. Take into consideration also the litigation sector, where I don't think that a certain right to disconnect law will actually benefit. Plus, there are certain exceptions also, like the healthcare sector, the emergency sector, as well as the defense sector, where obviously a right to disconnect law would lead to quite a crisis-based situation. Okay, so I would like to establish it with these points that basically working laws, it embeds dignity with agency, consent, and autonomy. As to how much autonomy a particular employee has given while he has signed an agreement with his or her employer. Secondly, right to disconnect, obviously, it is based on the premise of emotional as well as psychological well-being. Because obviously, when a particular worker is healthy, and by the contours of healthy, I not only mean physically healthy, but also mentally healthy, because obviously mentally healthy will give more effective results for the company for which he or she is working. Last but not the least, we have the recognizing the sovereignty factor. Now, when we talk about dignity, this particular thing, it draws a certain line between professional requirement as well as personal requirement. And when we talk about time sovereignty, it's like, yes, that particular person is available for a particular time period and not beyond that. So we have this culture in our corporate sector, the particular thing called always available, right? And at the end of the day, this particular thing, obviously it yields great results, but beyond the great results, there is a lot of thing that is happening mentally and a lot of people who are getting affected because of this very thing. Now moving on, how all these things, like through my paper, I would like to highlight this particular thing as to why this particular work culture has basically crept into each and every sector as we see now. I would like to give you an example where everyone knows the motor company Ford. And so the founder of the company, William Ford, actually came forth with this particular thing, the 8-hour work schedule. It was first of all established by this person. And you can sure as well blame this person also, because why this 8-hour work rule, where he came up with a person should actually take rest for 8 hours, work for 8 hours, and the rest 8 hours is based for all other activities for the rest of the day. Now, he in entirety turned this thinking of working class, and it slowly went on to adopt other countries as well as other working sectors. Now, where it came from, why? Because everyone knows where I'll be pointing fingers at. The concept of capitalism will come into play here, obviously, and that happens to be the very first reason. And what does state actually prioritizes? Obviously, state prioritizes mostly productivity over anything. And because I also highlighted the part that you are always available, but state also comes up with a certain new principle, or I would rectify myself, it's not a new principle, it's a hidden principle. It's like you are always replaceable, because if you're not ready to do your work, there are 10 more people who are lined up to do same amount of work which has been given to you. So you are easily replaceable. You are an replaceable asset for any company, any corporation, or in fact, even for the state. There are the other points that, yes, the marginalized voices are ignored because we know in entirety what is happening at the working sector. I'll just skip this part. So reimagining constitutional personhood. Now, I think everyone knows and understands what legal formalism is. Law basically says that we have to follow certain protocols, and that's where labor laws come into play. But does labor law take into account what exactly a particular worker is supposed to work? Yes, he has to be available and he has to work for certain working hours. But at the end of the day, whether the work which he is providing, is it actually making a contribution? Like he can contribute more if he's mentally fit, if he's mentally taken care of. We also have certain laws in India, like we have the Mental Health Care Act. It also takes into account that, yes, employees should be covered by this particular act. It gives a certain rule, if I would not say a law, but a rule that companies shall also have to take into account and take care of the mental health of their certain employees. But since it's a rule and not a law, obviously corporations are just including that in their respective CSR initiatives, but not something concrete in their legal or practice-based books. Now, moving on. Linking dignity with right to disconnect. Obviously, like I already highlighted, hyperconnectivity and normalized overwork is the new culture. Psychological well-being remains overlooked. So I need to emphasize upon this particular thing that yes, we do have laws in place, but then these very laws ignore a very important, or we can say a very cultural point that yes, the very culture that you need to be available and you need to be available at every given point of time. Why? Because the company considers this as loyalty. And hence this particular cultural thought process needs to be pinpointed and changed a bit. Now, limitations of traditional dignity jurisprudence. I already highlighted this point that colonial era labor codes perpetuate inequalities and they usually ignore marginalized groups like women and gig workers. I would also like to highlight this point here since we are talking about gig workers. Everyone knows the point that most famous food delivery app, that is Zomato, it doesn't employ riders, okay, or the delivery partners. They have coined up this new term called delivery partners. And why? Because they are actually providing them some rights. But if you are aware of the fact or not, but those very rights are not governed by any labor law legislations in India. So on the face of it, it seems that yes, Zomato is empowering all those delivery agents by giving them a new name as delivery partners or simply called partners. But at the end of the day, it's all bleak and dark. And the reason being because they don't want those workers to get any kind of rights or any kind of regulatory mechanisms or benefits. Okay. Post-colonial theory, I'll just skip this part because I need to highlight some more points here. Intersectional impacts, like there are some parts which are highlighted and I would like to just elaborate on this. Women and unpaid care. Obviously, gender remains a very important issue here. And as to how, because the kind of discrimination a male worker or a male employee faces at their workplace, and obviously when you compare that to a female employee, but at the end of the day, they are facing it more because there are other things into play, but then corporate being a corporate would only like to see that whether the productivity is taken into account or not. On this point itself, I'd like to highlight the point of menstrual leave that came into play. That again highlighted the very I won't call it gruesome, but then to a very low point as to where companies can stoop down to. Like when it was declared that certain companies will come up with a minimum of 2 menstrual leaves per month, and that led to a lot of HR agencies of those companies actually thinking of the point that why hire a certain employee where a certain employee is only available for 28 days of the month and not 30 days of the month. Again, a very problematic scenario, but company being company and capitalism being capitalism, productivity triumphs everything. And lastly, we have the point of emotional burden of digital overwork. Yes, a lot of people are working. I'm so sorry. A lot of people are actually providing services from their respective homes. And yes, because you are reporting from home, there are no fixed hours. And at the end of the day, this is also something that, yeah, sure. So through my paper, I would like to highlight all these points and eventually come upon this particular as to legal analysis of certain points that will evaluate some of the existing labor laws and constitutional provision.
Robin, last 2 minutes.
Yes, sir. And recognizing professional and personal line, as well as recognizing the concept of rest as well as break. And by rest and break, I don't mean the kind of breaks which you get at your workplace, but the part that there should be a definitive line as to where employer cannot establish any kind of communication or respects the boundary as to when he or she can actually communicate with his or her employee. Intersectional analysis, obviously we'll be talking about certain laws apart from labor laws, like I mentioned one of them as Mental Healthcare Act that does talk about this particular thing, and reform through participatory worker-led processes. Though there are a lot of participative activities, a brief example of that would be CSR activities that are undertaken by each and every company nowadays, and mental health camps. But then, yes, looks good on paper, yields very less amount of results. Lastly, I would like to make a comparative analysis also through my work. So there are certain countries, and first of all, it was started in the country of France itself, came to be known as the El Khomri law, where they actually talked about certain communication gap should be established between an employer and an employee beyond certain working hours. Moved on to other countries like Spain, Italy, lastly being Australia. Just 12 or 13 months back, the law came into fruition. And as of now, while we are talking about it, right to disconnect as a bill was presented in India way back in 2019. But since it was a private bill, I think everyone knows the success rate of a private bill being passed. So yes, work related to this kind of disconnect laws is still a long way to go in India as of now. But at the end of the day, through my work, I'd like to highlight why certain sectors actually require this kind of law in making. So just coming to the last part itself, that the quote, like, do what you love and you will never work a day in your life. But the point of stress here is the fact that even if I'm having my work and doing it with utmost care, what about upholding of my own dignity? Because at the end of the day, if I'm prioritizing my work, dignity somewhere takes a hit. And how much the law protects it, that remains a point of stress or a point of question. With this, I would conclude, and thank you very much. So.
Any thoughts, observations, questions on Robin's presentation? Yes. Go ahead.
Even if we were to, let's say, bring a regulation about even if we were to give it as a right to people, but what if people themselves are willing to put in the extra hours to get additional incentives? Because we can give the option to our people, but we can't enforce. Like
What is your question complete?
like we can't force them to disconnect, right? What if there are additional incentives for that? How do you?
The bill in itself talks about this particular thing, that it is not imposed as a law, more so like a regulation. Let's take, for example, if a person like you is ready to give in more amount of work, let's take, for example, more than 8 hours, taking it to be 12 hours. But then a person like me, who only wants to work for, let's take, for example, 8 hours, but clocks in 8 hours of productive work, constructive work, right? Because there is also, since we were talking about cultural shift and perspective thing also. In countries like India, it is considered that if you are sitting at a workplace and doing nothing, but still if you are seen from a distance that yes, I'm sitting at my workplace, oh yes, he is working very hard. Then this kind of culture, when you take into account countries like Japan, then yes, they actually take this thing very positively. If you are clocking in hard amounts of work and if you fall asleep at a workplace, they consider it as a very positive thing. So right to disconnect basically only talks this as a measure that it is not supposed to impose anything on you, rather it's supposed to save people like me or people who somewhat thinks that yes, law are also supposed to protect them, not entirely. Basically, it's not supposed to change your work culture or anyone's work culture for that matter. But at the end of the day, it strives to become something that yes, your mental health is being taken care of at the end of the day. Because eventually, even if you are also clocking 10 to 12 hours of work every day and always being available, it will eventually lead to something that we all know as burnout, and everyone knows about that recent suicide that happened at ENY. I'm not saying that it's a very common practice. It's rather very tragic incident, but then at the end of the day, why wait for something like that to happen? If you can actually bring in a regulation, let's take, for example, any kind of practice that can benefit you as well as me.
You want to respond? You have a question? I thought I'll just respond 1 minute and just respond. So the idea basically, and one of the things that we haven't really touched upon is the question of dignity in the context of labor. Of course, Mrs. Muralidhar in the morning spoke about it, about what are the ideas of dignity that are associated with labor. But one of the first ideas of dignity that is associated is what we have been hearing for the last 2 days, the idea of being human. The idea of having a limited amount of energy and to be seen as possibly something that is fragile and something that will get exhausted, and not to see it as as just a means of production, as something that will just constantly go on reproducing itself without any additional support, reinforcement, breaks being given to it. So I think to recognize the human value of labor, I think, is where the dignity paradigm is useful in terms of what it means and culturally and how far it gets recognized, it actually gets implemented. That is a different story, and that is true for all aspects of dignity. But as a norm, what does it ask us to see? I think that is what we can pay attention to. As a norm, it's asking what is the idea of dignity connected with labor or with something as simple as or as mundane as working hours. Is this business of seeing people as human and requiring all of those, support that is to be given as a person. So recognition of a personhood and humanness is where dignity becomes useful in this context of labor.
Basically, human being seen as a resource, and we can connect dignity with a human, cannot, or can we connect dignity with a resource? So that is the point of conflict here. Then that is what I'm trying to highlight with my work. And I think someone else had a question. Yes.
So, like, My question is grounded in practical considerations. Given the fact that currently in India, informal sector dominates and employs 90% of the workforce and contributes nearly half of the GDP of the nation. Do you think a right to off from the work would enable India to progress in a direction where only the organized sector is being regulated? What about the informal economy? Because that is the largest chunk of the nation right now.
This is the reason why I said that. Yes, sir, please.
See, the question of dignity as far as work is concerned, whether it can be a reference point in the globalized economy that we are living. It's never a reference point. I mean, in the whole debate also, 1920s, when there was an attempt to restrict the number of hours of laborers, it was opposed by even judiciary, and then they said it is everybody has a right to exploit themselves, or it's a personal liberty. From beginning there, you can't restrict the number of hours of work. Now we are asking these questions because there is some sense of work-life balance, or I mean, it's a human right, therefore you could restrict. But it was never a reference point for a capitalist economy. And now, at least after informal economy, I don't know whether there is any question of disconnecting, especially with the development of technology. There is nothing like disconnecting. How are we going to achieve this if foundations of our social life is technology and neoliberal economy, where you have to exploit yourself as much as possible in order to live a certain standard of life. You don't need even law. Even without that law, you can keep exploiting yourself. Indeed. Beyond that, there is one more question that is independent of regulation law, whether people really wanted to disconnect with the employer or with anyone else.
Certainly, sir.
Short 30-second comment, then we'll move on to the next speaker.
Yeah, just would like to highlight just this point itself, that basically it's a work of practice here as well as perspective. And I would like to highlight that very point itself, which I made to certain question that came, that at the end of the day, this particular law is only trying to highlight that there are certain section of workers that actually need this kind of protection in place. Answering your question, sir, at the end of the day, this requirement of the person, or whether we actually need disconnect, even if that is the question here, I would rather say that there is still a lot of workers in certain sectors that actually require this kind of protection or this kind of regulation in place, because the situation calls for it. But then it doesn't call for a very strict law as of now, but rather an enabling regulation, which will finally, or at the advent, will start making people aware of their rights first. That yes, you don't need to be available at every moment of time whenever your employer feels like, and start taking things in a more productive manner, as to like clock in a certain amount of work, but then be productive, because this is what standard workplace practices expect from you at the end of the day. And answering to your question, obviously in a country like India, again, certain sectors, all of the sectors should not be covered by something like this. But at the end of the day, one thing that needs to be highlighted is the fact that, because like I already said, there are so many irreplaceable assets here, considering all of us as workers. But then if something of this sort comes into play, this very notion of taking things or considering humans as resources, this very notion is going to be challenged a bit. Obviously, that's not going to transform everything right from the very first day, but then yes, because IT workers at the end of the day are not even aware of this particular thing. That is, something of this sort is also being possible of being made or being introduced in a country like this.
Thank you, Robin. We are really short of time. So now with this, we'll move to our last presentation. We have Mr. Abhineet Maurya, who will be locating the philosophical basis of dignity discourse in Indian law. Over to you.
Hello, everyone. I'm Abhineet. I am a recent graduate of NAU Delhi. The paper I'm presenting concerns the philosophical foundations of dignity in Indian constitutional discourse. As Professor Prasoon already mentioned, my paper is sort of a continuation of the discussion that we had during the first session yesterday. But I also hope that it draws from and also rounds the discussion that we've had since. What this paper looks at is various conceptions of dignity in the literature of moral philosophy and come up with a defensible idea of dignity that can be used as an understanding for dignity in law generally, but specifically within Indian constitutionalism. We will start with looking at some objections to the use of the concept of dignity and build our ideas from there. Ruth Macklin, a Yale bioethicist, in an influential 2003 article, criticized the idea of dignity as being vacuous. What Macklin's criticism hinged on was the argument that appeals to dignity are either vague restatements of other more precise notions like autonomy or mere slogans that add nothing to the understanding of the topic. Since then, the criticism about the concept of dignity has multiplied, and I think it is best captured by the provocation that is offered by Michael Rosen. He asks us to consider the words of Article 1 of the UDHR. All human beings are born free and equal in dignity and rights. What would be lost, Rosen asks, if one were just to say all human beings are born free and equal in rights? What is lost exactly? Or are we exactly where we started with freedom and equality? This criticism pulls us in one of two directions. We can abandon the claims based on dignity and search for more real concepts underlying it, like autonomy, and try to interpret them. Or we can search for a philosophically defensible thesis of the contents of dignity that brings something to the table that other concepts do not, thus preventing its collapse into other concepts. So let's sit with that thought for a moment and examine what the Indian Supreme Court jurisprudence tells us about the meaning of the word dignity. For the last half century, the Supreme Court has given a slew of judgments claiming what human dignity entails. But these claims mostly take the form of right X follows from dignity. But very few of these judgments actually discuss what dignity means or even discuss in detail why right X follows from dignity. The lengthiest exposition about the contents of dignity was given by the Supreme Court in the Puttaswamy cases in context of right to privacy and Aadhaar. In the Aadhaar judgment, Justice Sikri, writing for CJI Deepak Mishra himself and Justice A.M. Khanvilkar, stated that dignity is to be treated as empowerment which makes triple demand in name of respect for human dignity, namely respect for one's capacity as an agent to make one's own free choices, respect for choices so made, and respect for one's need to have context and conditions in which one could operate as a source of free and informed choice. Now, this explanation is also very similar to what the Delhi High Court said in the NAS Foundation case, where it said, at the root of dignity is the autonomy of private will and a person's freedom of choice and of action. Now, looking at this, Ruth Macklin's objection seems tempting, because this is basically the idea of autonomy. One is tempted to then go down the first route to sort of claim that, well, dignity is nothing more than autonomy. Therefore, what we should really be focusing on is autonomy and trying to interpret that. But the kind of rights that dignity has been made to anchor do not exactly support dignity's identity with autonomy. As Professor Erin mentioned yesterday, that autonomy assumes that we are all on islands, right? And rights like livelihood, healthcare, education, which have been linked to dignity by the Supreme Court, don't fit within this vision of dignity as autonomy. The bottom line is that the Supreme Court has a conception of dignity that is broader than other concepts like autonomy, but whose precise content is yet to be judicially expounded. That is why we must go into the second direction and we must look at new approaches to dignity. So yeah, we are back to the blackboard. So let's go to moral philosophy. What does a broad review of literature of moral philosophy tell us about the meaning of the word dignity? And a broad review of literature divides these definitions mostly in 4 camps. One is obviously a theological camp, the most prominent example of which is the concept of imago Dei in Catholicism, whereby human beings are treated as sacred for being made in the image of God. Of course, this cannot be made a moral ground for dignity in modern and secular society, but many argue that our modern concepts of dignity owe an unacknowledged debt to this Christian theological concept, and that is why it remains popular in moral philosophy literature. And the second is obviously the legacy of Kantianism, whereby humans are considered having an innate moral worth, noumenal worth, by virtue of having the capacity to reason. And this emphasizes the need to treat human beings following the Kantian aphorism as ends in themselves rather as means to other ends. The problem, of course, is that this concept too collapses into the idea of autonomy. Then we have the idea that is endorsed by scholars like Appiah and Waldron, that dignity is a purely legal construction. They argue that through law, dignity modernized the feudal construction of dignity as elevated rank associated with nobility. As per this account, the treatment and deference that were historically due to nobility are constitutive of what we call dignity. And then the last perspective is dignity as authoritative standing to make second personal claims. This view claims that dignity is a relational concept, which is neither inherent and not merely historical accident with no moral basis, but one that comes into existence with actual second-person encounters, meaning encounters with other people. For obvious reasons, we cannot take the theological paradigm and we cannot take Kantian paradigm either if we want dignity to be something more than autonomy. So the two contenders to give meaning to the content of dignity are the members of the third and the fourth camp. Let us take into consideration the third view. Waldron argues that dignity is not an innate moral right, but rather a purely legal construction. Its genealogy lies in the way dignity was in earlier societies, a master of rank, a marker of rank used to justify special protection and ceremonial respect for kings, aristocrats, officials, etc. The modern idea of dignity, according to Waldron, is a democratized version of this rank idea, now attributed to every human being. So as per Waldron, dignity is not a mere source of right, but a right in itself, a right to be treated as someone of high status in society with implications for how laws and officials behave. So what gives the idea of dignity its structure and meaning is its historical and legal roots. However, in my view, there are a bunch of issues with this view, and I'll highlight 3 of them which are relevant to us. The problem with a historically grounded construction of dignity is that it makes claims to dignity unintelligible in contexts which do not share that historical meaning. Dignity in Indian constitution is not a reference to a standard of treatment of medieval European nobility, but rather an intelligible moral concept. Descriptive history of a concept cannot be used as normative justification. In Waldron's case, what acts as a justifying norm is actually equality. And Waldron claims that dignity is closely related to equality, obviously, but it runs us into the same problem of collapsing of categories. Only instead of autonomy, we now have equality. If equality of treatment is the normative foundation of dignity, then normatively speaking, any treatment that can be equally guaranteed can make the concept of dignity. The fact that it is similar to the treatment of nobility is a mere chance of legal history. That does not explain the direction that the Indian Supreme Court has taken, where specific treatment is taken as, whereas particular treatment is taken as foundational to dignity. This leaves us with the fourth view, which I believe gives the most sensible account of dignity for our purposes, the view that is taken by Rainer Faust. According to Faust, to see human beings as having dignity is to see them as persons endowed with a right to justification of all actions or norms that affect them in morally relevant ways, and acknowledging that every moral person has duty to provide such justification. Therefore, dignity rests on the moral status of the person as a reason-giving, reason-demanding, and reason-deserving being. The concept of dignity is related to what Professor Vijay Raghavan talked about yesterday in relation to under-trials. That what registers as a violation of dignity to people is not even being heard by judges who are overseeing their case. Ms. Isaac talked about it just now as well, being heard in procedural proceedings. Not only does this idea of dignity encapsulate the idea of autonomy, it also demarcates the extent to which what we think of as socio-economic rights can be covered by the notion of dignity. Faust writes that what violates people's dignity is not something like poverty itself, but that they're compelled to live in poverty due to human actions and structures. The violation of dignity consists in being ignored, not counting, being invisible for the purposes of legitimizing social relations. And Kshetra also talked about it, about this invisibilization just now in context of tribal forest rights. Now, why do I think that this is a good picture? First reason is that this is a moral picture rather than a historical one. It can be interpreted independently, unlike Waldron's account, which restricts us to a legal historical paradigm of interpretation. Additionally, it is a moral concept of dignity that cannot be reduced to other ideas like autonomy or equality and has its own life. Now, Faust's view of dignity is a broad one, which makes dignity the foundation of democratic politics, which legitimizes social relations, and it has not just legal but also ethical, social, and political dimensions, which can very well be what can be understood as the meaning of the word dignity in the preamble of our Constitution. Because the Constitution is not merely a legal document, but also encompasses moral and political values. But what dignity can mean for us as far as part 3 of the Constitution is concerned has to be a narrower understanding of the political value of dignity, given the specific role that courts and legal institutions play in society. Dworkin talked about the distinction between principle and policy, and the idea is that the constitutional legal principle of dignity cannot mean the priorities of a welfare state. Professor Preetham yesterday discussed the idea of dignity inflation, which is also very closely related to this problem. Here too, Faust can be of help, especially the understanding of the difference between injustice and profound injustice as far as violation of dignity is concerned. He says, those relations are unjust that are not sufficiently justifiable in reciprocal and general terms, and those relations are profoundly unjust that systematically thwart the practice of justification itself. The idea of systematic thwarting imputes an agency upon an actor, this case the state. Therefore, a mere policy failure to ameliorate the condition which invisibilizes that person from process of legitimizing social relations, while it is a violation of dignity, would not be judicially enforceable given the specialized role of judiciary in the legal system. However, a practice or a set of practices that actively contribute to this process of invisibilization would constitute a judicially enforceable violation of the right to dignity. And this is what I think Article 21's conception of the right to dignity should entail. And this is the idea of dignity that we are legal institutions in India, but I think in many other jurisdictions can sort of adopt to have like a coherent, philosophically grounded understanding of dignity. Thank you.
Thank you, Abhinay, for that very powerful presentation and for bringing another dimension or content which says that reason-giving exercise or giving justification is what counts as citing dignity. And any questions, observations, or comments on Abhinay's paper? Okay. Yeah.
So just no questions as such, but as the floor is open to comments.
No, then we'll wait for people who have questions before making general observations.
I think while people are formulating their questions, I think Saksham can just go ahead. Yeah.
Thank you for this because and like how the way you collected everything back I think a general theme with the entire conference has been, and it's a general tendency for lawyers to try to box things up, to to have to pigeonhole stuff and like get some groundings. And the first panel did that as well. And I think at least if you quench that thirst to some extent for the lawyer inside me, and so thank you for that.
So faith affirming comment that you made. I'll take that opportunity to ask you a question that towards the end you spoke about what counts as justification. Would you want to flesh it further as to what is it that in the public realm would count as reason and justification giving exercise, and what is its link to the public realm and understanding of justice? Because there can be public reasoning, non-public reasoning, religious reasoning, identity-based reasoning. What is the kind of reasoning and justification are we talking about? And how different is it from Habermasian conception of public reasoning?
I think as far as Habermas is concerned, Habermas's idea is a very, as you mentioned, public reasoning focus. But I think Faust's idea is broader than that, because the way that he conceptualizes the idea of dignity, it is not just a public exercise. It's also a private exercise. He talks about in terms of reciprocal obligation. So if we are interacting in a one-on-one setting, because the idea is second person claim. So if we are interacting in a one-on-one setting, me treating you as a reason-deserving subject and you treating me as a reason-deserving subject is what sort of constitutes this like sort of reciprocal obligation. I think Gopal Guru also talks about how we are so obsessed with the idea of freedom of speech, but what we should focus on is this reciprocal ethic of communication. And I think Faust's idea sort of very well encapsulates that idea. That, of course, when we sort of, when we're talking about law, we are obviously getting the state involved. And then when the state is involved, then obviously we have to scale up, and then we have to go at the level of public reasoning and how, how do we conceptualize public reasoning in this way? What sort of justification sort of, count? And I think when we talk about public reasoning specifically, the reasons that should be given should be reasons that relate to the individual. They cannot be community justifications, right? You deserve this happening to you because, well, it is good for the community. That is not the sort of vision that Faust has, and I agree with Faust that what matters at the end of the day, dignity's relentless focus, as Professor Erin also said yesterday, is on bringing the issues back to the individual. And I think that this view does that beautifully, grounding, dignity so broadly that, as the private reason, public reason, everything that gets incorporated, but at the same time, the issue that the focus on the individual is always consistent.
Thank you. Yes, Professor.
Thank you. I think this is really interesting. And you mentioned a bunch of different kinds of reasoning, but I was actually thinking about bad reasons. And oh, sorry. Thank you. So I was wondering, and you sort of started to answer it in your last answer, but it seems to me that there has to be a qualification of what kinds of reasons are acceptable. And to have that qualification, you have to sort of assume dignity in order to get your answer for the justification for whatever you're asking for, right? So I'm thinking about US Supreme Court decisions from, let's say, the previous century that upheld segregation, and non-US Supreme Court, like lower court decisions. So those opinions have lots of reasons in them. We, I think, who care about dignity, would consider those reasons to be not acceptable, but they are reasons. And I'm trying to work this out, but it seems to me that the only reason that they're not acceptable is not just that they're group-based as opposed to individual, but that they deny dignity. And so I'm just wondering if that gets circular, or how you have an account of justification that
that tests the dignity rather than assumes it.
Yeah, I mean, in the past few weeks that I had the time to think about false ID, I think that is the most powerful, like, sort of, objection to the idea that I've also come across, that does false idea reduce it to a merely formal sort of qualification, and whether there is like a more substantive sort of criteria to the idea of dignity as well. And I think what struck me most when Judge Asad was talking about how accused persons are made to stand with their hands folded, heads down. That is instinctively feel that is a violation of dignity, because that sort of idea of dignity comes from a respect for a human person, which I think, yeah, that is, I think, one weakness within like Faust's sort of vision of dignity, in that this idea of respect that people have, and we can sort of think about a lot of other things, like the idea, and something that Supreme Court also has talked about a lot, about the idea of death with dignity as far as euthanasia is concerned. Can a model of reason sufficiently account for that idea of dignity, or do we need like to incorporate a broader idea of respect that goes along with this idea of justification as being like the end goal of dignity? And I think that is certainly something that I will have to address if I ever make this thing into a full paper. And I think it is something that I do not have a complete answer to as of now. So yeah, thank you very much for bringing that up. And it is something definitely that we need to think about when we sort of try to conceptualize dignity as a whole concept, and not something that just stands in for something else. And yeah, maybe we can think of it that maybe the right to justification entails within it a kind of morally complete justification, a morally correct justification. But then again, then we are not treating the idea of dignity as a standalone idea. And maybe that is fine, maybe that is not. But that is, I think, something that requires greater amount of thought to go into it. Yeah. Thank you.
Yeah. Well, generally, when I hear these things, I'm tempted to think that any reasoning will not help. Therefore, one needs to have some kind of ethical reasoning. This is what I try to then. Still, when I go back to the way that colonialism was justified, the way that slavery was justified, the way that caste system was justified, everybody was giving some reasoning or the other. Right. Then the question is, the kind of set of reasonings that you develop, even in the name of ethics, are conditioned by already existing structures of social relationships. Right. See, we are assuming that the two people who are now trying to communicate with one another are equal to one another. Therefore, the other person owes an ethical justification to the way that he treats the other person. But that is not the case. See, the guy who's now standing as a accused, he knows that he can't ask anything. The presumption on the part of the people who are sitting on the pedestal also knows the reason that why they don't want to give the reason. So the point is, somewhere we need to historicize, what kind of social structures of relations can produce what kind of reason. And one way is saying that, she said bad reasoning. I can say that, one should give a ethical reasoning. But this even in the name of ethical reasoning, justification was given to slavery and also colonialism. So those times, those counter arguments that we are giving are not available, because now we are living in a different kinds of era where there is a larger democratic discourse, which was not available during that time. So my point is, one haunting sentence that I read somewhere is, reasoning is not able to explain the rationality.
Right. Yeah, I mean, Foss also talks about the relationship between reason and power, and this historically grounded structures, and like what sort of role reason has in sort of mediating these sort of powers. And I think yeah, reason has this sort of very imminent role to play in how these power structures are challenged, right? And the dignity in that sense, and this very procedural idea of dignity that sort of FOST is proposing is to give space to all sorts of people, right? I mean, the kind of justification that were given to, for instance, justify slavery and caste were exactly the sort of power structure that invisibilized people. With invisibilized individual and talked in very broad terms in terms of justification, right? And I think that like at least FOSS idea is helpful to us in this regard, is to say that everyone counts. And by everyone, we mean every individual, and we just do not mean like, you know, every group or every community. So that is, I think, what is sort of different about FOSS idea. And I don't think that any sort of justification that were given about these institutions would count as justification as far as FOSS idea is concerned, because FOSS consideration is very individualistic, very, very focused on human person. And these institutions, which in their justification invisibilize that human person, are incongruous to the idea of dignity that he's trying to highlight. Yeah.
Thank you.
Thank you very much.
Yeah, with that, we come to the end of this final session. And now I'll invite Professor Vasanti to deliver the closing statements.
Thank you all for your presentation. I know closing statements are usually just a vote of thanks, but it's genuinely been a very wonderful 2 days for all of us. And I hope the audience also takes many of these questions, which are not really settled, right? I mean, the idea was to open up the discussion on dignity, to be able to understand it in its various complexities, not to reduce it to a single idea or to a single paradigm, and definitely not reduce it to some kind of a binary of it exists and it doesn't exist. What is a particular takeaway for me also was some of the things that were said in terms of why are we looking at the norm and the practice as necessarily binaries? Why is the norm so embedded in the practice and in the procedure? And I was really fascinated by what Maya Daruwala just said when she was so insisting that it's, all of you have told us that there is a problem, but nobody has answered the question of why is it so? And she was very, intrigued by the idea that nobody has paid any attention to why is it that we're all so okay with the indignity that we see around us, and how is it possible for us to come up with solution. There's a particular thing that she was talking about, how the procedure, how do we make the procedure in a way that it speaks to the question of dignity. So, and this is not necessarily coming from a lawyer, whereas as lawyers, we are simply saying there's a binary and there's a yes and no, and there is dignity or there is no dignity. But I think coming from her, this was really fascinating, where she was saying that how do we design procedure in a manner that will speak to the question of dignity. How can dignity be respected by respecting procedure? I think that was like a really wonderful idea for all of us to take away. And as we come to a close, I hope it has been as enriching for you as it has been for us. We are taking away so many ideas for this clinic and for future action as well. We were particularly gratified that all our panelists really believed that there was a space for this discussion in a law school, and that there was an obligation on the law school to foster this kind of a discussion. This conversation would not have been possible without the participation of so many distinguished panelists, some of whom are not here, but who were here yesterday. I also want to thank Professor Murli Karnam, Professor Erin Daly, who's accepted to be our Gyan scholar and accepted to be here for a week. And she's also our professor on clinical legal education. So we really look forward to more and more interactions and possibly future activities with her. Professor Karnam for really shouldering most of the organizing of this, and of course to the wonderful IGCL team and all the volunteers. This conference would not have been possible without all of their efforts. And also a big thank you to the Vice Chancellor for supporting us for over a year now, because this conversation started sometime last year. And so how do we run this clinic? What do we do with it? And it has taken a lot of time and a lot of support for this to be possible. To all the administrative staff, the support staff, the IT team who's been here for 2 days, and everybody else and all of you, wonderful audience, for being here on a Saturday and a Sunday and making sure that this is a worthwhile conference. So thank you all once again. I hope it's been a wonderful conference for you. Thank you.
Yeah, I'm telling you.
Big picture with everyone. Now we were wondering if we could take
This entire nitty-gritty thing, you guys have silently have done.
We forgot that we graduated because of you guys.
And I remember that.
Yeah, so it justifies when it seems out that yes, that was actually justification exercise.
Guys, we'll see. I volunteer also. Please, everybody, you also please.
It's your moment.
That is the moment that somebody not for the that's not my the branding point. But just fine. That's where it is. I'm very sorry. Yeah, I asked question to everyone.